Please. Good morning and welcome colleagues, invited guests, and members of the general public who are following today's proceedings of the Standing Senate Committee on Legal and Constitutional Affairs. Today we begin a pre-study on Bill C-36, an act to amend the Criminal Code in response to the Supreme Court of Canada decision in Attorney General of Canada versus Bedford, and to make consequential amendments to other acts. Pre-studies are a unique feature of the Senate that allows committees the opportunity to study the subject matter of the bill or a bill while they're still before the House of Commons. In 2007, a group of sex workers launched a court challenge to the constitutionality of 3 provisions in the Criminal Code relating to prostitution. The Supreme Court of Canada invalidated these 3 provisions in December 2013 and gave Parliament 1 year to respond. Bill C-36 was introduced in the House of Commons in June 2014 in response to the Court's decision. Our first witness today is the Honourable Peter MacKay, Minister of Justice and Attorney General of Canada, and the Minister is accompanied by the following officials from Justice Canada. Donald Paragoff, Senior Assistant Deputy Minister of Policy Sector, Natalie Levman, the Counsel of Criminal Law Policy Section, and Carol Morency, who's not at the table at the moment, will come forward later, Director General and Senior General Counsel of Criminal Law Policy Decision. We'll begin, Minister, with your opening remarks. Please proceed.
Thank you, Mr. Chair and honourable senators. I should also note, Mr. Chair, we are joined here this morning as well by Bill Pentney, Deputy Minister, in addition to the justice officials, very capable officials you've mentioned. Senators, I thank you very much for your presence. C'est avec plaisir que je comparerai devant.
I am pleased to appear before the committee on Bill C-36, entitled the Protection of Communities and Exploited Persons Act. I very much appreciate the committee's willingness to pre-study the bill. As you know, timelines are critical. Bill C-36 responds to the Supreme Court of Canada's Bedford decision of December 2013, which will result in the decriminalization of most adult prostitution-related activities if no legislative response is in force before the expiry of the court's one-year suspension on December 20th, 2014.
For you this morning, we've heard from dozens of witnesses, frontline support workers, police chiefs, experts from the legal profession, academia, and of course, victims who have testified before the House of Commons Standing Committee on Justice and Human Rights. And I want to take a moment, if you will permit me, to thank all of those witnesses, but in particular the many victims who testified before Committee on Bill C-36 and shared their personal reflections and insights. And I want to commend them for their courage. I also want to express my sincere admiration for the compassionate dedication of the frontline workers, workers who've demonstrated every day their compassion by helping support and literally saving the lives of individuals whose lives have been marred by the actions of pimps and johns and very often criminal organizations. The work that they do is tremendously appreciated, respected, and inspirational. Some proponents of legalization and representatives of the industry will come forward and tell you in the coming days that prostitution is a choice, that sex workers start at age 18, and that only legalization can provide them security. We disagree. One of the witnesses that we heard from this summer, Natasha Fall, told the committee on July 7th about the dangers and entrapments that prostitution brings to our society. And she said, and I quote, "I entered when I was close to 15. I came from a middle-class home in the Calgary suburbs. My father was a police officer. My mother managed bridal shops. My seemingly normal life suddenly became unsafe, and I hit the streets." She later went on to state, "One by one, each of us ended up with a pimp and or on drugs. My best friend was murdered. She was shot in the head." That young woman was shot in the head by a pimp that she'd known for only 3 months and who had been posing as a bodyguard. When the Supreme Court rendered their decision in Bedford, the Canadian government had a choice to make. Either legalize prostitution and normalize the sale of human bodies, or stand up for victims and their families and the health and safety of our communities. There has been much confusion about what Bill C-36 does and what it does not do. For example, some have asked why Bill C-36 does not facilitate selling one's own sexual services, since the bill proposes criminalization of the purchase but not the sale of sexual services. To be clear from the outset, Bill C-36 makes prostitution an illegal activity. Accordingly, it does not in any way seek to condone, allow, or facilitate either the purchase or the sale of sexual services. Bill C-36 proposes asymmetrical treatment of purchasing and selling. It does so not because it authorizes or allows selling, but rather because it treats sellers as victims of sexual exploitation. Victims who need assistance in leaving prostitution and not punishment for the exploitation that they have endured. C-36, in essence, provides a legal immunity and respects the Bedford decision and the concerns raised for safety. But make no mistake, the dynamics have changed insofar as the government has accepted the Supreme Court of Canada's invitation, where Madam Justice McLaughlin, writing for the majority, stated, and I quote from the Bedford decision, Mr. Chair, colleagues, "It will be for Parliament, should it choose to do so, to devise a new approach reflecting different elements of the existing regime." With the passage of this bill, prostitution will be illegal for the first time in Canada. And let us be clear about Bill C-36's ultimate objective. and that is to reduce the demand for prostitution with a view to discouraging entry into it, deterring participation in it, and ultimately abolishing it to the greatest extent possible. The enormity of that challenge is not lost on anyone. Yet, this should not dissuade this laudable goal of eliminating this inherently degrading and dangerous activity. Reducing prostitution reduces exploitation, violence, and suffering for many lives. And therefore, Bill C-36's legislative objectives are completely different from the objectives of the current law, which, according to the Supreme Court of Canada, primarily regulate the nuisance effect of an otherwise legal activity. Bill C-36, on the other hand, as I said, would make prostitution an illegal activity, and any constitutional analysis would be based on its new legislative objectives and framework. The considerations and calculations of the Court have therefore changed, and the premise upon much of which the Supreme Court based its decision has also changed, with prostitution becoming illegal. As well, the focus, the target, if you will, is now on pimps and johns. Bill C-36 reflects a fundamental paradigm shift toward the treatment of prostitution as a form of sexual exploitation that disproportionately and negatively impacts on women and children and other marginalized and vulnerable groups. Of particular note are Aboriginal First Nation women and New Canadians. Prostitution is not a victimless crime. Rather, it victimizes not only sellers but also communities in which prostitution takes place, including and specifically children. Children who may be exposed to it and society itself by normalizing the gender inequalities inherent in prostitution. Furthermore, commercialization and institutionalization of prostitution, for example, when prostitution, takes place in strip clubs, massage parlors, and through escort agencies, exacerbate its negative impact and inherent exploitation. I know all here would agree one of the main functions of the criminal law is to protect the vulnerable. And make no mistake, prostitution targets the vulnerable, and it preys on victims. Research indicates that entry into prostitution and remaining in it are both influenced by a variety of factors, such as poverty, youth, lack of education, child sex abuse, other forms of child abuse, drug and alcohol addiction, and mental health issues, among others. Research also shows that prostitution is an extremely dangerous activity that poses a risk of violence, psychological harm, and trauma to those subjected to it, regardless of the venue or legal framework in which it takes place. A system of laws that facilitates prostitution for the benefit of individuals who freely claim to choose it, in other words, a form of legalization or decriminalization, would result in greater demand for sexual services and a corresponding increase in the exploitation of vulnerable populations, including children and teenagers, to meet that demand. Such an approach, I believe, would also normalize the commodification of vulnerable groups, and primarily women and girls. This is corrosive on Canadian society and counter to the enormous gains that have been made throughout the country to advance gender equality. The Supreme Court's argument in Bedford has forced us to make a critical decision. If we were to adopt a system that facilitates prostitution, we would further harm the vulnerable majority, both those who have been subjected to exploitation through prostitution and those who are at risk of being drawn into it. So let me be clear, the government's priority is to protect vulnerable Canadians. Doing nothing was never an option and would have been an abdication of responsibility of the government. A responsibility to protect individuals, particularly vulnerable persons. And I repeat, it is the government's priority and fervent belief that we must protect vulnerable Canadians. And Bill C-36 reflects that priority. So let me address first and foremost the issue of demand. This bill seeks to achieve its objectives by tackling the demand for sexual services. For the first time, as I said, in criminal Canadian law, the purchase of sexual services would be criminalized. As I said, this would make prostitution illegal, as acknowledged by the Library of Parliament's legislative summary on this bill, which states that criminalizing the purchase of sexual service, quote, constitutes a de facto prohibition of prostitution. To complement the purchasing offense, this bill proposes to criminalize advertising, the sale of sexual services. So also for the first time in Canadian criminal law, the sale of sexual services is banned. is fueled by demand for the services and the advertising that contributes to that demand. To clarify the scope of this offense, because there has been some confusion in this regard, a person who advertises the sexual services of other persons would commit the offense, and the person who knowingly assists other persons in advertising sexual services for the sale would be a party to the offense. However, a person who advertises their own sexual services could not be prosecuted for this offense because Bill C-36 treats the person as a victim of sexual exploitation. So the new law will target those who purchase the bodies and the lives of other human beings. This approach is consistent with the bill's objective of reducing the demand for prostitution while treating those subjected to it as victims who need assistance, not punishment. Bill C-36 also maintains but modernizes offenses that criminalize those who seek to capitalize on the demand created by purchasers. Proposed new offenses would prohibit materially benefiting from the prostitution of another individual and procuring another person to provide sexual services. The material benefit offense would replace the former living on the avails offense found unconstitutional by the Supreme Court in Bedford. It also takes into account both the Supreme Court of Canada's concern that living off the avails of the offense prevents the hiring of bodyguards and other persons that could enhance safety, as well as the very real concern that those same bodyguards would become exploitative to maximize their profits. Accordingly, legislated exceptions would apply to non-exploitative relationships, enabling sellers to enact with others on the same basis as anyone else, and I'll go into that in some more detail. For example, the material benefit offense would not apply to those who offer goods or services through legitimate businesses or, informally, for example, an acquaintance who provides protective services. Other examples include financial accounting, delivery or driving services, those that are readily available to the public. However, if a person who fits within that legislated exception becomes exploitative, such as by using violence or financially benefiting from another's prostitution in the commercial context, such as in a strip club or a massage parlor, that person would be subject to a charge under the material benefit offense. So the relationship, as we know, can obviously change or morph into an exploitative one. A parasitic or exploitative relationship does become criminal. Monsieur le Président, le projet de loi
Mr. Chairman, Bill C-36 would also modernize existing procuring offenses, whereas the proposed material benefit offense does not require proof of active involvement in the prostitution of others. The proposed procuring offense requires active involvement, such as causing or inciting others to engage in prostitution. This is consistent with the existing criminal code approach and justifies the higher penalties imposed for procuring.
I've already noted that Bill C-36 proposes to criminalize the purchase but not the sale of sexual services. This bill would also expressly immunize sellers from prosecution for any part that they might play in the proposed purchasing, material benefit, procuring, or advertising offenses. In particular, Bill C-36 would not prevent sellers from implementing certain safety measures noted in the Bedford case, such as selling one's own sexual services from a fixed indoor location and hiring legitimate bodyguards, in addition to the personal advertising that I previously mentioned. I've also already stressed that this is not because Bill C-36 in any way condones, enables, or allows the sale of sexual services. Rather, this bill treats those subjected to prostitution as victims and weighs in the balance the need to protect the vulnerable as most important. The reality is that while we as a society work towards Bill C-36's objective of deterring and ultimately abolishing prostitution, just as we do with all other criminal offenses, Some, sadly, continue to remain subjected to it. This bill would, however, criminalize certain conduct engaged in by sellers in limited circumstances where such conduct is deemed to harm children. As introduced, Bill C-36 proposes a summary offense that could and would have criminalized communicating for the purposes of selling sexual services in public places where children can reasonably be expected to be present. Now, this is the wisdom of the previous committee, where witnesses before the House of Commons Committee on Justice and Human Rights expressed concern about this offense as introduced. And I had previously heard a broad array of opinions in previous consultations about this specific section of the bill. And I must say that even in policing circles, there is a broad array of opinion on this subject. In response to the concerns raised at the committee, the government moved to amend the offense by narrowing its scope to apply only to specific places that are or are next to 3 locations designed to be used for children: school grounds, playgrounds, and daycare centers. The main objective of the amendment, the amended offense, I should say, remains the same: to protect children from exposure to prostitution, because such exposure would result in vulnerable children potentially being drawn into a life of exploitation. The offense also protects children from additional harms associated with prostitution, including being exposed to drug-related activities, drug instruments, such as syringes, or to used condoms or other dangerous material. By clearly establishing the parameters of criminal liability, the amended communicating offense carefully balances the different interests at play, which include the need to protect sellers from exploitation and violence, as well as the need to protect vulnerable children from the harms associated with prostitution. The Supreme Court in Bedford acknowledges the particular importance of protecting children. And in that vein, this bill includes harsher escalating penalties for those who engage in acts associated with child prostitution. Mr. Chair, the complementary funding element is something important to mention here. The government believes that the best way to address prostitution's inherent risks and harms is to reduce its incidence and to help those subjected to prostitution to exit. In that regard, the government has announced it will provide assistance through complementary funding of $20 million over 5 years. This is in addition to other federal initiatives, including the National Action Plan to Combat Human Trafficking, the National Crime Prevention Strategy, the Victims Fund, the Aboriginal Justice Strategy, and funding to address the issue of missing and murdered Aboriginal women. It's also important to note that in addition to funding provided, there is funding, I should say, provided by provinces and territories, which are primarily responsible for the delivery of many of the needed services in areas such as housing, social and medical services, education programs, occupational and vocational training, and victim and addiction services and treatment and counseling. In conclusion, Mr. Speaker, Mr. Chair, the testimony that you will hear, I suspect, will open your eyes to a very sad reality that is often not understood and certainly perhaps not known by the majority of Canadians. A world of exploitation where only money counts, and where there is terrible suffering, violence, and exploitation happening everywhere in the country. Je vous invite à prendre une considération.
I encourage you to consider the final results of the government's public consultation on prostitution-related offenses in Canada, which garnered more than which garnered more than 31,000 responses, as well as the technical paper I tabled before the Justice Committee on July 7th, 2014, and which contains references to the body of research available on prostitution and provides legal analysis of the bill's law reform proposals. I have brought a copy of this paper with me today for your reference.
We all know, and it's penetrating statement of the obvious is a complex social issue requiring a multi-pronged response. This bill proposes much-needed criminal law tools to address prostitution, which takes into account all safety concerns, including those outlined in the Bedford decision, as well as the broader safety and societal concerns posed by prostitution more generally and specifically. Specifically, those subjected to prostitution must be protected from violence and exploitation. Communities must be protected from prostitution's harmful effects, including exposure to children. And society must be protected from the normalization of a gendered and exploitative practice. But the complexity of this issue requires much more than just legislation to fill the legal void created by the Bedford decision. In recognition of this fact, the government has dedicated funding to assist buttressing current programs in ending the multifaceted harms of prostitution. And finally, Bill C-36 and its complementary funding reflect our government's commitment to work together with our provincial, territorial, and civil society partners to reduce the harms caused by prostitution, with a view to one day bringing this inherently dangerous activity to an end by paving the path to a more productive, peaceful, and prosperous life for prostitutes and their families. I thank you for the work that you're undertaking on this bill. I thank you for being here on this day, and I look forward to your questions. Merci beaucoup.
Thank you very much, Minister. I understand you'll be with us until 11 a.m.?
That's correct, but I'm willing
And
to stay
officials?
longer if necessary.
Okay, and officials will be here until noon,
That's
available
correct.
for members. All right, good. We'll begin the questions with the Deputy Chair of the committee, Senator Baker.
Thank you, Mr. Chairman, and welcome, Minister, to the committee once again. And, we realize as well, the main questions here regard the constitutionality of this new provision. And I recognize that you are a former Crown prosecutor and you have litigated charter arguments. You're used to doing up a factum concerning the charter and arguing it before the courts. And in one particular case, I recall the Supreme Court of Canada upheld the Court of Appeal of Nova Scotia, and you were the Crown prosecutor in that particular case concerning Sections 8 and 9. Now, having said that, I'd like to put three questions to you at the same time. First question is the outlawing of activities that take place in public. This was one of the major considerations of the Supreme Court of Canada in that it drove the activity into the dark alleys and endangered the people who were involved in it. So what makes this bill immune from unconstitutionality when one of the provisions of the bill does exactly the same thing? The second point, perhaps you might want to comment on, is that two recent polls in Canada, one done by your own department, shows that Canadians are divided on the issue fairly evenly of whether or not prostitution should be legalized. And my third question is this. I look at your bill, and your bill, it exempts 286.5, no person shall be prosecuted for an offense under Section 286.2, which is receiving a material benefit from prostitution, if the benefit is derived from the provision of their own sexual services, in other words, to protect the prostitute from being charged. Then the next section goes on and says the same thing about advertising. And then the third section goes on to say that no person shall be prosecuted for aiding and abetting in any of those offenses if it concerns the provision of their own sexual services. Prior to that, we go back to the next page, and there's an exemption there for those people who are working for prostitutes, that is bodyguards or receptionists, and if you go back even further than that, in the bill, it also provides protection for those who are living with a prostitute if indeed it is what is called under the legislation a legitimate living arrangement. So, when you say that de facto prostitution is being made illegal in Canada for the first time, is it, yes, de facto, but what about de jure? Is it, is in fact the act of prostitution for the first time in Canadian history being made an illegal activity? And all of our legislation dating back to 1869 does not include a provision that says that the act of prostitution is de jure illegal. Could you comment on any of those, Minister?
I will, Senator. Thank you for that, that very penetrating and important question. With respect to your first and third question, you've actually answered much of the reasoning behind the delineation between why we would prosecute or target the pimps and johns but not proceed with prosecution of prostitutes themselves. It's because of both the commentary found in the Bedford decision but also the very, I think, proper recognition that prostitutes themselves are victims. This will be disputed by some, but I think the overwhelming jurisprudence and objective examination of fact will tell you that the vast majority are not in prostitution by choice. And the very reason that the Supreme Court, in my estimation, struck the provisions, the three provisions of the criminal code, was because of weighing in the balance and using the charter analysis the dangers inherent in prostitution required a different approach. And Madam Justice McLaughlin and the Court invited Parliament to put a new framework in place that included, and does include now, making prostitution illegal for the first time. Now, your question about why legal exemption, why have we, in essence, immunized prostitutes from being prosecuted from those three constituent elements of procuring, of communicating, operating a bawdy house. It was for that very reason that we have, and this subject of aiding and abetting or being a party to an event, they are essentially immunized, but for the communicating in a public place or communicating in specified areas where children would be present, or areas designed specifically for children to be present, playgrounds, schools. And so this bill, I would argue, certainly does not, as some have alleged, drive prostitutes into the dark, into the alleys, back into places where they would, number one, be at greater risk, or, and this is an extremely salient point, or be forced to curtail certain actions and steps that would make them more, or would make them less vulnerable. So the examination of the individual, the opportunity to perhaps record information. This bill, while isn't an enabler, recognizes that there are certain steps that can be taken to reduce risk. Having said that, and I've stated earlier, it's my belief that prostitution is inherently dangerous. There is very little that can be done to completely eliminate that risk. This bill goes to great lengths after great consultation, great examination of facts and factors, and international examination of other jurisdictions to try to lessen the risk, while at the same time protecting the vulnerable, drawing that very firm line between who we consider to be the perpetrators here, the Johns and the pimps, targeting them with police and criminal sanction, and doing so in a way that we believe eventually moves all of the efforts, combining other jurisdiction, provincial, territorial efforts, many of the groups that we heard from who are doing outstanding work in this area, moving prostitutes to a better place, giving them better options, giving them access to the type of support we think will improve their lives and draw them out of prostitution to a more productive place. Now, your last question about the conflicting polling data, this isn't surprising to me, that we have differences of opinion, very strong differences of opinion on this subject as other subjects. And again, it's an understatement to say this is an issue that has been around a long time, and people have a tendency to form very fervent views. However, looking at this from a criminal justice perspective, we believe that we have it right in this bill. We believe, on balance, looking at the Supreme Court and its recommendations and advice, and hearing from an extremely large number of Canadians, some 31,000 that took part in the online consultation and other face-to-face meetings that were held, we believe that this is the direction that the country should be heading when facing this very complex issue.
Minister, thank you very much for attending here today. I would like you to tell us more about the legislative objectives of this proposed Canadian model and the evidence on which these objectives are based. I come from Saskatchewan. I've lived almost all my life in Regina, and prior to coming to the Senate, I was the Justice Minister's Chief of Staff in Saskatchewan for 4.5 years. So I had a unique vantage point into Saskatchewan's criminal justice system. And from what I saw, the average prostitute in Saskatchewan is probably a 14-year-old Aboriginal girl who has probably been beaten up earlier that day by her pimp and is likely addicted to drugs. For that young girl, the world of prostitution is not a choice. It's coercion, it's desperation, it is exploitation, it is not a choice. And this confirms what you have mentioned, that prostitution is not a choice in the vast majority of cases. It is a dangerous activity, and people who enter prostitution start at a very young age. If you could comment on that, please.
Well, thank you, Senator. And your description of the graphic life circumstances of many prostitutes in your province and others, I think, is quite accurate, and feeds into, again, the questioning from Senator Baker as to the very objectives of the bill. As I mentioned, this is a fundamental paradigm shift in approach under the criminal justice system in Canada that we are proposing through this bill, and that is treating prostitution as a form of sexual exploitation, treating prostitutes themselves as victims, as they are, in certainly the scenario that you have just described. And so the overall objectives of this bill are to reduce the demand for prostitution by targeting the consumer, the pimps, and the Johns, who are the enablers, making prostitution itself illegal, which is a move away from simply criminalizing certain aspects or parts of the practice, discouraging entry into prostitution itself. So preemptive efforts, I think, should not be undersold as critical to what we're attempting to do here. Deterring prostitution at its very origins, so the underlying causes, of which there are many important issues that remain really the type of work that is being done in other areas of mental health, of addiction services, of poverty, of housing, childcare, issues of which I know that you, in your previous career, were working closely to deter. And, ultimately diminishing prostitution to the greatest extent possible. Some were scoffing at the fact that I'd previously said that we hope to eliminate prostitution. Well, that is, in effect, what we're attempting to do. Is it something that will happen quickly? Of course not. Is it something that will require enormous effort beyond any criminal justice initiative? It will require enormous effort and investment. But these new objectives, I believe, coupled with the programming that I mentioned earlier, are the right thing to do. And I believe that This is the advice that we've been receiving. It is the example that has been pursued in other jurisdictions that has helped to address the extremely inherently dangerous practice of prostitution. And it has a very broad and sweeping impact on so many communities in Canada that it will require a particular approach in many of those communities that will be unique to those communities. So this bill, I believe, goes a long way to allow our criminal justice officials, but will bring about greater collaboration to address all of those underpinnings of prostitution.
Since Bill C-36 was introduced, there has been a lot of misinformation in media reports concerning the advertising provisions of this bill. And I would like you to clarify the advertising provisions as it relates to those individuals who sell their own sexual services.
Yes, as I previously mentioned, the selling of one's own sexual services will not be captured or will not be criminalized by this bill. It is focused on those who enable and perpetuate prostitution, so the advertisers themselves, the pimps who use advertising, and it applies to all forms of advertising. So we view in this bill advertising as one of those causes that have to be addressed, but again, for reasons that are clearly stated in the Bedford case and have been clearly outlined by witnesses, on balance, prostitutes themselves should not be subject to criminal prosecution. And so, when one considers all of the factors that we are discussing here, we believe targeting those who are enabling the advertising, those who are enabling prostitution through that medium, will be, in fact, subject to prosecution.
Thank you.
Thank you, Minister. Senator Jeffer.
Thank you very much, Chair. And Chair, may I, with your permission, ask the clerk to distribute a small chart that I have prepared for the Minister to look at. Minister, thank you very much for your presentation and for being here today. I have a number of questions, but I know time is limited, so I will try and ask them to you as fast as I can. In the House of Commons hearings on July 7th, Mr. Peregoff stated in responding to a question, and I quote him, "The overall objective of Bill C-36 is to reduce prostitution, discourage entry into prostitution, and to deter participation. It also recognizes the process of trying to deter prostitution is not an easy avenue, and in that course of that, people who engage in prostitution and selling sexual services need to be protected." Close quotations. Minister, the latter part of the statement is most pertinent in addressing what Bedford requested, not to so much to decrease prostitution, but rather to protect the women who are in the work. And you have been very persuasive in your desire to protect sexual workers. Can you specifically state how you feel in this bill that women will be protected, the sexual workers will be protected, as only, I know you've spoken very persuasively about reducing prostitution, and I don't think anybody in this room disagrees with you on that. But I disagree with you in the emphasis you've put, in the sense that my reading of Bedford is that we need to protect sexual workers. The sexual workers have rights as well. And I'm not completely confident that this bill will protect sexual workers. Can you please elaborate on that?
Thank you very much, Senator Jaffer. I am emphatic in my belief that this bill will do both. In fact, it will help reduce prostitution itself, but will create the climate in which prostitutes can take certain specific measures, steps to further protect themselves or insulate themselves from violence. So reducing the demand, targeting the perpetrators, pimps and johns, is a major thrust focus of the bill. The bill also focuses, as I said, law enforcement's resources and attentions primarily on those responsible for prostitution. mainly the individuals who exploit women, and in particular, those who are drawn to prostitution because of their vulnerability. But to answer your question more specifically, it is this bill's underlying premise that it would not prohibit individuals, as some would argue, and it certainly is the court accepted, from taking specific measures to protect themselves. So they include mainly fixed indoor locations being not precluded from areas in which sexual services are sold, including indoor locations, whether this is done independently or cooperatively. It also allows for, it's permissive in the sense that individuals can have bodyguards in their employ. They can have individuals, for example, who act as spotters, who record certain information, which acts as a deterrent. I've spoken already about the advertising, and this issue of criminalizing the receiving of financial or material benefit by individuals who are around them who are not in a exploitative relationship. So these were all factors, and among others, that the court pointed out increased vulnerability of prostitutes. We have eliminated, I believe, some of those barriers to taking steps to ensure greater safety. Having said that, I need to emphasize that there is, in my view, no possibility of eliminating all of the inherent dangers because of the very nature of prostitution. And having just answered your question about how to sort of create better, safer conditions, it's not the intent of the bill, and it's certainly not the intent of the government, to enable, encourage, or further foster individuals entering prostitution. And prostitution is now de facto illegal. But the emphasis and the focus is on the purchaser and the perpetrator, the pimps who are attempting to exploit and gain materially from prostitution itself.
I want to encourage, I gave the lead questioners a little more latitude, but the minister is leaving in hopefully not too long, but we have enough opportunity for each senator to ask a question while the minister is still here, so I'm going to encourage you all to tighten up your questions. And Minister, I know it's a challenging subject matter to deal with in a cursory way, but I encourage his questions and answers as brief as possible so we all have an opportunity. Senator McIntyre.
Thank you, Chair. Thank you, Minister, for being here today. Two quick questions. The first has to do with the Youth Criminal Justice Act. As I understand, provisions under the Act would apply in the case of an individual under the age of 18. In other words, the Act would cover any interactions that would involve someone under the age of 18, and I want you to confirm that. My other question has to do with human trafficking, the human trafficking component of this bill. And could you explain why human trafficking and prostitution are closely linked together and cannot be separated from each other?
Well, that's a very good question, Senator. Firstly, I do confirm, as you've said, that the Youth Criminal Justice Act would apply here, and found within the pages of Bill C-36, as you know, are efforts to augment the penalties associated with child prostitution in particular, because this is clearly a more aggravating circumstance when individuals fit that definition of a child. They're more vulnerable. On the human trafficking component, trafficking, like prostitution, is a terrible crime. It's exploitative at its core. Many women in particular, new Canadians, Aboriginal Canadians, are subject to trafficking for the purposes of prostitution. And so therefore they are inextricably linked. And in my view, in the criminal justice system, they cannot truly be separated in our approach, in our response, in our efforts to alleviate the harm and to extricate women from these very exploitative circumstances. So a lot of jurisdictions that we examined that have decriminalized or legalized prostitution have actually seen an increase, so an uptick in human trafficking, which proves the point that they are, in fact, closely linked and associated. And it's for that reason that we have not gone down the road of legalization or decriminalization, because we believe that it would bring about greater harm and a rise in trafficking. And jurisdictions we've looked at prove that out. Again, referring to outside jurisdictions, the European Parliament, interestingly, quite recently, just this spring, endorsed what is being described as classically the Nordic model, of which, while ours is a Canadian model, it borrows heavily from that approach. And the Council of Europe recommended that member states observe this approach. That included the decriminalizing or the focusing, I should say, on perpetrators, while focusing their rehabilitative efforts and efforts to help exit prostitution on the prostitutes themselves. So this bill, these amendments, are consistent between the human trafficking offenses and the proposed prostitution offenses found in Bill C-36. It increases the maximum penalty. It imposes mandatory minimum penalties for receiving material benefit from child trafficking. And I believe it is, again, an approach that recognizes that these two societal ills are very closely associated.
I would like to draw your attention to Section 286.5 of the bill, and I make an interpretation of it, and I would like to have your comment, if possible. According to the reading that I make of Section 286.5, a prostitute can advertise her service or his service, can hire a cab to go and pick up customer, can hire a bodyguard, can partner with other prostitutes to offer her services, and be totally within the legality of that section. Am I right in interpreting that section that way?
The answer, Senator Joyal, is that if it is not of an exploitative nature, if it is not providing material benefit
to a third person,
that it is done, it's obviously going to be examined in its circumstance. Is there intimidation? Is it done in a way that perpetuates violence, addiction? Is it of an exploitative nature? But otherwise, the answer is yes.
Yeah. So in other words, a person who is totally on her or his will to offer his or her sexual services against money, because that's essentially, a commercial transaction.
It's the remuneration, you're right.
It's a remuneration, okay? So that person, being free of her will or his will, can advertise his or her service on internet, for instance, or in any newspaper or magazine. As I said, can hire a cab, a taxi driver, to go and pick up customers who would contact that person. Can hire a bodyguard at his apartment to make sure that safety is maintained. And that person would be totally within the legality of the Section 286.5. If, as you say, and I agree with, if that person is not working for a pimp or a John to give a percentage, of the remuneration, or that person is under threat, not having his or her drug, and so on, all the other circumstances that we might understand. But I want to concentrate essentially on the act of selling her sexual services against remuneration, on her free will.
The short answer, Senator, is yes.
Yeah.
There is immunity from prosecution, but having said that, in the strict legal sense, it is a criminal act. But there is specific immunity set out in the criminal code in this section.
Yeah. If there is an immunity in that context, how can you then target the person who pays for those services being a criminal? That's where I have some problems to connect the logic of that legal activities within 286.5 and the fact that a person receiving those services would pay for those services.
Well, the short answer there is that the immunization from prosecution is because of the clear recognition that the prostitute is a victim.
Well, where
And
is it?
therein lies
Yeah,
the
but-
difference. You have individuals who are victims, you have individuals who are materially benefiting and exploiting, and it comes back to your earlier question of
No, no.
the exploitative relationship.
I-
And so the exploiter is participating in a criminal act. The prostitute, even though willing in some cases, is the victim. And so it's a power imbalance that we are trying to capture in these code sections.
Yeah, but there is a nuance between the fact that I am a pimp, I am exploiting a person, him or her, and I am in the context of a criminal exploitation. But in the context of a free operation from her own will, without the context of the exploitation by a pimp, you know, the person who pays freely for those services that are legal, that are legally advertised, that are legally offered, that are legally performed, how can that person be seen as a complicity of a victim status that the code doesn't recognize, that the provision doesn't recognize for that person who offer her service or his service freely? That's why I think there's a nuance there that the court will want to investigate.
They will investigate, without doubt, and we'll look at the individual circumstances in every case.
Yeah.
I would suggest to you, Senator, that the very question of is it of free will, when one considers the circumstances that the prostitute finds themselves, whether there are a plethora of underlying causes of addiction, of exploitation, of violence, is it truly of their free will? And is there an acceptance? I don't believe there is, by courts or experts who examine prostitution, that it isn't a power imbalance, that it isn't the commodification and the gender exploitation that is so endemic in prostitution, that is so associated with how women in particular, and young women, find themselves in these circumstances. And I think that is what, telescoping back, we have to keep in mind in what these sections attempt to accomplish. We believe that the providing of immunity for the prostitute allows the right focus, the force of the law, to be brought to bear on the perpetrators, while at the same time providing safer conditions in which women who continue to practice will eventually be able to avail themselves of exit programs and strategies. So it is a simultaneous effort that will have to occur. We're focusing, obviously, your committee is looking at this bill. But please, Senators, keep in mind that the continuation of programming and the good work that is being done, and we hope will be bolstered by further funding and resources, will allow a clear path for prostitutes to leave prostitution. And it is that simultaneous effort, I think, that will bring about results. How quickly, how effectively we're able to do that really begins in part with the passage of this legislation, but obviously a great deal of the harm that's being done will be lessened when we lessen the demand and we increase the availability of programming and optionality for prostitutes.
Thank you, Chair. Minister, I have a list of questions, and obviously I won't be able to ask them. Thank you very much for being here. I will ask one question, maybe two real quick. First of all, let me say I support the intent of the bill. I support the bill completely. I am one of those that wishes the bill would maybe go a little further than what it did, and I'll be real quick in my preamble. The immunity part of the bill, we talk about the prostitutes being victims, and Senator Batter said 14-year-old girls, and I support that 100%. We have 14-year-old boys selling drugs. They don't have immunity. Or 14-year-old girls selling drugs. They don't have immunity. They are also victims somewhere along the line, and yet they are charged. My concern with this is this, Minister, that In the long term, if we take away the customers, we close down the business. I understand that and support that. But in the short term, is the pimp going to say to the 14 or 15 or 16-year-old girl, I am losing many of my customers. You cannot be prosecuted. So you just go out there and hustle a little harder to make sure that you keep as much activity going as possible. Do we have some short-term solution for that? I agree the long-term, I support it 100%. I would like you to address that. And then very, very quickly, the $20 million, how did that $20 million, how did that number come arrived at? I read one report that the United States, I think, has $10 million for 10 times as many people doing the same thing. Where did we get the $20 million from?
Well, answering your question, your latter question first, the $20 million figure we believe is a reasonable investment to begin. It's also important to view that figure as complementary to other programs and other resources, including the Aboriginal Justice Strategy, including ongoing programming delivered and in some cases also financed by provinces and territories. So $20 million figure should not be viewed in isolation. There are other specific investments in the area, to reference Senator McIntyre's question about combating human trafficking. So that's a component element, but also overlapping funding. There is the National Crime Prevention Strategy, the Victims Fund. All of this should be seen in its totality, not simply in isolation as far as that $20 million figure. I would also respond to your question about a short-term impact. We want an immediate impact, obviously. And the mindset we hope that will quickly evolve is that the victims will feel empowered to come forward and report. If they are in this exploitative relationship, find themselves victimized by pimps, victimized by Johns, there is, and we heard this testimony, we heard from prostitutes that there is, in many cases, a reluctance to report for fear of prosecution themselves, that they will fall victim, if you will, to being charged criminally, and therefore there is a reticence to report. Removing that possibility, we hope will encourage reporting. We hope will empower those victims, those prostitutes, to come forward and cooperate with police, cooperate with social workers, those who are tasked to help them, with the clear knowledge that they are not going to wind up with a criminal record. So that is in part an answer to your question. Young people in particular, to use your example of the 14-year-old, there are now, will be elevated penalties. And that's something I know that Senator Plett, you and I can very much agree on, that those who prey on children in particular, in whatever context, should be prosecuted to the full extent of the law and should face very serious penalties and incarceration. And so that is an underlying theme in this bill as well. And children in other legislative initiatives that we've taken are very much presented as our most vulnerable and our most valuable citizens. And so more can be done in the criminal justice context in that regard. And I come back to the basic premise of this bill, which is a shift away from previous efforts, which were failing, quite frankly. And that is to focus on the demand, as you said, to focus on how we discourage entry and participation in prostitution itself, and to go after that demand, to go after the exploiters, the perpetrators, those who are really behind what we know are the numerous complex issues that drive prostitution. And so I'm confident that with this greater collaborated approach and focus, we will start to have the desired effect of reducing prostitution, reducing the other social ills and issues that are associated with prostitution itself. And, it's certainly hopeful that it will lessen human suffering which is, again, so closely associated with this. And back to Senator Jaffer's point about not criminalizing the safety measures. So taken in balance, I think that we have measured all of these calculations very carefully, taken the advice of experts, taken the input of those who find themselves in these circumstances, and really tried to broaden safety and societal concerns along with criminal justice measures, along with programming, to do a better job helping those who are out there every day doing important work to help the many, many people affected by prostitution.
Thank you.
Thank you.
Two additional senators with questions, brief questions I'm sure they'd like to pose. You have time? We'll move on to Senator Dagenet.
Merci, Monsieur le Président.
Thank you very much, Mr. Chairman, and thank you, Mr. Minister, for your presentation. I have two brief questions. Why will Bill C-36 criminalize the advertising of prostitution services? Second question, obviously, also has to do with advertising. The offense of advertising sexual services will sanction. Can you hear, Mr. Minister? If you want, I can repeat my question. No, that's fine. So second question, the offense with regard to advertising sexual services, will it sanction people who edit classified ads and the administrators of websites who will post these ads? Well, the answer to the second question is yes. But it is not the intent of this bill to focus on prostitutes. It is only to go after, to attack the participation involved in prostitution.
Component of prostitution as one of those, clearly one of those underlying enablers that fuels the demand, that invites greater exploitation, that enables pimps, quite frankly, the exploiters. So it is that highway to greater prostitution, the proliferation, expansion of prostitution. That's why we're going after the advertisers. But you're absolutely right in saying this isn't meant to go after the sole individual, the prostitute themselves, who may choose either through the internet or through other forms of advertising to say, this is what I'm doing. Again, we offer that immunity because of the recognition and acceptance that a prostitute is a victim in that regard. And all of those underlying back causes that have led the person to that point in their life. We think on balance the focus needs to remain on the enablers, the perpetrators, and that means pimps and johns. Merci bien.
Thank you very much.
Yes, thank you, Minister, and thank you for being here. One of the positive things, perhaps, of this issue becoming high profile is the media and others are starting to pay attention of the severity of this. I get up the other Saturday morning, in fact, August 30th, and it was captioned in the front page of the Chronicle Herald, and there was a full-page story of lost girl. And let me just, they chronicled this young 13-year-old girl who was from a broken home and how her troubled life lured her into easy money and prostitution, drugs, brand name clothes, and that type of thing. And she would see as many as 5 clients a day, aged 18 to 70. Many of her peers do the same thing. In fact, she estimates that she could name 50 in Halifax alone. Police estimate the same number. And goodness knows how many others there are in the larger cities. She states that one of their big fears is that they'll be taken away to Toronto by pimps. Let me just quote what she says here in just one small paragraph. I don't know how to convince people to stay away from it.
It's dirty and it's sad, and I just shouldn't have been in that situation. I missed out on my innocence. It's not like I can go back. She's, as I say, under 16. She's been involved in prostitution, drugs, dangerous life, afraid of pimps, loss of teenage years, no education, and now she's trying to get back into the educational system. I guess the question is, and you've touched on some of it, what is this going to do, and what programs do we have that will aid and abet these individuals to get back to a normal life?
Well, it will take a Herculean effort, to be sure, and I'm heartened by the fact that there are tremendous organizations in the country today, individuals who have literally devoted their lives to this effort of helping to liberate women from, predominantly women, from modern slavery. And this newspaper account that you've described underscores some of the other insidious elements of prostitution. Young people, in particular young women, isolated from their peer group and their parents, their normal support mechanisms are gone, and so they're trapped, or they're moved away from their home and their community, and again, further captured by that circumstance, and then forced into the acts of prostitution, in large part with violence, intimidation, blackmail. There is elements of cyber crime that touch on prostitution, that people are blackmailed into these acts of prostitution by fear of disclosures of certain images or things that are captured online. And so to answer your question more precisely, the focus of the bill on the perpetrators, the immunity provisions, the stricter penalties, the support of the ongoing work that is being done, and I mentioned in specific, for example, the Center to End All Sexual Exploitation, or CEASE, in Edmonton, who we heard from, Streetlight Support Services in Toronto, the prostitution education programs that exist in our province in Nova Scotia. I was in London, Ontario several times during our consultation, and the London Abused Women's Centre and Sex Trade 101, people like Megan Walker and many, many others who've devoted their lives to this. Joy Smith, our colleague in the House of Commons, and many, many others who are continuing their very real, tangible efforts to help bring people to a better place and bring them out of this exploitation. And I just want to leave you with a quote, if I might, from one of the witnesses who testified, and she went on to say, "Prostitution is not a career choice made by the vast majority of women in the sex trade. Life gives them few options. Prostitution almost always leads to these women becoming victims of violence." And it is that fear, that underlying violence, that we need to continue to focus on. That's what this bill does in its underpinnings. That's what the programming, funding, and further support networks will do. But make no mistake about it, it is going to take time and extreme effort to help prevent and preempt and pull people away from prostitution.
Minister, thank you for coming early and staying overtime and giving those senators who wish to pose a question directly to you the opportunity to do so. Very much appreciated. Senators, we're going to suspend. You had some final comment?
If I might, Mr. Chair, only to once again thank you for being here and preempting. I know this is done in a preliminary way, and your work will continue. But if I might, by your leave, table this technical document, which provides further background information. We tabled this with the House of Commons Committee. I would like your committee to also have the benefit of this material.
Okay, thank you very much. Appreciate it again. We're going to suspend briefly while the minister departs and reconvene with justice officials.
I was just going to say that.
Just as a reminder to members, we now have appearing before us Donald K. Piragoff, who is the Senior Assistant Deputy Minister of Policy Sector, and Natalie Levman, Counsel of the Criminal Law Policy Section, and Carol Morency, the Director General, Senior General Counsel of the Criminal Law Policy Section. We'll welcome you all as well. I appreciate your appearance here today, and we'll begin the questions with the Deputy Chair of the Committee, Senator Baker.
Thank you, Mr. Chairman, and welcome to the witnesses, and congratulations on the excellent job the three of you are doing in the department. My question relates to the form of this bill. Given the fact that the Supreme Court of Canada noted in its decision that, times have changed, we move on, there are different matters that affect legislation. It's an ever-changing world when it comes to legislation. It's a fluid process. And when I picked up your bill, the bill of the department, and I don't know if you can answer this question for me, I was struck by the repeated reference in the bill to comic books, to crime comics. Now, if I go to, it says in 164(1), is obscene or a crime comic as defined by Section 163. Now, 163 defines a crime comic as being any publication, fictitious or otherwise, that shows violence. I'm paraphrasing what's there. I turn the page and there's 3 references to crime comics. Again, on the next page, on page 4 of the bill. I know that the only litigation that is recorded on crime comics involves the Dick Tracy crime comics, Court of Appeal of Manitoba. And that's been used in the courts. It's a very confined area of the law that does not deal with prostitution, does not deal with anything that is considered to be obscene, but simply deals with comic books. And yet we have it entrenched in this bill. I know you're not changing the law, but you're repeating it again. And I'm wondering, do you have a process in the Department of Justice to correct these things that belong back in the 1940s? In today's world, violence in comic books is a comical subject, given our world today. So that's my question. To me it was an affront when I looked at it. And the continual repetition of a crime comic in this legislation. Do you have any answer to the question I'm proposing?
This bill deals with advertisements for sexual services, and the point of these provisions is to add advertisements for sexual services into the provisions that authorize takedowns, etc. It wasn't to substantively change the provisions, and so what you see is the phrase advertisement for sexual services inserted into the existing provision. It wasn't intended to address crime comics at all. It's just what was there.
You had an opportunity, though, the drafters of the legislation, to remove something from the law that is considered to be, in this day and age, rather comical. Why is there any provision that you have to correct these things that are a part of the criminal code that shouldn't be repeated as it is in this legislation?
Senator, the Cabinet gave authority to amend the criminal code to deal with prostitution and prostitution issues. Cabinet did not give the officials the authority to change the law with respect to comic books. That's the process. We cannot just simply, as we open up a section, say, "Oh, I as an official think that this is ancient and should be taken out." That is something for governments to give us directions and for Parliament. Maybe this is an example would be of a good private member's bill or senator's private business bill.
Thank you very much, witnesses.
Some Canadians have expressed confusion over the fact that Bill C-36 criminalizes the purchase of sex for the first time in Canada, yet the bill in most cases immunizes from prosecution the seller of sex, the prostitute. I'm wondering if you could please explain the reason for this basically asymmetrical criminal law in this case, and give us some other examples of asymmetrical criminal law in Canada to help people understand.
Maybe I'll start with the best example that I know, which is existing subsection 212.4 of the Criminal Code, which criminalizes obtaining sexual services for consideration from minors. So really, new Section 286.1 is modeled on existing 212.4. It's exactly the same approach whereby you criminalize the person who purchases as the person who creates the demand for the exploitative practice, but not the person who sells, because that person is considered to be a victim of that transaction. And that is the logic behind criminalizing purchasing, but not the sale.
Thank you. And from a technical point of view, can you please tell us how Bill C-36 addresses the concerns about the safety of prostitutes that were raised by the Supreme Court of Canada in the Bedford decision?
Well, I think that it addresses the safety concerns in a number of different ways, and not just the safety concerns that were raised in the Supreme Court of Canada's decision, but the broader social and safety concerns, as the Minister mentioned this morning. So first of all, because prostitution is viewed as inherently exploitative, obviously reducing the incidence of prostitution will create greater safety because fewer people will be subjected to it. Secondly, those who remain in it are not prevented from implementing certain safety measures that were outlined by the Supreme Court of Canada in the Bedford case. So the Minister went over what some of those are. For example, selling sexual services in a fixed indoor location, hiring protective services, and also negotiating safer conditions for the sale of sex in places other than where those specific locations that are designed for the use of children. Also, I would say that Bill C-36 targets the exploiters, and that also enhances safety. So not just the pimps, the procurers, as existing criminal law does, but also the person who purchases, the person who creates the demand in the first place.
Thank you.
Thank you. Senator Jaffer.
Thank you, Chair. I will ask my questions at one time, and if you can answer. For me, when I read the Bedford decision a number of times, the mantra for me from that decision was the violence of a John does not diminish the role of the state in making a prostitute more vulnerable to that violence. I think that's, the state also has a responsibility to protect sexual workers. With that in mind, can you please tell me why you didn't think that health and safety of workers be mentioned in the bill's preamble? And also, the minister mentioned a number of times the issue of indictable offenses, about young people. And so I was wondering why you didn't, in other sections you have added it, and in other parts of the code also it exists, but if you didn't make it an indictable offense rather than a summary for a John that picked up a child under 18. And my third question is that I understand that you did you asked for a peer-reviewed report from the BC Centre of Excellence in HIV/AIDS, and the Pivot Legal Society produced an impact of criminalization of clients. Could you tell us the results of that study? And I also understand as part of that study, they looked at Sweden and Norway. Could you tell us what the report concluded as to what's happening with almost the Canada model that exists in Sweden and Norway, does it protect the sexual workers?
Okay.
Go ahead.
There were several questions embedded in there, so let me start from the last one. The approach, Sweden's approach was evaluated by its government in 2010, and it has, the results were that it did succeed in reducing the incidence of prostitution. There has been another study in Norway that was just recently released. Unfortunately, most of it's in Norwegian, but there is a little bit in English. And my understanding is the Norwegian government's come to similar results. This type of research is all referenced in that technical paper that the minister tabled today for your review. So if you look at the international context.
I think that you misunderstood. I'm not talking about you yourselves asked Pivot to do a report on this, and I'm asking you what the results were.
No, we didn't ask Pivot to do. I know that Pivot did a study.
And what did they say about the criminalization of clients?
Well, they did a study. My understanding of their study is that it looked at the impact of a policy that was implemented by the Vancouver Police Department, whereby they would only target Johns under Section 213. And it was a qualitative study, and the people who responded, who were sex workers, about 30 of them, as I understand, said that they felt they didn't feel any more safe as a result of that, the implementation of that policy. That's my understanding, and that's one study of many. And so I would again direct you to the portion of the technical paper that goes over all of the various studies and uses larger samples as well on that point. Now, you mentioned something about the purchasing sexual services for minors being indictable. It is a strictly indictable offense. So 286.1 sub 1 is the purchasing offense for where sexual services are purchased from adults, and 286.1 sub 2 is the purchasing offense where sexual services are purchased from minors under 18s, and that is a strictly indictable offense, and it raises the penalties. It's the same offense as in 212.4, but moved to Part 8 of the Code to be with the other prostitution offenses, and it would raise the maximum penalty to 10 years, strictly indictable, and has a mandatory minimum penalty of 6 months for first offense and 1 year for subsequent offenses. Did I cover?
I'll answer the first question. Thank you. I'll answer the first question, Senator. With respect to the question that the quote you made from the Bedford decision about the state's obligation not to make the situation more dangerous for sex workers on the street. This bill actually goes out of its way to ensure that it doesn't put more hindrances or facilitates the increase of dangers. It actually does a number of things, as the minister indicated. The question was asked, I think it was Senator Baker asked the question, under the existing law, there were studies in the past that the result was people were going to the back alleys because under the existing law, both the seller of sex and the purchaser of sex were guilty if they tried to communicate to a transaction. So they wouldn't do it out in the open, so they'd go into the back. And the question was, well, that forced people into the back alleys is not safe. Well, they had to go in the back alleys, not safe, because they couldn't do it at home. She couldn't work out of her apartment, because if she worked out of her apartment twice, it became her body house. This law now says, no, you don't have to work on the street. You can work out of the safety of your apartment. You can hire a bodyguard. You can work with a friend out of the safety of an apartment, two of you together. As long as you don't exploit one another, you can work together and be safe. So you don't have to go on the street. But if you do go out on the street, now, you can still have a bodyguard, as long as it's a legitimate, non-exploitative bodyguard working with you to protect you on the street. You can have a spotter, a fellow prostitute, or somebody else taking down license number plates. So the bill has removed a lot of the elements of the existing law, which the Supreme Court of Canada said tended to push prostitutes into areas of dangerousness. So you can work inside, but if you want to work on the street, you can have bodyguards, you can have spotters. You also have the ability now, as this is the sex worker, unlike the current law, you have the ability to screen your client, because it's no longer a crime for you to communicate for the purpose of sale. So you have the time to take the time. Now, the client may not have the time, but you, as a sex worker, has the time to screen the client as much as you want to. So you don't have to jump in the car quickly because you're afraid you're going to be arrested, because you won't be arrested. So,
Giving you
Thank you.
additional time.
Thank you.
Senator McIntyre.
Well, thank you to the three of you for being here. I simply wish to pick up where Senator Baker left off when he addressed the issue of form. The Bill C-36 comprises a preamble and 49 clauses. Some clauses made consequential amendments to other acts by replicating code offenses in the National Defense Act, technical amendments, linguistic amendments, reformulations, the purpose of which is to clarify the intent of the legislator. I also note that several sections of the legislation are amended to include offenses created by the bill in existing list of offenses with respect to the Dangerous Offender Registry and DNA sampling. My question is this. As draftsman of this bill, are you satisfied with it? I'm not asking you if you agree or not agree with the bill, but are you satisfied with the overall drafting of the bill? And the reason I ask you this is because certain terms are not defined in the bill, such as the definition of sexual services, public place, and so on. Could I have your
Thank you for that
comment on that?
question.
Pardon?
Thank you for that question. Yes, I'm satisfied that the terminology, the phrases used in the bill have meaning in Canadian law. And I would direct you again to the technical paper, which actually goes over the jurisprudence interpreting some of those phrases. For example, the phrase sexual services is in existing 212.4, and there's quite a body of law interpreting what that means. It narrows it to the context of prostitution, but also gives a certain amount of flexibility for courts to adjust to new ways of affecting it. And so I feel that it does give a very clear standard for courts to apply. Again, public place, open to public view, these types of phrases already exist in the code. There is case law interpreting them. To define them would be potentially to alter that case law, which hasn't been in dispute, isn't difficult for courts to apply. So, you know, drafting is always like that. When you use newer phrases, you might want to define it if there's no jurisprudential context for it. But where there is jurisprudential context, it's a decision to leave that jurisprudence in place and allow it to continue to apply to assist judges in interpreting those phrases.
Thank you.
Senator Joel.
On the answer you were giving to earlier on to Senator Jaffer in relation to Section 286.5, on the basis of illegal activity, quote unquote, performed by a prostitute in the context that you have just described, what kind of legal link can you make between the fact that a person is performing illegal activities, but the person who is part of that activity becomes criminally responsible?
If you look at the language used in the section that you referred to, Senator Royal, it says no person shall be prosecuted. It doesn't say no person commits an offense or no person is criminally liable. It says no person shall be prosecuted in the following circumstances. So it's an immunity from prosecution. That doesn't mean that the person is not involved in illegal activity. It's just like the situation of a trafficker of drugs. The trafficker of drugs sells drugs. That's a crime. The purchaser does not commit a crime. There's no offense of purchase of drugs, but that still is a criminal activity. The purchaser, however, could, by aiding or abetting or conspiracy, if you buy a lot of drugs, could be liable as a conspirator. That's why the provision also says no person shall be prosecuted if they aid or abet or conspiracy someone else, such as one of the other people who might be involved. So there's a distinction between saying no liability. It's the same thing with respect to situations. There are many other examples of asymmetrical. No child under 12 can commit an offense. Yet if a person counsels an 11-year-old or 10-year-old to commit an offense, that person can be convicted of counseling, but the child can't be. So we have lots of examples of asymmetrical situations where one person is immune while the other person is guilty.
Yeah, but indirectly, you deprive the person of her living, of a legal living, by criminalizing the purchasing of the services in that context. So, in my opinion, there's a total different context into which a pimp is recruiting customers on the basis of getting sexual favors, because then you could reason on the basis that there is a complicity link between the one who is the intermediary and the person who accepts that context. But for a prostitute that exercises her capacity of providing sexual services to a person who is willing to accept it and is in legal status to buy them, I don't see how in court you will be able to sustain the legality of the criminal responsibility of the person who purchased the services in those circumstances.
I think the minister answered the question already. The purchaser is being criminalized for the exploitative conduct of purchasing. That purchasing sex is exploitative conduct for all the various reasons that the minister gave. And that therefore that person is guilty for their own conduct. They're not guilty for the conduct of the person selling them sex. They're guilty for the fact that they are buying sex, that they are keeping a person in a type of activity which the government feels is harmful. And therefore the government's view is that this is victim. It comes down to a policy decision in the end. So it's not a question, purely a question of logic of the law. It's also a question of policy. Do you want to increase prostitution in Canada, or do you want to deter and reduce prostitution? And so once you make that decision, then you have certain options, legal options, as to how to affect that policy, Senator.
Yeah, but you are, again, coming back to the decision in Bedford on Section 7. My opinion in this context, very specific context of 286.4 that you have rightly described, in my opinion, in previous answer, there is no legal basis to get to criminality to someone who purchased a service that is legally offered within the context of Section 286.5. If I would be charged, I would challenge it on the basis of the constitutionality, because the person who offers a legal service that is totally recognized being legal in specific circumstances cannot be found criminally responsible to have purchased those services who are legally offered.
It's not a legal service that has been offered. It is a service which the law, the bill says we will not prosecute you for.
Yeah,
there's a difference.
Yeah, but still, in my opinion, as I say, the person who willingly, on her own will, offer her service in the context you have just described, within the confine of a private apartment, who advertise it within the confine of a direct offer, who send her driver to pick up the customer, who has a bodyguard in front, all those people who are part of the activities are, as you say, immune of prosecution, but they are part of the activities, and they are totally conscious of the activity, aware of the activities. The landlord is aware of the activities. Everyone is aware of the activities. But the person who will pay rightly for the service offer, that person would be charged criminally. I really don't see the link of legality, of criminality, between something that is offered totally within the confines of the bill presently.
I believe that in law, a criminal act is still being committed because they are a party to one of the prostitution offenses. The fact that 286.5 immunizes them from prosecution is solely as a result of the Bill C-36's position that they are victims that need assistance. But Bill C-36 isn't saying that their role is legal. It's not facilitating it.
Forever, I think. Senator McInnes, and we'll hopefully have an opportunity for a second round.
Yeah, thank you very much. I don't know how much you know about polls, but I want you to comment, if you would, on the consultative process that Justice went through. It was mentioned, I think, by Senator Baker earlier that there was a poll out saying 50-50. I think it might have been Ipso Reid, I'm not sure. But that's a poll that's taken randomly. You know, they select 4% or whatever across the country. From what I understand, you had a paper, you had a series of questions that you put up online. You had a web page, you used Twitter, you did all of these things, and you posed the questions. And I think there were 31,000 individuals that responded. And there were the questions. I guess the point is that I think do you think that purchasing sexual service from an adult should be a criminal offense? 56% should be a criminal offense, 44% not. Do you think selling sexual services by an adult should be a criminal offense? 66%, or 17,801, felt it should not be, as opposed to 34%. And it goes on with another question, whether it should be a criminal offense to benefit economically from prostitution of an adult. 62% to 38% felt it should be a criminal offense to benefit economically from prostitution. I guess my question is, you obviously did that, and I think it was a worthy thing to do, but I'd like for your comment, because often governments try to bring about legislation that hits the majority of Canadians. And if they don't, it's to their peril. Sometimes you have to bring legislation that the majority is not there, but mostly you do. Do you want to comment on that effort that you went about doing here? I just presumed you were experts in polls when I saw it.
Well, it was a month-long consultation process whereby people got to send in their responses, and it was one of many different factors that informed the development of the bill. It wasn't just the public consultation. Obviously, the Bedford decision was extremely important, jurisprudence, research, etc. But the government wanted to hear from Canadians as to what they thought the law should be. And the results, although 56% isn't a huge majority, but I would say the results do support the approach taken in Bill C-36.
If I just might add to that, there are differences between the public opinion poll and the consultation. The public opinion poll is essentially, it's on the moment, it's on the telephone call, there's no background information, it's basically an uninformed opinion. What do you think? It's whatever comes to the top of your mind, yes, no, I support it, I don't support it. That's a public opinion poll. A consultation, as you indicated, is different. It's more informed. There was a document, 2-page, 3-page document, which actually talked about various options that exist throughout the world in terms of decriminalization has been one option, the Nordic model is another option, or straight prohibition is another option. So there was a stimulus. So number one, the person who responds has a lot more information. The disadvantage, of course, is that people who will respond to the consultation online will probably have an interest to actually pick up the computer and answer. So there's a certain bias in that you have people who are actually interested in answering the question as opposed to the public opinion poll, which is a more uninformed stimulus question, but of course you have a broad base of the population without maybe people even being interested in the topic, and they have to answer it. So, but both of them are the two different techniques. If you look at the numbers, they're generally very close together.
Yeah.
There's some areas where there's a difference, but basically they're very close together. So both types of polling techniques, one by consultation, one by public opinion polls, tended to come up with very close the answer. Now, are they statistically close? I don't know. I'm not a statistician to say that, but if you just look at the numbers, they're generally close.
Yeah, just a supplemental on that. I didn't read the poll or the questions. Was one of the questions posed how many people agreed or disagreed with the Bedford decision?
No. There was some information, as Mr. Paragoff said. There was some background information included in the paper before you reached the questions, and there was information on the Bedford decision there, as well as different policy approaches to prostitution. But the focus was on forward-looking on what the law, what respondents felt the law should be, not seeking opinions on court cases.
Thank you.
We have a few minutes left and an opportunity for a quick second round. Senator Baker, do you wish to begin?
Yes, Mr. Chairman, I'll leave the repeated reference to comic books in this bill, and I'll move on to, and why it's there is just beyond me, why it couldn't have been taken out. Let me ask you, Mr. Paragraph, your example of the drug trafficker, I don't think is a good one, because you said it's not illegal for somebody to receive the drug. Of course it is. They can be charged with possession under a different section under the criminal code. I think the point that Senator Joyal is making is that it is difficult to conceive of a situation where one can be charged with being party to a legal offense, to a legal act. In other words, the act of prostitution, as you have described it and the minister described it, as far as the prostitute is concerned, is a legal act and is not an illegal act. You say that the person will not be prosecuted, they're exempt from prosecution. The decision to prosecute is made in the first instance by the police, in the second instance by the Crown. That's our system in Canada. So could we see a situation here with the passage of this bill where a search warrant were issued, or warrants with listening devices on them into a prostitute's apartment to investigate an offense, in that you're saying the departmental opinion is this is an illegal activity for which one person will not be prosecuted? And the second part of my question is this. It's a bizarre way. The ordinary person, Canadians look at this and they say, this is very bizarre. You make prostitution de facto illegal. You make it, but it's legal for the prostitute. The act of prostitution for her or him is still legal. It's rather bizarre. It's an indirect way, the de facto illegality of it. You do everything on the outskirts of it. Is there anywhere in Canadian history that explains why Canada has chosen, since 1869 in the criminal code, to not to criminalize the act of prostitution? Why we've gone down the various roads we have in the criminal code in indirectly making it illegal, but in actual legal terms, it's a legal act.
That's where we beg to differ, Senator. It is an illegal act. But for the provision which grants immunity, a seller of sexual, even if the law only directly penalized the purchase of sex, the seller could be a party to that purchase. But for the fact that C-36 explicitly says you cannot be prosecuted for that. Without that immunity provision, a seller of sex could be a party to a purchaser. Just as a seller of drugs, the purchaser of drugs can be a party to the selling. And that's how purchasers get caught up, because they get caught up in conspiracy. They're buying a large quantity. In addition to the fact that they may be possessors, they can also be charged with the actual trafficking if they get tied up as neighbors. The same with this. It's that provision. And there's a difference between saying Parliament saying no one commits an offense if, as opposed to no one shall be prosecuted if. No one shall be prosecuted if, which is the language, presupposes that there may be a crime there. But we're not going to prosecute these people because they are victims. They do not need to be prosecuted. The policy decision is that they should be treated as victims. They need to find ways to get exited out of the system. They need to find ways to get into programs to help them exit. And you're not going to treat that by prosecuting them.
So the warrant.
If you want.
Sorry. About 3 or 4 minutes to Senator Joyal. Quick question.
Could you give additional explanation on Section 286.24, which is another exception to the bill? It's the one that applies to persons who receive the benefit in the context of a legitimate living arrangement or the result of a legal or moral obligation of the person for whose sexual services the benefit is derived in consideration for a service or good they offer, and so on. Why this exception? Could you explain the objective of this exception in the context of the discussion we just had?
What you're describing is the provision that outlines the legislated exceptions to the material benefit offense. Those exceptions, those 4 exceptions, are based on, the first 3 are based on case law interpreting the existing living on the avails offense. So the Grillo case found that people who are in legitimate living arrangements with others who sell sexual services are not covered by the living on the avails offense unless they are exploitative. That's Grillo, Ontario Court of Appeal. It's also referenced in the technical paper, which explains all of these legislated exceptions. The legal and moral obligation legislated exception is also from the Grillo case. So supporting someone, a dependent person who doesn't live with you, for example, giving a gift, etc. Again, carving out an area in which sellers of sexual services can interact with others just like you or I without foisting criminal liability upon those with whom they are interacting. The third exception comes from a line of cases starting with a House of Lords case, 1962, the Shaw case, that finds that, for example, if you're an accountant and one of your clients sells sexual services, you're still allowed to get paid for your services as long as they're offered on the same terms and conditions as they would be offered to anyone else. The fourth exception responds to the Bedford case directly. So it carves out an area in which people who sell sexual services, should they fear for their safety, etc., can hire a friend, an acquaintance, somebody who offers these types of services more informally, like not Pinkerton or Brinks, because they would be covered by C. And provided that they're giving, they are paying a proportionate amount for the service that they receive, and that person is not involving themselves in the selling of sexual services in any way, not encouraging or inciting them to do it, then there would be an exception there for protective type services or other services, the same way as if I were feared for my safety and I wanted to hire someone to come and protect me.
Senator Jaffer, respecting the clock, a very quick question.
I just wanted you to answer why health and safety of sex workers was not mentioned in the bill's preamble.
Well, I think the preamble talks about protection of the inherent exploitation in prostitution and the importance of protecting human dignity and equality, recognizing the social harm caused by the objectification and the commodification. I think that concepts like health and safety are incorporated in these types of concepts.
witnesses for your time and your testimony. Very much appreciated. Members, we're going to suspend until 1 p.m. and reconvene with our next panel of witnesses. For our next group of witnesses, committee, please welcome from the Canadian Association of Elizabeth Fry Societies, Kim Pate, the Executive Director of that organization. From the Native Women's Association of Canada, Michelle Odette, who is President. Teresa Edwards, Director of International Affairs and Human Rights. And from Walk With Me Canada, Robert Hooper, the Chairperson, Board of Directors, and Tamia Nagy, a founder and frontline victim care worker. Now, I'm not sure. Okay, Michelle, apparently you're going to begin, but we're going to have 5 minutes from each organization. Is that the intent, or are you all planning to speak 5 minutes as individuals? I'm not sure how you're going to approach this. Five minutes by organization? We're fine with that? I'm not seeing any reaction here.
I can tell you from our perspective that we thought it was 5 minutes each, but we can be 5 minutes in total if that's appropriate.
That is the general rule of thumb. I can show a little flexibility on that, but we want to give senators as many opportunities as possible to direct questions to you and have you have the opportunity to respond. So we'll begin with Michelle Odette.
Nation from here, la nation Anishinaabe. Et merci.
Thank you, dear members present here today, and thank you to our colleagues who will debate. I certainly hope this issue in an open spirit, open mind, I hope, on a subject which is on the minds of Native women. I am Michelle Odette, and I have worked for a long time with the Aboriginal women of Canada. It's my passion. I have 5 kids, and I'm extremely concerned with their present and their future. I worry about the lives of my sons and daughters. Thank you for this invitation. We will reiterate our concerns with regard to this hot topic, and I certainly hope that we will find solutions and that Native women will not be forgotten in this bill. Young women, young Aboriginal women across Canada deserve justice, protection, security, dignity, and more. Native Women of Canada has worked and continues to work. It has been working since 1974 with the provinces and territories in which we have sister organizations, and they also have networks directly connected, or rather plugged into their communities. I am a Native woman, and I live my daily life in my community. We hear, we see, we feel, we touch, we taste this violence every day. And unfortunately, all of our senses are exposed to these unacceptable conditions. You know very well that extreme poverty exists in Native communities, and it is women especially who are affected by this. Our children and their situation is a reality. We're all aware of premiers a few weeks ago in Prince Edward Island made this issue a priority. Why do I talk about the situation and the placement of our children? Well, I'm sure that you've heard of the unfortunate story of 15-year-old Tina Fontaine, who unfortunately had been placed into a foster family, and she was found dead in a garbage bag close to the river. These things have to end in Canada. We also know that in that same area where every week it seems that a young woman has disappeared or has died, we're talking about young Aboriginal women. You may have seen on the CBC that former members of street gangs have said that young Native women who either ran away from home or were put in a foster home were an easy target for human trafficking, prostitution, and the sex industry. So this makes us Aboriginal women and young girls, it makes us a very vulnerable population. We have mobilized, we have done research, we have held meetings with women who unfortunately are still caught up in this environment or who have been able to escape it. And the vast majority of them, if not all of them, have told us that it was not a free choice on their part. It was not a decision based on consent, but rather it was a situation where they had no voice of their own. They were forced into these situations. They were threatened with death if they tried to escape. Human trafficking can start from the ages of 7, 8, 9, up to 12 years old in our Native communities. And these communities are part of Canada, and we are all responsible for them. Most of these young girls, the ones we've met who are now women and even grandmothers, have told us that they were extremely touched or affected by violence within their communities, but also within Canada as a whole, the Canadian community, women who were trafficked in the sex industry, who were involved in prostitution, were also victims either by their pimps or their johns. And these women, of course, were all affected by this industry. So in the few minutes remaining, let me reiterate that we did not have the choice to enter this industry, and we put the question to these women again. If you had a choice for the same amount of money, would you do it again? And the answer was categorical no. So it is important to remember that in the decisions we are going to take, you have the power, you have the legislative power to protect Native women, to impose a tolerance zero with regard to sexual violence, tolerance zero with regard to the sexual exploitation of young Native women and girls. And you have the power to make sure that when criminalization is brought about, well, let us not criminalize Native women. Most Native women who end up in jail was for the unfortunate reason of extreme poverty. These women wanted to feed their families, so perhaps prostitution was a choice that was imposed on them through which they were able to feed their families. But together, let us find solutions so that women can escape poverty by providing us, amongst other things, with decent housing. If we're talking about money, let us ensure that any money invested is culturally adapted to the needs of Aboriginal women. Thank you so much for giving us a few moments of your time.
And Ms. Pate, I believe you're next.
Thank you.
Please proceed.
Thank you, Mr. Chair and committee members. I want to start by acknowledging the traditional territory in which we have the privilege of meeting, Algonquin territory. And I think it's vitally important, particularly as we're talking about this issue, as with many other issues we discuss at this table, to recognize the ongoing impact of colonization on our Indigenous peoples. It's certainly brought home to me every day of the last 30 years that I've had the privilege and opportunity and, most importantly, responsibility of walking in and being able to walk out of prisons for women and for young people and children and even for men. Our work with marginalized, victimized, criminalized, and institutionalized young people, particularly with young girls and women, has meant that although this was not an issue that we ever chose to work on, it is an issue that touches us every day of the 30 years that I've been doing this work. I never intended to focus on prostitution. I never intended to be arguing in this area, and yet every individual who I have met, particularly since working with women in the prison system, has been touched directly and or indirectly by this issue. And prostitution, I would suggest to you, needs to be looked at as it is. It raises fundamental issues of equality and violence against women. I want to say a bit of a word about some of what's been in the media and in particularly social media about this. The discussions and media reports on this issue have been incredibly divisive, dismissive, disrespectful, and harmful, particularly to those women with lived experience in the prostitution industry who do not support complete decriminalization. And I think that is regrettable, reprehensible, and quite unconscionable. The fact that we have conversations and debate that cannot be respectful and have been reduced to abuse, I think, is something that just underscores some of the difficulty in addressing this very issue. I encourage all people who are working on this issue to recognize the common ground we have and to pursue that common ground. And I also want to say the comments that we're not having adequate discussion, has been more discussion on this bill in my experience than any other crime bill, save perhaps the gun registry, ever put before, or not ever, but certainly within the last decade. And so the fact that we're being told there has been no discussion is mischievous at best. So I want to talk about who we are talking about. When we're talking about prostitution, for the most part, we are talking about the most disadvantaged and marginalized women of all. They are not women who come from a class who think they are making specific choices, but women who are forced into the prostitution industry because they have no other choice. To survive in this industry, they are also having to survive increasingly inhospitable environments, both within prostitution and within the community if they're not engaged in prostitution. Presumably, we all agree, I hope that this is a starting point, that we want to stop violence against women, and that it's fundamental to our belief that our starting point will be to ensure that violence against women needs to be eradicated, and that we should all support equality for all women and girls and support all measures that seek to make women and girls equal. I would suggest to you, if the case that has generated this bill had been brought by 3 men rather than 3 women, if they had brought the issue of prostitution to court, I respectfully submit that we would not be having these discussions right now. Women's groups and equality advocates would not be so divided if 3 men had sought to assert their rights to engage in free market capitalism of buying and selling the rights of access to the bodies of women and their sexual services. As you know, throughout the country, where we are, as our organization, our sister organizations, others, including ones who will present from a different perspective on this bill, are engaged in working on early intervention programs with young people, programs in the community, working with individuals in mental health settings, working with homeless, addicted individuals, and those with significant mental health issues. We see the move to decriminalize women as fundamental to women's equality. We also see it as fundamental to women's equality that violence against women, which we see this legislation as part of the move to eliminate violence against women, challenges the violation and commodification of women and girls as a means of helping to achieve that equality. This is not a case about sexual morality or sexual orientation. And those who suggest it is a continuation of those discussions, I suggest to you again, are trying to lead us down a different path. So, what is our history? Well, women and girls haven't always enjoyed equality. In law, we are supposed to enjoy equality now. First, we were told that we were the property of the men who married us or who fathered us. We now see that as rather ludicrous. We don't accept that anymore. In fact, now women have been declared persons in this country, and we're permitted to vote, and we're supposed to be equal according to Section 15 of our Charter. In 1983, men were given the clear message that just because you marry someone, no longer you're allowed to rape them either. And so we had the continuation of the notion of women's equality, that men could be convicted of raping their wives if they forced themselves upon their wives sexually. Some of you will remember, I certainly remember, it's been my working lifetime that that debate occurred, and it was seen as outrageous that a woman would expect to not be made sexually available to her husband if she married him. That would be seen as equally outrageous now as a position, I would suggest, for anyone taking the opposite view. Now we have an opportunity to clearly articulate that women's equality requires that we no longer accept the commodification or sale of women for sex in ways that further enhances women's sexual inequality. How do we get there? Some say more legal sanctions, some say no legal sanctions. The reality is that we already have laws in countries around the world that address violence against women and girls, including in this country. I don't hear anyone suggesting that just because we have not eradicated violence against women that we think it's okay, and so we should not have any provisions prohibiting violence against women. That is essentially what we were talking about when we talk about decriminalizing women, but not decriminalizing the act of buying and selling women for sex. We don't argue, debate, lobby at all that we will in fact revisit the notion that violence against women should not be criminalized. I haven't heard anybody raising that. I would suggest we would all think it unthinkable. So here we go. Sorry, I'm over time. So we don't want to see free market capitalism as an excuse. We want to see the end to violence against women. We are concerned that there are provisions in this legislation that would continue to potentially criminalize women, like some of the advertising provisions, like the provisions around having individuals in areas where children will be, particularly when the majority of the women we're talking about are poor, single moms. We do not support the inadequate provision of services, resources for social services. We do support the need for things like a guaranteed livable income, adequate social services, health care, and we do support a provision that is not there currently that we think should be, and that would be to ensure that, in fact, all those who have been criminalized for prostitution should have their records expunged in the way that was done when the grain. Great, thank you. I look forward to questions.
Both presenters have, but I'm trying to be as generous as possible here to get your points before the committee. Mr. Hooper, please proceed.
I'm going to defer to Ms. Nagy.
All right. Ms. Nagy.
Thank you for the opportunity to appear before all of you today. I'm going to read my testimony just to make sure we are on time. My personal experience in the sex industry started when I was forced into it by traffickers at the age of 20 here in Canada. I escaped and I started my life all over again. Years later, my boyfriend committed suicide, and I found myself on the street on a cold winter day without shoes and money. Wasn't eligible for any social assistance from the government, without any family support. My choice was either to become homeless or go back to the sex industry for a few months till I get back on my feet. I decided to go back for 3 months. Neither time was really a real choice for me, and both times I experienced the same thing, which was violence by Johns. I'm a survivor of sex trafficking, a former prostitute, a founder of an agency that works with victims of sex trafficking here in Canada. Yes, they actually do exist. Our latest victim was 15 years old. Well over 90% of the victims we deal with here in Canada, they are Canadian girls, and they are forced into sex trafficking and prostitution. Yes, I know that we already have laws for human trafficking, but the law does not address the root cause of sex trafficking. And that is the demand, which is the John, if you like to call it that way. It's very simple, actually. If the demand is decreased and there would be fewer buyers, there would be definitely less victims, because the traffickers would go out of business. It's simple as that. If you go to a store and if you don't find your item, you will not keep going back to that store again. If buying becomes difficult, demand will decrease, and there is an evidence to that. In Sweden, the prostitution unit was taping a European trafficker's ring conversation on the phone. The traffickers were trying to decide where to take the latest shipment of women to work in Europe. They quickly decided not to take them to Swedish land because business is so horrible there, because there are no buyers. According to the prostitution unit, they only had 3 human trafficking charges in 2013 in a capital city. We had over 145 in Canada just last year. The Canadian government is taking a huge step forward with this legislation. This legislation is finally targeting the real criminals, the Johns and the pimps. I hear the pro-groups loud and clear when they say, well, what about us? What about the women that are in it? Because they want to be in it. It's our choice, and there is no pimping, and we have the right for our safety as well. And I say, yes, you do. But according to you, you made a conscious decision to enter into a very dangerous world. The trafficked victims didn't make that decision for themselves. You have the luxury of working 4 hours a day or just 10 hours a day if you like to. You have the luxury choosing your client or declining your client, or the service that you would like to provide or don't want to provide. The trafficked victims don't have that luxury. You could call the police if the John hurts you. The trafficked victim can't. But the truth is that the real danger happens behind doors, when you are alone with the John. Not knowing his phone number or his name or having a copy of his driver's license will not keep you safe. It did not keep me safe in the past. The other thing I would say is that I'm very happy for you for being able to make $2,000 to $3,000 a month and feed your family, pay for your education, for your lifestyle. And most of all, I'm extremely happy for you to have the luxury and most importantly, your freedom to be able to sit at this table and have this debate. Our victims don't have that. What about the girls that are trafficked and kept under horrible conditions across Canada as we speak? What about their safety? What about their freedom? What about their rights to safety? They can't be here today to tell you the truth about Johns and the pimps. They are not in the industry to buy $1,000 worth of shoes. They are not in the industry to pay for college. They have been lured, manipulated, and they are being kept against their will while serving 10, 15 clients a day like I did once, just so that they can eat once a day. And they're not doing this for money to save up. They are doing this so they don't get beaten. They work for months. They serve thousands of clients. They make thousands and hundreds of thousands of dollars for pimps, and they will never see a dime from it. We believe that there are a lot more victims in the sex trade than independent workers. But yet again, you can't hear their voice, and not because they don't exist, but because they are still enslaved and they can't be here today. That's why we have other agencies, frontline workers, experts to be here today and testify on their behalf and tell you that they are not just our wild imagination, they are real. They are our daughters, our sisters, and mothers. Both sides do agree on one thing. This is a very dangerous business because of the Johns. Otherwise, the pros wouldn't have asked for a law to protect their safety. I know from working on the front lines that sex trafficking is a huge issue. Most of us in the country don't actually realize how bad it is. I see this every single day. Canadian women and girls are trafficked and held and tortured and manipulated by pimps, and girls' lives are ruined forever by Johns. So my question is to you, do we create a law for luxury, convenience, to be able to support a habit, or do we create laws to save lives, to create a healthy and a safe future for our society? I am supporting this bill because I believe that we should create laws to protect our most vulnerable, and this bill will do just that. Thank you very much for listening.
Okay, thank you very much. And we'll begin the questions. We have a long list of questioners. We'll begin with the Deputy Chair of the Committee, Senator Baker.
Thank you, Mr. Chairman, and a special thank you to the presenters here today and the witnesses. However, Mr. Chairman, I would like to dedicate the rest of my time to Kim Pate to finish what she had started in her presentation. I have great respect for this witness. She's in case law, as we all know, presentations to the Supreme Court of Canada down to the superior courts in the provinces. So I wonder, Ms. Pate, if you could just turn your mind back to your thought when the 5 minutes came up as to what you were about to say and continue on to the end.
Okay. Thank you very much. Our organization had a position of decriminalization across the board until 2008. Part of the reason we changed our position was because we started to see, as we were seeing cuts to social programs, health care, as well as challenges to women's equality, some of the most disadvantaged women and desperate women were facing even more brutalizing and dangerous conditions on the street. And so some of you will remember the case of an individual who was picked up after he had electrocuted, he had attached cables, booster cables to a woman, was electrocuting her. This was in the downtown east side in Vancouver. And when I went to the prison and started talking about that example, because the woman had not reported to the police, nobody else, that man had never been reported to the police, even though he had a trunk full of evidence that he routinely was buying women to abuse them. And when I spoke to the women in prison, one of the things they talked about, and this was at the time also that we were looking for women who we later realized had been found, their remains were found on the Picton farm, and what they talked about was the fact that if they were the poorest, if they had mental health issues, if they were addicted, if they had criminal records, the likelihood of them ever doing anything but prostitution was increasingly becoming more remote, and they believed that they could be bought and sold to be brutalized, not just for sex, not just for brutal sex, but to be beaten, to be electrocuted, to be in some cases, I don't think anybody ever consented to being killed, but that was seen as part of the reality of prostitution. That led us to change our position and to argue that instead we should be clearly articulating that, especially with NAFTA and others, the fact that we know there are people referred to as bunny ranchers, the fact that we know in the state of Victoria in Australia when it was legalized and the brothels were opened, they became the fastest trading commodities on the stock market, that we needed to re-examine this position, and we re-examined it and decided that we had to pair it. It's not just a decriminalization of women, it continues to be a decriminalization of women in recognition that their position of inequality is fundamental to this equation. It also talked about denouncing the commodification of women and girls as part of a longer-term strategy around equality and the provision of guaranteed livable incomes, adequate social services, health care, all of which have been alluded to but aren't fundamental to this legislation. We would argue that should be in the preamble, that should be clear. $20 million is not sufficient. That's what we're paying to have Preston Street fixed up. And, if that's all we'll put into this, it shows not really a clear indication of equality. No mandatory minimums. When we have seen the focus of the law change in 1983 to 1990, I've got the wrong year now, sorry. But when we saw the law change to communicating for the purpose of solicitation, we argued, I wish we were wrong, we were not, in 83 it was, that women would be, still would be jailed and men would still avoid criminalization. That's exactly what's happened. I have said across this country since before this bill, since before Bedford, find me a man who has been jailed, criminalized and jailed for pimping or for buying sex. All right, and unless they have done other things, beaten people up, they have not been criminalized. You know my position. I don't want to see more people in jail. I don't think there is any illusion that attitudes will change, just as they have not fundamentally in some areas on violence against women. But we have had a change in attitude around what is acceptable in terms of how you treat women. I suggest this legislation continues in that vein, but there are things that need to be changed. We need to ensure there are adequate resources. We need to ensure there are no mandatory minimums. We need to take out the provisions that say that women advertising can ever be criminalized regardless, and that we need to take out the provision that says a woman who may have to prostitute in her own home when her child is in the next bedroom may be criminalized. Until we have all the other options available so women can actually make choices, so that the very, very few, our position would not interfere with the very, very few who actually have a choice at all. And yet it will interfere with the creation of increasingly dangerous situations. I was just speaking, I received a call from a woman, now an hour ago, who was in that position, who knows many of the victims of Picton, many of whom he was never convicted for, but they were clearly there on the farm. And she said, even if I would never call the police, if a guy knew I could call the police, I would be much safer, no matter where I started out, on the street, in my own home. And so, we are not talking about making it more dangerous. It already is incredibly dangerous for women who are engaged in prostitution.
I have a question for Miss Pate. If we take it for granted that the media, websites, or newspapers will publish full-page ads for sex services, and these ads are sometimes the main tool of pimps and people who exploit women. I'm a former policeman with the Quebec Police, and when 3 women with 3 different names have the same phone number, well, that number is often a central telephone number. How do you think we should address advertising to avoid that kind of situation?
Well, I think, je m'excuse, mais
I'm sorry, I don't really speak French. No, go ahead in English.
We need to be looking at much broader issues, and so we need to be looking at issues around pornography. I had some of these discussions with my 15-year-old daughter as I was getting ready to come here. We're in Saskatoon now. She sees very clearly. She couldn't see more clearly who is being commodified in that community. She said, how come for all the Aboriginal girls, the expectation is they'll go out on the street and they expect we'll go get jobs in, even if it's retail or, so the fact that we have allowed women and girls in particular to be increasingly commodified is part of the problem. Criminalizing them after the fact is not going to solve it. I would suggest to you in that situation, if we have opportunities, if you can contact individuals who are engaged in prostitution and provide meaningful options, real options for them to exit. I don't know to a woman or to a young man. Some of you know I had young people, young men and young women live with me years ago who are coming off the street in that situation. I don't know to a young person that they would not choose another option, as Native Women's Association has just reinforced in terms of the research they've been doing. What's not provided usually, though, is an option for them to exit. The option is either be criminalized or remain silent and be beaten or continue in the situation you're in. And I don't think those are viable options.
Merci beaucoup, Madame.
Thank you very much.
Thank you very much, Chair. And thank you very much, Chair. And thank you very much for all your very powerful presentations. They're very moving. I'll speak for myself, nobody else, but there's no one here that wants people to go into, be pushed into prostitution or trafficking. And, we've never heard of anyone saying, I want to grow up to be a sexual worker. The problem I have with this bill is they talk about the prostitution not being a good thing, but then there is nothing at the end to show that we are going to deal with helping people exit. What choices do we give people who are in this? How do we help them to get out? To do that, the only way to do that is to have proper resources. And so I ask all of you, one of the main aims that has been outlined in this bill is to reduce prostitution or ideally eliminate it. How do you think this bill will achieve the goal? The goal is very laudable. I'm all for it. But I'm tired of being all the time passing bills that raise expectations with no resources.
I'd like to respond from the Native Women's Association of Canada. I see it as we're at a crossroads today in society, and the government has an opportunity to send the message to society that it's no longer acceptable to commodify women, as has been presented by everyone before me. I was struck this morning when I woke up and I read the headlines when I was signing into my email account, and I saw that the NFL had banned Ray Rice in the wake of this latest domestic violence, right? As Kim Pate laid out to you, years ago, that was a completely acceptable practice, both legally and socially. And as it moved from legally, it slowly, over time, moved socially. And it certainly was never acceptable for women or for society per se, but it was not something that an NFL or professional sports league would ever speak out about. But here we are, because you've had government leading the way to say a statement, a change in philosophy, a change wanting, demonstrating new policy, if you will, or vision for Canadians and for women in particular, to say, no, this is no longer acceptable. We're going to criminalize pimps and traffickers, and we're going to find a better way for women. There are plenty of opportunities. Aboriginal women are the fastest growing youth population. Over 80% are single women. If this government and any other government afterward were to invest in economic development, a quarter of what they're investing in family violence, you'll start to see a huge improvement in the social economic conditions of Aboriginal women. We need to invest in Aboriginal women in education and income, because although Aboriginal women have higher education than Aboriginal men, it's not translating into income. We need a guaranteed livable income for women, for all women, especially for those most marginalized, like Aboriginal women, immigrant refugee women. For them to have real options, we need those social programs, exit services, counseling, and services for women who have exited. Because, as Timea, not to speak for her, but as she spoke of her own situation of being a trafficked woman, escaping, and then returning, was it a choice or was it a forced decision because she had no other social services available to her? So to me, I see it as a crossroads right now that the government has to absolutely, is this an ideal bill? No, not by a long shot, but it's a step in the right path. and we have to send that message to Canadians. And Kim alluded to it earlier, and enough can't be said about this, and I mean, I don't want to confuse the conversation, but it needs to really be at the forefront of your mind. And that issue is pornography. It's not a moral issue. What I'm saying to you is children, particularly boys, have unlimited access to gonzo porn, violent porn, when they enter the slightest words on a computer today. It's gone, Penthouse and all that, that's seen as the good old days now. Okay, when a boy, 6, 7 years old, there are no measures in place to stop these children from having access on the internet. And why is that relevant to this issue? Because at a time that their brain is forming, in their formative years, they're seeing images of extreme violence and sexuality against women. And this is tainting their brains. This is tainting their appetite, it's forming their sexual appetite. And in turn, these men are becoming police, judges, parliamentarians, politicians. And if this is their view of women, and this is creating their sexual appetite for women, it's only going to further support the use of prostitution, the use of trafficking, the use and abuse of women as a commodity. So that's something that you need to keep in your mind when looking at this issue, because it is hugely relevant. With the online women selling services online, or pimps using services online to sell women, it's a breeding ground for disaster for boys growing up having access to internet porn, and in particular gonzo porn. But that's something we'll lobby you at a later date to change, about having some safeguards in place for children. I don't think anyone would dispute having safeguards in place for children having access to porn.
And with respect, Senator Jaffer, I think your point is well taken. However, it's not a position that has been necessarily taken by senators when other bills have passed which required the same sort of other interventions. And I would suggest a very strong message could be sent to ensure that some of these other provisions are put into the bill so that it can actually achieve, or at least have an aspirational hope of achieving some of those equality provisions. And so I would urge that they be there, that all of the mandatory minimum sentences be removed, and that we instead look at really clearly articulating this is about creating a more equal situation for women and yet again addressing violence against women.
To respond as well?
Yes, thank you. Thank you for the question, Senator. Tomei and I have discussed this at length, and really from our position we think three main things. One, $20 million is a start. It actually is more money than the U.S. government has put towards exit plans. However, we agree with our colleagues that it is wholly inadequate. We have some plans about social service exits and some guarantees that should be made to echo Ms. Pate with respect to criminal records being expunged, etc. We have a very good plan that would take some time to explain, and we do think there should be rehabilitation or recovery centers. We can tell you anecdotally from our experience of the 300-plus victims that we've dealt with to attempt to move them to recovery and to survivorship, that what is presently missing is once Tomei and her team does frontline work, what next, question mark, which is this isn't a 1 week, 2 week fix. This is a journey, if I could call it that, and there isn't a place for housing, for social services, for dental to get your teeth fixed because they've been knocked out, etc. I could go on, but that would be something that would be a dreamboat for us, that the next stages would come, which just echoes my colleagues' comments.
Thank you all for your presentation. Ms. Pate, I would have a question for you regarding the Supreme Court of Canada decision of R versus Gladue, of which I'm sure you're very familiar with. As you know, the court has enunciated several principles in the case of Gladue. And as I understand, Gladue is a sentencing principle that applies irrespective of whether there is a mandatory minimum or not. I also understand that Gladue compels a judge to explore options other than incarceration when sentencing an Aboriginal offender. Now, Bill C-36 calls for mandatory minimum sentences. Are you satisfied that C-36 is consistent with the GLADU principles and that mandatory minimum sentences do not run afoul of GLADU?
I would say I'm not satisfied, and I'd also defer to Teresa, who's and Native Women's Association on this. But if there's a mandatory minimum sentence, then the judge has very few options in terms of looking, except for increasing beyond that mandatory minimum sentence, unless he or she chooses to argue that they will not impose the mandatory minimum sentence. And so, in fact, the provisions of Section 718(2)E, what are often referred to as the GLADU principles, would not necessarily apply in those sentencing decisions. So I think it is a problem. It's part of the reason we would support not having mandatory minimum sentences.
But as I understand, GLADU applies irrespective whether there is a minimum sentence or not.
No, it has been interpreted. There may be some confusion because...
I know there are different interpretations to GLADU there.
No, well,
that's why I'm asking you.
It may be because, well, I don't profess to be the ultimate voice, but the Supreme Court of Canada has said that the provisions that are looked at that were looked at in the GLADU case and in Section 718(2)E apply in other circumstances, like release decisions from prison, like decisions around dangerous offender and long-term offender provisions. But they have not said, to my knowledge, unless it's something very recent that I've missed.
So irrespective of GLADU, you're concerned with the mandatory minimum sentences?
That's correct.
Yeah.
That's correct.
Thank you.
Joel, Senator Joel.
Thank you, Mr. Chair. I want to emphasize the answer given by Ms. Pate on it, because this question was raised in this committee in an earlier bill. When there is a mandatory minimum, GLADU principle doesn't apply. The judge is compelled to impose the minimum sentence, even though he is facing a circumstances whereby an abortional person can show that because of past experience, family trouble, exploitation on the street, whatever other circumstances might be explaining the case.
Even in the case of aboriginal offenders?
Absolutely, absolutely. When the minimum is provided in the bill, it imposes. We have asked that question previously to the Justice Department officers. I'm sure that the Library of Parliament can go back into the minutes of this committee and confirm that interpretation.
But I just don't want to cut you off, but I was reading the transcript from the House of Commons committee, and it appears to me that the witnesses for the Department of Justice had another answer. They were saying that mandatory minimum do not run afoul of GLADU. That's what I understand anyway.
Well, that's not what we heard on this case around the table. We'll have an opportunity, Mr. Chair, to check the record of previous witness in relation to that. Ms. Pate and Ms. Odette, my concern about the bill is the logic of the bill. The bill is based, according to what the minister has said to us this morning, as prostitution equating exploitation. If it is exploitation and victimization, why would the victim be found guilty? You know, because if the person is compelled, and as you all described, to survive, as Ms. Nagy mentioned, I mean, to eat one time a day, to feed her children, like the aboriginal person might have described earlier on, why the bill continue to criminalize a person who is forced to prostitution to eat one time a day? There's something illogical, in my opinion, of the philosophical basis of prostitution is equating to victimization of women. If it is so, then the bill would have to reflect that, and the judge facing a situation whereby that proof or that evidence would be brought to him or her would have to lift the penalty, lift the sentence of responsibility, of criminal responsibility, no criminal records, and the possibility for that person to be admitted to social services. So it seems to me that there is something illogic in this bill on the basis of the premise of the whereas of the bill, where we talk about exploitation, paragraph 1, commodification, paragraph 2, encourage prostitution to report incidents. How will I report incidents if I will be found guilty? You know, this is something to me, you know, illogical. The bill pursues two sets of objectives which are contradicted by some section of the bill. That's where I feel that listening to you, there is an element of a redefinition of some of the offenses in relation to persons who are proven being the object of exploitation and being pushed to prostitution to survive. That's why it seems to me there is something in this bill that doesn't stand the rationale of what the proponent says that it's supporting it.
Si vous me permettez, Monsieur le Président.
If I may, Mr. Chairman? Briefly, I would say, Mr. Senator, in my brief presentation, I mentioned that we do not want to criminalize Native women who end up in this situation. So, yes, there is an inconsistency. As a spokesperson for Native women in Canada, I know that women end up through no choice of their own at a young age, up to 18, in the sex industry. And to us, they should not even be considered as criminals. You said, why call if you will be accused of being a criminal? And we've said that from the very beginning. Our organization has concerns with regard to Native women when they are in extreme poverty.
It was clear that we do not support the provisions that would result in the criminalization of any women. That one of I would suggest to you that as I've tried to read, and perhaps I haven't been that clear, but let me try and articulate it a bit more clearly. In the preamble, there should be clearly provision, not just that women experience exploitation, commodification, but that this is a position of inequality, fundamentally, that women start from, and children, including young men. Young men tend to age out in our experience, that we're less likely to see adult men in the industry for as long. There are some, but again, though we would stand by our position that if people truly have choices, it should not interfere. Our position should not interfere with that. So if we inject the notion of equality, then we can see provisions that would say we will not see the criminalization of those engaged in for whatever reason, and that we will see those who choose to exploit, who choose to buy and sell, who choose to participate in the commodification, they can be criminalized. Now, our position would be no mandatory minimums. We don't think throwing anybody in jail for this will solve it. We need to be seeing some other options, but that's our position, as you would know from other appearances, that we'll continue to have. And so our position around sentencing would be continue to be look at productive options to try and address these issues. Look at public education, but also we cannot separate these provisions from the need for some of the other social and economic and health provisions that need to be in place as well, similar to other bills that have been before you.
But you have mentioned also the sections dealing with the advertising.
That's right.
And the one dealing with exercising prostitution.
Yes, we would suggest those be
within schools,
removed.
within the schools, perimeters or distance.
Yeah, we don't support those provisions.
Are there other sections of the bill you don't support?
Those would be the primary ones, but also all of the provisions that impose mandatory minimums, including there were some mandatory minimum sentences already on the books. We think those should be repealed.
Thank you very much to all our witnesses for your very sincere testimony and your very important testimony. Michel Odette, hello, it's always a pleasure to see you again. I would like to congratulate you for your commitment and the mission that you're carrying out within your community. I'm very aware of the situation. I know that 2 young women disappeared in Maniwaki. They're possibly taken into the prostitution business. This is a plague which affects your communities, but also non-Native communities. A few months ago, I had a meeting in Longueuil where I met with stakeholders with a youth center who follow and help 200 young women who have entered prostitution to pay for their debts and their drugs. So it's a vicious circle. They get into the business young and they engage in prostitution to pay their bills. This causes them to leave school and sometimes to commit suicide. It's a horrible plague, and the long-term impacts are often permanent. Our government has committed to this bill or rather in this bill, to invest $20 million. This is double what the Americans have invested on their side. So what I'd like to know from you is this, including from you, Michel. There has to be prevention at some point. We have to prevent young women from entering prostitution. We can't just criminalize pimps and impose sanctions. Often it's too late. Some women have been in prostitution, have been prostituting themselves for up to 20 years. They're 20, 25 years old. They're completely demolished socially, psychologically, and it becomes almost impossible for them to get well again. So what do you think about prevention? Especially people in your community. Is there any way we can invest more in prevention, not only in what comes afterwards, to prevent this plague from growing? So I'd like to know what you think about this, Michel. If I may, thank you so much for your comments at the beginning of your question. I have a great deal of respect for everything you've done so far, especially from a personal point of view. So what I would say, $20 million. Certainly we agree, all of us here on this side of the table. It's not enough given the size of the problem, but it's a good beginning, and Mr. Hooper shares his point of view too. Native Women of Canada for many, many years now has called for a public inquiry into the missing and murdered Aboriginal women. Unfortunately, there is a link, a connection with those women and the industry of prostitution and exploitation. So that is one part of the solution. Recently, the 13 premiers have supported the idea of holding a roundtable with the federal government, which is a conservative government. We have all kinds of Native programs and Native groups, and it would be good if we could sit down with them to find urgent and concrete solutions. And part of these solutions do include prevention. And when it comes to prevention, both men and women can collaborate, and they might take different approaches. And we think we could sit down with these various ministers, these premiers. We will now have legislation to counter prostitution, and so from that we have to develop awareness and tools. Awareness for Canadians, Canadian men, and women too, and awareness within our communities. So I believe that it is extremely important to do this, not just to criminalize people because this fills our jails. I believe that prevention is good. There are different approaches, both for Canadian society and for Aboriginal communities. I have a great deal of admiration for the work of the police everywhere in Canada. I have a question which might put you in an uncomfortable situation, but I'll put it to you nevertheless. When it comes to the intervention of police and legal intervention, because, of course, the police are involved in your communities to help solve problems, and they're also involved in the legal process. So do you think there is fairness in the way natives versus non-natives are treated by the police? I've had to deal with several files involving disappeared Native women, and I got the impression that not as much work was being put into those files versus the files of other Canadians who had disappeared. Do you think that we need to work more closely with the police to make sure that we move forward in this area? I wouldn't want to say in a better way, but in another way. If I turn to the Opal Commission's report from British Columbia with regard to the response of the police with regard to victims, most of whom are Aboriginal women, and the Human Rights Report sheds a very negative light on the relationship between the police and Native women. It seems that when Native women are involved in the justice and public safety area, these cases are treated differently. However, I think that we could take a more positive approach. Instead of arguing about this, can't we focus more on prevention? We've reached out to the RCMP, and soon we will reach out to the Canadian Association of Chiefs of Police and the Chiefs of First Nations. there is no law which prevents us from sharing information between police forces, but we as an organization, can we develop courses, information, tools to make a difference on the ground? And Mr. Senator, the best example I can give you is that in 1998, our organization began working with the chiefs of police of First Nations to find ways to help counter spousal abuse and violence in communities. And so during these 2 hours per year, we could speak with these new Native chiefs of police, and that has morphed into a 2-day workshop, if you will, and certainly we can build on that. Certainly we can point fingers at each other, but why not for the 10 or 20, 15 years, why not work even more closely with police organizations?
Thank you to all the witnesses for coming here today. I'm certainly happy to hear that all of you support this particular piece of legislation that will serve to protect our most vulnerable, and I also appreciate your support for the abolition of prostitution. I support that as well. I have 2 questions, and I will pose them to Ms. Nagy, and I would like her to respond. I think she, in her presentation, made it clear she probably, out of everybody in the room, has the most direct experience in much of what we're talking about, and I appreciated you sharing your story with us, and certainly commend you for the work that you are doing. I would also, however, like the Native Women's Association to respond after Ms. Nagy has. We have critics, of course, to this bill, and many critics say that prostitution can be a legitimate profession when proper safeguards are in place. And further, many of the same critics would say that prostitution is in fact a free choice between consenting adults many times. And we have talked much about children, and you got into the profession very young. But how do you respond to these critics that say we are taking too large of a step, because if there are safeguards in place, it would be okay, and we are also interfering with consenting adults engaging in prostitution?
Thank you very much for those questions. I hear them all the time. I do believe that there are women out there today who believe that this is their choice. And I'm not going to go any further in that. But I know that they believe that this was their choice. I believed that it was my choice when I went back because I needed the money. 10 years later, when I gone through a lot of counseling, then I looked back and I realized that I was sexually molested when I was a child, then I was trafficked, and then it was my normal. And so, of course, I believe that it's totally fine to turn a few tricks to make some money for food. 10 years later, right now, if somebody would want to have sex with me for money, I would feel like I'm being raped, because now I feel clean. And I've been through a healing journey. And so, but to respect where they at in their life, that's why I say I believe that she believes right now that this is her choice. And again, I want to say, because this is one of our way of working with victims as well, that this is her journey, this is her choice, and if she believes that this is her choice right now, I don't have the right to judge that. That's not my life, that's her life. But what I do have the right to do is to help her along that journey to make it as safe as possible. So when we talk about this, you know, there are women that wants to do this, and it's between 2 consensual adults, I also would like to put the spotlight on the client. So the woman says, well, he comes in my room, he pays for sex, it's between him and I. Well, what about his wife who's at home with 5 kids? We had cases where we knew, we were in a parking lot with the police officers, and we knew where the husband just came out of. And the husband went home, and there's the 5 children with the wife. Doesn't the wife have the right to know where the husband just been? I highly doubt that that wife actually know where he was. Doesn't the children have the right to know where he was? So if it's consensual, Does the John goes to the wife before he goes and pays for sex and say, sweetheart, I'm going to go for an hour, I'm going to pay $350 and I'm going to have unprotected sex because that's how I like it and you don't really like it that way anymore, and let's have this conversation with the children too. Are you guys okay with that? Because that's consent for me. But when it's just between this one man and one woman behind closed doors, I don't take that as a consent. Now, in the event that the buyer is, or the man is single, and there's all kinds of reasons why he's doing this. Again, it's his choice. There are cases, and I'm not going to argue, there are cases when it is consensual. But my answer to all of that is that, yes, there are women who are in this business because they chose to, and I believe that they are doing this because they want to. But they have their freedom, and they have been able to keep doing this business somewhat safe. But they are the one who brought this argument forward and saying that it is not safe and we need new laws. So why are you choosing a job that is so dangerous, and then why are you looking at the government to keep you safe? What did we do for minors, fishers? I can't remember what we did back in the day in Nova Scotia, where eventually the government said this is a very dangerous business, we're closing it down and you're no longer allowed to do that. If you want to do this, you need to do this on your own. So the last comments for that is that we both agree that this is a very dangerous business. This is not like working at McDonald's, as I heard my pro-activists on television saying. This is nothing like working at McDonald's. You're going to a job where guaranteed that you're going to be abused, raped, or violated by a John or by a pimp. I have a different job now, and I can't say that I have that fear going to work every single day. I'm sure you don't have the same fear either, and I'm sure the person at McDonald's doesn't have that fear either. So I don't think we can call that as a sex work. And just because it's been around for so long, it doesn't mean that it's okay. We've been murdering people for so long, so is that okay? Should we just drop the laws?
So your choice was either have sex, eat, or be beaten. So you had a choice.
Oh, yeah, I had a choice. Yes.
Thank you. Maybe you'd like to comment.
Shortly, and I guess my colleague will continue. Well, for my end, I have to say that I've been for 20 years now with Quebec Native Women and Native Women of Canada, and between that, Deputy Minister for Status of Women in Quebec, and I never met an Aboriginal woman who told me, a young woman or a mother saying, I did it by choice. It never happened. But I don't say I met all the women across Canada. What I'm saying today, with the research, the knowledge, and the expertise, and the passion that we put into it, we do not judge those women that I didn't meet or hear, because probably they're there, who made it by choice. But one day, if they decide to go out that circuit, comment t'appelles ça, ce circuit-là, this place, then the government has an important role, provincial also, and the municipality, to support the organization who help women to come off that industry.
I wanted to make a comment that I want to bring it back to what I had made earlier about the crossroads and the decision of the government. We really need to keep our focus on not about preventing women from going into prostitution, but preventing men from buying prostitution, right? We need to look at the role of men that they can play in this. And as I mentioned with the saturation of prostitution and gonzo porn, where violence is a huge role in prostitution, forming young men's minds or young boys' minds, we need to have a clear message from the government, from society, from leaders, from senators, from organizations, from sports agencies that says it's no longer tolerated that we buy, use, and abuse women, and that this isn't a question of consenting. We're not going to fight for the rights of a few who might argue that this is between two consenting adults, when we know, the high rates, 97%, are subject to violence by Johns and pimps, or they can't leave, even if they did so-called choose to go into prostitution. They have a debt incurred, and he says to them, well, yeah, you have to pay me off $100,000 before you can leave. None of us have that kind of choice when we go to our work. We give our 2 weeks' notice, or we leave without notice and suffer the consequence of not getting paid. That's not the case for women involved in this. And I really want our attention to stay where it needs to be, also on the huge role that men play in this. Right? When we see that constant example, Bob beat Mary, right? What happens out of that classic example? It becomes Mary is a beaten woman, and Bob's gone. Bob's out of the equation entirely. And then suddenly all government and officials and civil society is working to deal with Mary, the beaten woman. And what are we going to do for Mary? Hold it. What are we going to do for Bob? The fact that he beat Mary in the first place. And it's the same with missing and murdered women. It's not about what are we going to do to keep these women buddied up or not hitchhiking or being safe. It's what are we going to do to stop men from killing them? That's a huge problem. What are we going to do to stop men from killing our women, men from beating our women, men from raping our women, and men from buying women? We've got to move past this. We need a new vision for Canada, and I have to believe that you all want a new vision for Canada than simply buying and using women.
Thank you. I have a quick question for Ms. Pate. And I know Senator Baker referenced your extensive background in law in the preliminary to his question, and I could be wrong. I've heard that you are now also, as well as your responsibilities that have you appearing here today, also serving as a law professor at the University of Saskatchewan. Is that correct?
Yes, I'm currently in the Sallows Chair in Human Rights at the University of Saskatchewan Law School.
Well, I'm not sure if you're comfortable with this, but I know reading the clips that came out of our meeting this morning with the minister, the bulk of it that I've read, noticed so far has been referencing the issue of constitutionality. I mean, you know, given your background in law, I just wonder if you have a view with respect to the constitutionality of the legislation.
Well, certainly our view would be in light of the fact that Section 15 allows for proactive measures to encourage equality provisions to be implemented. I think the provisions that would call for women to be decriminalized and for those supports to be put in place should survive charter scrutiny. Certainly there were discussions about asymmetrical application of the law in other areas. I think, you know, for the most part, those I would support that. I do think, as I've already said, there are parts of the law that I would encourage you to change and to adapt. But I think there is certainly an opportunity for this to be implemented in a way that meets the constitutional requirements, and I think adding into the preamble the fact that we need to ensure there are equality provisions there would help with that. And so,
Senator McInnes.
Yes, thank you, Mr. Chairman, and thank you for coming. It's been very enlightening. In fact, as you can appreciate, over the last few weeks we've been inundated with information with respect to prostitution in Canada. And this is not the question I intended to ask, but sitting here listening, it's perhaps appropriate I'm the last one. First of all, this issue now has been given a high profile. This is a glorious opportunity. But as I sat here, I heard commodification of women by men, inequality under the Charter, which of course I knew, percent of Native women involved, survival sex, drugs, buying food for children and clothes, trafficking of humans, children involved in the sex trade. I was provided with bibliographies of, I think it was something like, there was 199 articles, books, and or papers that were written on this issue. You've all said that you think that this bill will be helpful in bringing down the number that's involved in prostitution. You also talked about the fact that the 20 million perhaps will not be enough. I'm not sure what amount would be enough if there's not infrastructure in place to deal with the social economic problems. it seems to me that there are all kinds of organizations like yours, from coast to coast to coast. And so, is there a need for some way of channeling this so that we do actually target the issues? And we do actually, try to come up with anything but a quick fix, because I don't think the quick fix is there. And so this bill's going to pass probably, and it'll become law. And so then what? Where's your high profile then? And so this is an ongoing problem, and it's a socio-economic problem from what I'm hearing from you. So what's your suggestion to government as to how we're actually going to bring, at some point, a resolve to this?
I'm going to start, and then Mr. Hooper has a couple of thoughts. We have already talked about this. The number one thing is prevention, is education. Not just educating the society and men, but educating law enforcement, police, and what that, everybody says, well, what is that going to do? Well, according to studies, the Johns are between the age of 25 to 45, college, university students, majority of those Johns. Well, it all starts in school. Where do you want to go for your stack party, strip joint? Well, let's have an education about that. So when you start at the early age, you educate the man, which is the demand, so you slowly decrease that, which means they're not going to buy the girls, and then the demand is not going to be as strong. There is no quick fix for this. We messed up society for the last 40 years, so we're not going to fix that in the next 2 years, but we need to do that in baby steps. You eat the elephant one bite at a time. This is the first bite, and we need to do that. And so you start the education, you educate men, you educate girls. This is not okay to be a prostitute. It is not okay to sell your body, and so on and so forth. Make it not acceptable in society, because right now and he will tell you, it takes, he did this as a research study, I'm so sorry, but it will take 6 seconds for a man to buy a girl online in Canada. So what kind of a society do we live in if we allow that? So it's all about prevention, education. You start with that, so to make sure that no more are become a victim. And then you have to take care of the victims that are involved currently. And for that, yes, there are organizations across Canada that are trying to help, but there isn't enough funding for those organizations. And we do have to become one. I mean, all of us, not just, us and then pro groups, because we would love to have education from them so that they can educate the ones that are currently in it, because it's not right to force them out of it. So we have to come together as a country, all of us together, put our differences aside and say, how can we do this together? And yes, there are funds that should probably come from the government, but corporate world needs to step up big time. So there's a lot of money in Canada from all kinds of corporations, and they are doing nothing against it, and they're doing nothing for it. For example, hotel companies. So I think we can look for extra money and funds from corporations in Canada. It's not just the government's problem. This is society's problem. So everybody have to come together for this.
I want to be clear, this bill alone, even with the amendments that we've suggested, would not solve this issue. Having been in the last year in Amsterdam and in Germany and in Thailand, we know what happens when you allow free market capitalism in this area, and we've seen the demand driven up. We've seen the incredible influx of other women, women being trafficked in. Trafficking is already happening in Canada, not just as Tamea has talked about, but also between communities, whether it's women from the East Coast to the Central Canada, whether it's all around. I mean, when I was working with young people 20-some years ago, it was the triangle between Vancouver, Edmonton, Calgary, that young Aboriginal women in particular were trafficked. So what we really need to be focusing on, like many of the crime bills, is fundamentally looking at a much broader approach. And so putting that in the preamble would be helpful, but to pretend that this bill alone will solve this issue, I think would be silly, quite frankly.
Have something to add?
Yes, just briefly. I mean, Back to the question of choice, generally speaking, we echo that we've not had anybody come to our services say they chose to be trafficked or prostituted, but we really see two things. Two studies came out about what Canadian population thinks about prostitution, and quite honestly, the numbers were surprising to me that there was many people who thought legalization was an option. And what that said to me and to our organization that we've talked about is that Canadian society is who needs to be educated because they think that's okay. But I think if you drill down and ask more than the question of do you think it should be legalized or not legalized, if you say if that was your 14-year-old daughter or son, what are you going to think about that? I think the answer is going to be vastly different to our society and to the business leaders in this community. And the last point that we see is, and we've probably said it a number of times, is but the social economic situation that we're in, and particular groups are in this country, there has to be something that eradicates that. And I think Teresa and Michelle have said it. May have said 40 years, and I think you said maybe 200 years that you've been trying to solve that issue. And that's the root of the problem. Not only the awareness of the society, but fixing that problem so people aren't making that fake choice at 14, 15, or 16. And we need to get to elementary schools and high schools from that perspective and educate both sides. We often talk about we're going to fix this problem because we're going to go tell girls not to be at Tim Hortons at 10:35 in Kapuskasing, Ontario, because that's when the pimp's going to show up and take you to Toronto. Well, we also need to tell the 14-year-old boy in the Toronto school that he shouldn't pay $150 to have sexual services from that girl from Kapuskasing. So we need to educate the entire society. So that's what we see.
At the second round, we've got a little over 10 minutes left. I have 4 senators who wish to ask questions. I hope the questioners will keep the time in mind as well as the witnesses, and we'll begin with Senator Baker.
Just very quickly, Mr. Chairman, just to verify what our witnesses have said here today, Teresa Edwards and Kim Pate specifically, about the application of mandatory minimum sentences to Aboriginal offenders. And Senator McIntyre was absolutely correct. We did a fast check, and we found out, yes, that the Department of Justice did give evidence before the House Committee. And the words were that the mandatory minimums do not run afoul of GLADU. GLADU is a principle that would be applied in light of the mandatory minimum. However, Senator Joyal and Ms. Edwards and Ms. Pate are absolutely correct because we just checked and we found that just 3 months ago, the Supreme Court of Canada in R.V. Anderson said as follows: appeal allowed by the Crown and sentence varied to mandatory minimum sentence. Crown prosecutors under no constitutional duty to consider accused Aboriginal status. So you're absolutely correct. There may have been some discussion in the courts as to the truthfulness of that, and Senator McIntyre was correct in quoting the Department of Justice in the House of Commons, but it's obvious that you're correct. They were wrong. Thank you. Yes, as far as mandatory minimums are concerned in R.B. Anderson. In June, 3 months ago.
Okay.
To settle the matter, but our witnesses here today, Ms. Kate and Ms. Edwards, were absolutely correct that that is the standing law, Mr. Chair.
That clears the air.
Senator Dagenet.
I listened to your presentations, and so I have a question for Ms. Odette now. Ladies and gentlemen, I noticed that all of your presentations were well structured with the objective to convince young women not to enter prostitution. Of course, some of you have a voice in the media. Can you explain to us why the message does not seem to get through to young women? In other words, we've heard you, and I don't understand why young women do not hear your message. So I'd like to hear you on that. Well, the message does get through. I just came from the Native Women's Centre in Toronto, and they didn't know me. They'd never seen me. They did not know how passionate I am about the issue of murdered and missing Aboriginal women and the fact that I want to build Canada into a better place. And the simple reason for that is because we are not on the ground. Native Women of Canada is here now with you instead of being on the ground. Our provincial and territorial organizations, however, are doing the best they can. So my dream, if I may, Mr. Senator, if this roundtable does take place, I would like us to sit down with the RCMP, with the SQ, with the OPP, and the other police organizations so that everyone could focus on doing outreach together. This way, young women would know that Native Women of Canada, of Manitoba, a provincial organization, are out there, as well as services for them. But, of course, I can't be everywhere at once. Our organization is doing the best it can. We do work through the internet. But, as it now stands, when we're here with you, we're not on the ground. And we have a very small team of 13 people to cover a large territory. Well, certainly I've seen your face before. I've seen it on TV recently. And I believe that Radio-Canada, they have a national mandate. So, anyhow, 30 seconds. A woman on the street, a homeless woman who is subject to extreme violence, unfortunately does not tend to listen to the news. I don't want to be sarcastic, but our artists, our musicians, people on the ground also have a very important role to play in terms of public education.
Quickly, please.
The reason some of our youth still don't hear our voice, because we are up against the mainstream media, musicians, rappers, and it is embedded in our culture that it's cool to wear the short skirt, it's cool to have a high heel shoes. That whole message is on our society right now, and our job is, as a society, with the prevention programs, to bring that voice back down and say it's not cool. It's not cool to be pimped. It's not cool to work, and it's not cool. So,
can I just add? Sorry. The other thing is we've had the hypersexualization of young women in particular, but add to that the hyper-responsibilization, this notion of choice. So when I go out and speak in a public event and I'll say, okay, how many of you here are planning to have a buddy or have someone walk home with you? Almost invariably it will be the young women who have received that message loud and clear that it's their responsibility to make sure they're safe. We don't generally, if we had the headlines being, after there's been an attack, no man is allowed out after dark unless he's accompanied by a woman who will vouch for his credentials as a safe man. Nice. Yes, of course, people laugh. And yet we don't laugh when we say that a woman should not be walking alone at night by herself because it may be unsafe. And so we have to change fundamentally those ideas about whose responsibility is to keep us all safe. And it's not just the individual woman.
Chair, did any one of you reflected on this bill and the impact that it will have on the improvement or none of the health condition of the women who are involved into prostitution?
Looked at one of the issues we've looked at for some time, and as part of our reconsideration of our position in leading up to in 2008, was would it be healthier to have what many have advocated, red light districts, brothels. The reality is in areas like Amsterdam, like Thailand, like other jurisdictions and including New Zealand where they have those options, the women that we walk with and are part of our organization and we work with generally would not be able to access those, either because of their records, addictions, mental health issues. And so the reality is those women are not likely to benefit from any kind of option that would regulate or legalize. And in fact, in those countries where we've seen that kind of regulation and legalization, admittedly, New Zealand is going to be one of the last to go, largely because it's an island, largely because it's right next to another country that has legalized prostitution as well. But in most other jurisdictions, we've seen the demand go up, the influx of others into the country, and the rate of violence against women also.
Last question, Senator Jaffer.
Thank you very much. As you all know, I've talked to you privately, there are many things in this bill that bother me, and one of them is to put women and girls together. There are such different issues, and I'd like to hear from you, your point of view, should there be two different bills? Because the challenges that girls face, young girls face, are very different from the women. What is your opinion?
I'm sorry, not lengthy questions or responses. We only have 2 or 3 minutes, so if you can condense it, that would be appreciated.
Yeah, although I think we need to have separate services for women and girls, I think the distinction being made, girls are trafficked, they come of age, they're told it's their choice, and they're adults, right? So I think we need to move with this legislation and continue to work on the nuances that we want, the improvements that we want, the additional things, but we need to have this foundation, we need to have it now. So I don't think we need to separate it to have something specific for girls and something for women.
Thank you all. Very helpful and informative deliberations and contribution to our hearings. And we have a very lengthy list of witnesses, and we want to give them all an opportunity to make a contribution to our deliberations. So thank you again. We're going to suspend briefly and await our next panel. Thank you again. Order, please. Our next panel, appearing before the committee from the Asian Women's Coalition Ending Prostitution, Suzanne J. and Alice Lee, who are members of the organization. Appearing as an individual, K. Brian McConaughey, who's the director of Ratanak International. Hopefully I've pronounced that correctly. From the Evangelical Fellowship of Canada, Julia Beasley, who's a policy analyst with the organization. And from Pivot Legal Society, Katrina Pacey, litigation director, and Carrie Porth, the chair of the board of directors. Suzanne J. is going to lead off. Please proceed.
Okay. Thank you very much for the opportunity. The Asian Women Coalition Ending Prostitution works to advance equality for Asian women and to promote our meaningful participation and leadership in civil society. We believe that prostitution is male violence, and we work towards the abolition of prostitution. We applaud the intention of the bill to protect women's dignity and equality rights. It's consistent with the principle that all Canadian law is to be understood and interpreted in the context of the Charter of Rights and Freedoms. The preamble of the bill demonstrates an understanding of the systemic nature of prostitution and the consequence of undermining women's equality on the basis of race, national or ethnic origin, color, and sex. We appreciate that the bill acknowledges the danger that's inherent in prostitution and the profound exploitation that's done by pimps, brothel keepers, procurers, advertisers, and customers of prostitution, especially as it affects Asian and other racialized women. We recommend strengthening the preamble by including an acknowledgement of the disproportionate impact of prostitution on racialized women and to reference the international agreements that Canada has signed committing to eradicate discrimination against women and to protect trafficked persons. We support the section of the bill that criminalizes advertising of sexual services because of the role that advertising plays in normalizing and entrenching ideas in people's minds. In Metro Vancouver, Asian women are dramatically overrepresented in the advertising for prostitution. Asian massage parlors are embedded in neighborhoods across Canada, and the advertising for sex with Asian women is so regularized that it's virtually invisible. Stereotypes that we have to deal with, such as Japanese schoolgirl, China doll, subservient and eager to please, they dehumanize us and sexualize Asian women. The normalization of these stereotypes blocks our access to our charter rights, regardless of whether or not we're prostituted. Pimps, procurers, brothel keepers, and advertisers, and the others who are involved in the sales and marketing of prostituted women, they cater to these very deeply racist demands, and it's in their commercial interest to normalize these stereotypes in order to grow the market for their product. The practice of prostitution overlaps with the violence of wife battering, rape, and incest, and these are all acts of sexist violence that are usually committed by men in private venues, where privacy is used to confine women, reinforce the attacker's authority, and hide the violence from public view. Being indoors with a man does not increase safety for wives, incested children, or prostituted women. However, we do recognize that indoor venues, including Asian massage parlors, they do enhance safety for men. They shield pimps, brothel keepers, procurers, and johns from scrutiny, and they hide the violence that is intrinsic to prostitution. We are worried that there is now a loophole in the legislation for pimps to disguise themselves as bodyguards. We support the bill's tailored approach to target the source of the harm to prostituted women. We support that the bill makes a differentiation between those who depend on a woman's income without caring about how it's earned, such as children and hairdressers, and those who are parasitically invested in recruiting and trapping women into prostitution, such as pimps, brothel keepers, procurers, and johns. The Parliamentary Committee has already indicated that they understand there's a problem with criminalizing communication in public areas. The amendment to target women only around schools, daycare, and playgrounds, it still weakens the legislation because criminalizing women for their own exploitation undermines the objective of equality. Human trafficking is intrinsic to Asian women's experience of prostitution, regardless of what country we come from. Trafficking is an area that my colleague Alice Lee can speak to in more detail. We appreciate that the bill prevents the transformation of members of organized crime into regular businessmen. Currently, the human trafficking law we have only applies to the traffickers, and it does not apply to the buyers. Bill C-36 makes it illegal for a man to buy a trafficked woman. However, the bill does not change the balance of power that organized crime and human trafficking operations rely on, because the current immigration law supports the exploiter. We recommend granting women in exploitative situations landed status upon arrival to Canada in order to reduce a woman's vulnerability to recruitment and to contribute to successful exit from prostitution. In conclusion, a made-in-Canada approach to prostitution has to be a lot more robust in order to be effective in a racially diverse country. Criminal law is limited in that it can only address violence and exploitation after it happens. The Asian Women Coalition Ending Prostitution calls on our federal government to provide comprehensive social supports to interfere with recruitment and to facilitate women's access to our charter rights.
Okay, thank you. Now, Mr. McConaughey, I guess you are next.
Thank you. Mr. Chair, ladies and gentlemen, thank you for the opportunity to speak to Bill C-36. My name is Brian McConaughey. I have 22 years' experience in the RCMP and 24 years of directing a charity that assists youth recover from the abuse of the sex trade. I would like to commend the government for its efforts in Bill C-36 to identify those prostituted as victims rather than criminals. I also support criminalizing those who purchase and benefit from the sale of Canadian women. I do not support legalized prostitution. The harm reduction principles presented in support of legalized prostitution are, I believe, misguided. I remain unconvinced that women in prostitution will be safer if regulated. It is in my opinion, foolish to presume that the introduction of regulations would transform prostitution into an industry of compliance. I do not believe that the legalization would have protected women Willie Picton picked up who ended up dismembered and in my RCMP freezers for forensic analysis. What we do learn from the Picton file and the analysis of their body parts indicates that Picton was only the last in a long line of predators who had over years subjected these women to traumatic abuse and injury. Let us be under no illusion as to the brutality of this industry. Canadian citizens are routinely subjected to great harm in prostitution, and their vulnerabilities are exploited to the full. Legalized prostitution would seek to address only peripheral violence, the threats, beatings, stabbings, etc. However, it is my belief that the central activity that is prostitution represents violence against women. Harm reduction practices will not protect women from violence if the job itself represents violence. The purchasing of women's consent and subjecting them to thousands of paid rapes does violence to their bodies and is profoundly destructive to the psyche. Young women exiting prostitution frequently attempt suicide. I have never encountered a young woman in a transition program that has attempted suicide because of her memories of beatings or being held at gunpoint. Invariably, the source of distress is a profound sense of worthlessness resulting from repeated sexual assaults that are central to the job, along with the associated verbal abuse that undermines their self-esteem and shakes their identity to the core. This is the central violence of prostitution. If then violence is central to the life of prostitution, the only clear way to reduce that violence is to reduce the size of the trade. Experimentation in other nations teaches us that legalization will not reduce the harm, but by growing the trade will increase it. In addition, I believe we are naive if we assume the creation of a legalized Canadian industry of sex abuse would go unnoticed by a very large source of demand south of the border. Simple economics dictates that the demand will be filled with increasingly vulnerable product found within Canadian society. Providing such a market is potentially catastrophic. The issue of choice. I view prostitution as a seamless continuum of abuse that runs from the prostituted child who, by virtue of age, is deemed incompetent to consent, and progresses into the abused adult who, by virtue of conditioning, addiction, trauma, is frequently rendered equally incapable of informed consent. Tragically, in this context, we see victims consenting to bodily harm and physical injury driven by their desperation for the next drug fix. Call it what you will, this is not informed consent free of duress. It is my belief that the law needs to target those who clearly have choice regarding such harm. Those women, the majority of whom have experienced abuse as children, who are frequently drug addicted, manipulated, and extremely vulnerable, do not have that choice. However, those with money, careers, and a reputation to maintain, those who kiss their kids goodnight, say goodbye to their wives, drive downtown, and choose to abuse a vulnerable woman or girl, these are the ones our laws clearly need to focus on. So as one who has spent far too much time picking through the dismembered body parts of prostituted women, analyzing the circumstances of their brutal deaths, as one who knows how many years it takes to rehabilitate an abused youth, as one who has devoted his life to the recovery of such victims, allow me to assure you this is not an industry of choice for the vast majority of those prostituted. It is neither lucrative nor empowering for them. It is destructive and it is deadly. One of the key indicators of a mature democracy is its ability to look past the superficial and create legislation that protects the most vulnerable, irrespective of their circumstances or standing in society. In creating this legislation, Canada has moved to protect such victimized women. While I have reservations regarding Section 213, communication, I am in support of this bill and would ask for its speedy passage. Thank you.
The Evangelical Fellowship of Canada is the National Association of Evangelical Christians, gathered together for influence, impact, and identity in ministry and public witness. Over the last 2 decades, the EFC has presented a number of papers and submissions to Parliament on the subjects of prostitution and human trafficking. We also acted as interveners in the Bedford case before the Supreme Court of Canada. We're grateful for the opportunity to speak to this important bill. In July, we made a submission to the Justice Committee offering our firm, if qualified, support for Bill C-36. Because the time is short, I'd ask that you refer to our written brief for our fuller comments and recommendations. In crafting this bill, the government has taken a big picture view of prostitution and courageously challenged the long-held assumption that men are entitled to paid sexual access to women's bodies. They've also boldly refuted the notion that buying sex is inevitable in our society. In this regard, the bill represents a paradigm shift in law and policy about prostitution, and eventually, we hope, in public attitude. The preamble recognizes that prostitution is inherently exploitive and dangerous, that objectification of the human body and commodification of sexual activity causes social harm, and that prostitution violates both human dignity and gender equality. It also recognizes that issues like poverty, addiction, mental illness, and racialization are key contributing factors to individuals entering prostitution. And it notes the importance of denouncing and prohibiting the purchase of sex because that's what creates the demand for prostitution. This positioning effectively turns the historic treatment of prostitution on its head. Legal and political treatment of the issue has long focused almost exclusively on those who are prostituted and how we might deal with them, as public nuisance, as a threat to public health, or a source of community disruption. Sex buyers who drive the demand that funnels individuals into prostitution and holds them there have been largely invisible. Bill C-36 correctly identifies and targets demand as the driving force behind prostitution and sex trafficking. The bill proposes a new offense prohibiting the purchase or attempted purchase of sexual services. If passed, buying sex would be illegal in Canada for the first time, and a buyer's conduct illegal wherever it occurs. The sex trade operates according to market principles of supply and demand. Without male demand for access to primarily women and children, the prostitution industry would not flourish or expand. So the new offense takes aim at the root of exploitation, and it's supported by significant fines and potential jail time. Surveys of men who buy sex indicate that these, along with the risk of public exposure, are the things that would most effectively deter them from persisting in their sex buying. The bill also initiates a critical shift in how those who are prostituted are viewed in law. Research and anecdotal evidence tell us that between 88% and 96% of women in prostitution are not there by choice and would get out if they felt they had a viable alternative. This bill recognizes and reflects that reality. The government has made it clear that in the spirit and intent of the law, those who are prostituted are no longer seen as nuisance, but as vulnerable, as victims of exploitation, and are afforded immunity from criminal charges, except under specific circumstances. This is an important shift that we affirm wholeheartedly. But before the Justice Committee, we expressed concern that the wording of sections 213.1 and 1.1 left a fairly big loophole that could undermine the intent of the legislation to criminalize mainly the activities of Johns and pimps. We want to minimize the scope of this section for continued criminalization of prostituted individuals. The committee did hear this concern. It was raised by almost all witnesses who appeared. And they amended Section 213.1.1 to specify that the public locations referred to include areas near schools, playgrounds, or daycare centers. And we welcome this amendment. Still, by our interpretation, the only ones who risk potential criminalization under this section are, in fact, the most vulnerable. Individuals engaging in street-level prostitution who are among the most desperate, most addicted. So criminalization of vulnerable individuals creates barriers to their exit from prostitution and serves mainly to further entrench the inequality and marginalization that got them there. Criminal records are a significant barrier to many potential educational and employment opportunities for those who successfully exit. So we recommend, again, that the punishment for offenses under Section 213.1 and 1.1 be set at a very low threshold, with no potential for imprisonment, and defined in the legislation to ensure that the most vulnerable don't continue to face undue punishment or hardship. Further, since much of the success of the laws will depend on how they are enforced, we recommend standardized training be developed for law enforcement, provincial attorneys general, and Crown attorneys about the new treatment of prostitution under Bill C-36 to support enforcement that is consistent with the intent of the legislation. Finally, the proposed laws are to be part of what is a two-pronged approach taken by the government. We welcome the initial commitment of $20 million to support programs assisting individuals with exit, and hope this will translate to increased long-term sustained federal funding. Bill C-36 is not perfect, but what it accomplishes by reframing the issue as it does and directly targeting the demand for paid sex is significant. And for these reasons, we support it. Some have argued that Bill C-36 will endanger women, but it's not the laws that are the cause of the violence and stigma experienced in prostitution. Rather, it is the belief that men are entitled to paid sexual access to women's bodies on their terms at all times, and the common perception among sex buyers that those they buy are other, somehow a class separate from mother, wife, or daughter. And unless we challenge those beliefs, as this bill does, the misogynistic attitudes and behaviors that are the cause of the violence and the stigma will persist. Thank you.
Ms. Porth, did you wish to lead off?
Yes. My name is Carrie Porth, and I'm a former sex worker and current chair of the board of Pivot Legal Society. Bill C-36 will create an environment where more exploitation, more violence, and more desperation will occur. It didn't have to be this way. The Bedford decision represented an historic opportunity to open a balanced national discussion about sex work. This was our chance to prioritize the voices of sex workers who have extraordinary expertise about what policies and regulations would protect their human and labor rights. Instead, we have a bill that improperly characterizes all sex workers as victims and then fails to provide meaningful protections to them. I want to make an important point today that I feel gets lost in these discussions. The experiences of sex workers fall along a spectrum. At one extreme, you find people who have been coerced into sex work or who face extremely challenging circumstances in their lives, leaving them few options to make ends meet. At the other end of the spectrum, you find people who identify sex work as their calling and who derive fulfillment from their work. The vast majority of adult sex workers fall somewhere in between those two extremes. Because sex work occurs along this spectrum, laws and programs need to respond to a diversity of needs, and I submit that 3 principles should guide Canada's laws and policies in this regard. 1, we must ensure that people who are in the sex industry, irrespective of the circumstances that led them there, have access to the safest possible working conditions. Ensuring safety requires that sex work be decriminalized. 2, we must ensure that people who experience abuse, coercion, or victimization in the context of sex work have access to the protections they need. This does not require the enactment of new laws. It requires that we ensure that sex workers have access to the range of criminal laws that are intended to protect them and do address all of the harms that may occur in the sex industry. 3, we must ensure that those who do not want to be doing sex work have the support and options they need to make that change in their lives. Criminalization does not help in this regard. In fact, it limits options for sex workers. The way to ensure that no one is doing sex work out of desperation or lack of options is to ensure an effective range of social supports and professional training options. That is how you really support choice. Thank you.
Thank you. And I'm going to spend my 2.5 minutes responding to what I see as a number of fictions that are being relied on in order to rationalize the approach proposed in Bill C-36. First, it is false to say that criminal laws that prohibit the purchase of sexual services or other aspects of adult sex work will have a considerable impact on rates of prostitution in Canada. I dispute what justice officials said this morning. I dispute what's been reported to you insofar as the results from Sweden and Norway. Criminalization in many different forms has been tried all over the world in many different ways, and in no jurisdiction is there any solid empirical evidence to show that there's a meaningful or significant decline. In fact, even where there has been a decline, there are many, many other explanations, such as sex workers moving from the visible street sex trade to indoors. Second, it is wrong to represent C-36 as a legal framework that immunizes sex workers from prosecution. Street-based sex workers will continue to be criminalized on the street, and any sex worker could be criminalized if she or he is involved in running a business, a partnership, a cooperative enterprise, or anything that could be deemed a commercial enterprise, or where she or he is seen as deriving some benefit from the work of her or his colleagues. This should not be supported by any Canadian that has a true commitment to sex workers' safety and rights. Third, the government says that C-36 conforms with the Section 7 rights of sex workers and with the Bedford decision. They say that C-36 does not limit sex workers' access to safety-enhancing measures, such as screening clients, working indoors, and working with others. Again, this is simply false. Just like the Body House law, the ban on purchasing sex and the ban on advertising will make it practically impossible to work indoors. Sex workers will be deprived of that meaningful opportunity to work safely. Just like the communication law, the prohibition on communication by clients, as well as communication by sex workers, will continue to displace marginalized street-based sex workers to dangerous locations, will give them little time to negotiate or screen clients, will place them at odds with police. These are the exact circumstances that we've experienced in the downtown east side, and are the exact circumstances that Commissioner Wally Opal found led to the tragedy of the missing and murdered women. And like the Living on the Avails provision, the prohibition on procuring and the prohibition on materially contributing or benefiting will continue to isolate sex workers, will continue to deprive them of engaging in safety-enhancing relationships. C-36 will reproduce the conditions we saw under the laws struck down in Bedford. It will decrease sex workers' control over the circumstances of their work and does not conform with Section 7 of the Charter. And my final point is that there's a statement being made that the Bedford decision, if allowed to stand, if the laws are struck down, will create a void, that there will be a lack of protections in place for sex workers who experience abuse or exploitation or forms of violence in the context of their sex work. And that is simply not true. The anti-trafficking laws remain on the books. The laws that prevent sexual exploitation of children and youth remain on the books. The range of provisions that protect all of us from abuse, extortion, assault, confinement, threatening, and harassment all remain on the books. And those are the provisions sex workers are asking for access to. They're asking for equal and full protection to the protections that exist for all of us, and sex workers should have that access as well. Thank you.
Thank you all. And we'll begin the questions with the Deputy Chair, Senator Baker.
Thank you, Mr. Chairman, and thank you to all the witnesses for their very excellent presentations. Ms. Pacey and Ms. Porth, you say that the new law that is being now considered before this committee, you believe will be struck down, just as the Bedford matter was struck down, those 3 provisions by the Supreme Court of Canada. Could you elaborate on that a bit? You said, for example, the three provisions that the government have put in place here, that is, if it concerns one's own sexual services, that there is immunity from prosecution for advertising, for deriving a benefit from sexual services, and from counseling or aiding and abetting. And there's a provision there that says that you would be allowed to hire receptionists or drivers or bodyguards and so on. You say that this does not really accomplish anything for the sex worker. Could you elaborate on that for us?
Certainly. Perhaps I'll begin by saying that Bill C-36 is a very extensive bill, and there are many aspects of it. What I'd like to focus on in my comments regarding the constitutionality are those provisions that I've discussed today. So specifically focus on the provisions that ban purchasing sex, the materially benefiting provisions, and the provisions that I've spoken to today.
That's very much appreciated, because the bill is called to amend the criminal code in response to the Supreme Court of Canada's decision in Attorney General of Canada versus Bedford. That's what the bill is supposed to be about.
That's correct.
But that's only a minority of what's in this bill.
There are many, many aspects to this bill.
Yes.
There are mandatory minimums. There's many pieces.
So you're going to deal with the measures that we want to hear about. So you go ahead.
I hope so, and if I don't, please ask me. So we have to start with the starting point, which is the Bedford decision. Yep. We have to realize that what the Bedford decision says is that laws that impede sex workers from taking steps to ensure their safety, irrespective of why they're doing sex work, if there are meaningful steps that they can take and the laws prevent them from doing so, then that is not justifiable pursuant to Section 7 of the Charter. We take that analysis and then we look at the provisions, and the place where I believe we need to begin is the effect. We need to ask ourselves, will the provisions that are found in Bill C-36 that specifically target adult sex work itself, whether it's buying sex, whether it's communicating in public, whether it's engaging in business relationships, and we need to look at whether or not it's going to reproduce the same impact or effects that sex workers experienced under the laws that were at issue in Bedford. In my submission, I think both based on the evidence and a full and comprehensive review of the evidence from Canada, from around the world, as well as just plain common sense, frankly, I think it is very clear that the same effects will be reproduced. Street-based sex workers will continue to work in the most dangerous parts of our cities. Indoor sex workers will continue to be deprived of the ability to set up the safest possible indoor spaces for themselves. And I think it's quite logical to imagine that a sex worker who says, I'd like to establish an indoor space, if she's unable or he's unable to advertise and tell anybody that they're carrying on their business, a police officer merely has to park out front and tell their clients that they're under arrest the minute that they attend there. If that person has to continue to work alone because the minute she or he engages with others, it's considered a commercial enterprise, I think you can see how this is an indirect attack on the capacity of sex workers to work indoors. So if we look at those effects, then we move on to ask ourselves what will happen with a Section 7 analysis. The minister this morning was very careful to say that they have constructed the preamble and the objectives of this legislation in order to deal with what they see as the balancing exercise that they lost on at the Supreme Court of Canada, which was laws that are particularly about nuisance cannot be justified if the outcome is harm and violence. So they've reconstructed the preamble and the objectives. In my view, even with the preamble and the objectives as they're stated in Bill C-36, even if it is stated for the record that this is about protection, when the court looks at the evidence, when the court understands the real direct impact and engages in that balancing exercise, in my view, the laws will fall.
The preamble, of course, is not determinative of constitutionality by itself. The provision, what's in this law, is determinative together with the preamble. So you're absolutely right there. It's not just enough to say, well, it's the preamble. You've made an important point that we're talking about, in this matter, a consent between adults, aren't we? We're not talking about child prostitution or anything else, not the Bedford decision. Those matters still remained in the law. So your point is that even if these matters were not addressed by the Government of Canada, you would still have adequate laws in place in Canada governing this subject.
Absolutely, and I bring that position to you as a lawyer who's worked in the downtown east side of Vancouver for the last 12 years with an absolute commitment to sex worker safety. That is exactly why I do this work, is because of my concern of the harms and the violence that I have seen experienced by the women that I'm so close to in our neighborhood. And it is from that place that we have sat down with the criminal code, that we have sat down with experts, constitutional experts and criminal lawyers, and we have analyzed this and said from a place of with a clear interest in protection. Does the Criminal Code of Canada, with these laws gone, and those laws meaning the ones at issue in Bedford, if they are gone, is this enough for you? This is from sex workers themselves, and the answer was yes. They do not want to see people, forced into sex work. They certainly would never want to see someone trafficked, and they certainly want children protected. And they said, you know what, with these laws gone that are perhaps unintentionally harming us, and that being living on the avails, communicating, and body house, there still remain a full breadth of provisions that provide them with the protection they want and that they've been deprived access to because they're treated as criminals.
Thank you, all of you, for coming here today. Mr. McConaughey, I'd like to start with you. First of all, I very much appreciate your comment. I thought you really boiled this issue down when you said that the people who should be targeted are the ones who have the true choice here, and those are the ones who buy sex. And that is what part of what this bill tries to do. I also very much appreciated your comments in your opening statement, and you made a similar comment to the House of Commons Justice Committee, where you talked about young women exiting prostitution frequently attempt suicide. And as someone who, that's a very personal issue too, I've done a lot of work over the last several years to try to help people have better awareness and about mental health and suicide. I very much, that struck a real chord when I heard that. And you talked about that profound sense of worthlessness, and that's the central violence that is prostitution. So I'm just wondering if you could speak a little bit more about that particular aspect.
Yeah, I think a lot of the issues, and colleagues around this table would totally disagree with me, but we are all, I think, united in the desire to protect women. And I think the difference of opinion comes in an understanding of what is the violent component. The peripheral violence, as I choose to describe it, is the beatings, the stabbings, the threats, all that kind of stuff that is not central to the job. However, my opinion is that the actual job description of a prostitute is in and of itself destructive. And this is what, even if we can produce regulations through legalizing, where we have an industry that is regulated and there's health care provided and there's bodyguards and everything is sweetness and light in terms of the structure, I firmly believe that the actual job description is destructive to the psyche. And this is what we see with women who have transitioned out and girls who have transitioned out, that it is this understanding of worthlessness from the repeated sexual assaults that creates the absolute despair. That fundamentally is a career choice I don't think any of us would want our daughters to make. And I don't think it is a career that we should be institutionalizing as a Canadian society, saying that young women are a product to be sold. And I am very leery of the implications of this in terms of south of the 49th parallel. If we create a legalized industry here, we really are naive if we think there's not going to be truckloads of guys coming north of the border. We've seen this in Germany in terms of the amount of trafficking of women coming in to service people coming from all over Europe. Thailand is a great example where you have a legalized trade there, and they pretty well stripped the Northern Hill tribes of girls, and they moved on to taking as many girls as they can get illegally trafficked across the borders from Cambodia, Laos, Vietnam. It becomes a much bigger issue. And here we are as a fairly small population contemplating what could be a legalized sex trade just north of Detroit, etc. What is the Detroit-Windsor border crossing going to look like when this kicks in? So we're playing with fire here, and if we think that the actual primary duties, if I can put it that way, of a career in prostitution is not damaging, I really think we're naive.
Thank you. To Ms. Jay at the House of Commons Justice Committee, you said we, meaning Asian women, experience negative consequences when our characteristics, whether they are real or imagined, are sexualized and commodified to promote sexual services. These stereotypes dehumanize and sexualize Asian women, and they block our access to our charter rights, regardless of whether or not we are prostituted. I thought that was a very interesting point, and I'm wondering if you can just speak a little bit about that when you hear arguments about, prostitutes' charter rights, and then you have your own response to that, which I thought was a very interesting point.
I think it's important to not create a subgroup of women for whom it's acceptable to contravene their human rights or commit violence on them without consequence. And I think that that's what happens when we address the whole issue of prostitution as dealing with by separating women into sex workers or non-sex workers. For Asian women as a group, we rarely get to escape any of the stereotypes around the sexualization of our characteristics. Whether or not I work in a massage parlor, when I walk down the street, there's a very real possibility that someone would just simply assume that I'm sexually available in the same way they would expect any woman walking down the street in Thailand or any of those other sex tourism places to be sexually available to them. It's an assumption that men are trained into now through sex tourism, through pornography, through the normalization of the advertising in online venues and newspapers for Asian massage parlors. Asian massage parlors have become a running joke. They are they're kind of background to much of the popular hipster culture that we're dealing with right now. And having men accept those ideas about us without question and have them means that those are the men that we work with. Those are the men that we go to school with. Those are the men that are also in positions of authority over us. And if their presumptions and their adoptions of those stereotypes are unchallenged, they apply those stereotypes to us as well, and that has an impact on whether or not we will be dealt with as equals in the workplace, in the school, and it will have an impact on what kinds of duties we're expected to perform in those venues.
Thank you.
Thank you, Chair. I have first a question for you, Ms. J. or Lee. You talked about getting landed status, but I didn't quite understand. Something I've been working on for years for exploited women from outside Canada is, can you explain what did you mean that when the person arrives here they immediately get landed status, or when they're found in the massage parlor by the police? Now what the practice is in our city, in Vancouver, often they're driven to the airport, but is that what do you mean? Can you expand on that? And while I'll ask Ms. Pacey and Ms. Ford my questions as well. And that is that, can you expand on the report that you did, that PIVET did on the issue, and what was I don't quite agree with all the due respect with what Justice said about the situation in Sweden and Norway. And you have some experience, so can you expand on that? And as chair of PIVET before, if you can further explain what it will do to what will this bill exactly do to sexual workers? So we start with Ms. J.
Sure. The short answer to the question is we are recommending that Canada grant landed status to any women who arrives here in Canada under exploitative circumstances. So we would include as mail-order brides, as under the Temporary Foreign Workers Program and under the Living Caregivers Program. Those are people who are coming to Canada because almost always because of poverty in their own countries. And they're coming here for better opportunities, but somebody here is sponsoring them in order to take advantage of their disadvantage in their country of origin. And so we're saying that there are examples, very recent examples, of how the balance of power remains in the hands of the employer in the Temporary Foreign Workers Program. There are several cases very recently showing how those people are very subject to exploitation. And if they have regularized status, then there's a greater possibility that they can escape those circumstances. Also, I'd like to say that that the procurers, the pimps, the organized crime that operate the Asian massage parlors and micro brothels, they rely on women having irregular immigration status. If the women don't have irregular immigration status when they arrive, they encourage it. They confiscate papers. They encourage women to overstay visas. They also just threaten women with reporting them to immigration, because women don't have always enough information about what their rights are when they're here in Canada.
Thank you. So Pivot recently released a report entitled "My Work Should Not Cost Me My Life," and it was a collaboration with the BC Centre for Excellence in HIV/AIDS. So it was looking at the impact of a shift in enforcement by the Vancouver Police Department towards not pursuing sex workers on the street, towards actively pursuing their clients. So while it has only been official policy of the Vancouver Police Department since January of 2013, it's been in effect for about the last 5 years. So what sex workers in the report were reporting to us was that they were having to work much longer hours. And, you know, a sex worker who has stood on the street for 6 hours and hasn't made any money that day, she can't just say, oh, well, I'll just go home for the day. She relies on that income to meet her survival needs. So she's having to stay out far longer. For street-based sex workers who are working in active addiction, the longer they are out, the more likely they are entering into withdrawal. That makes them much more vulnerable to accepting a riskier client out of desperation. The other thing that's happening is a shift in the behavior of clients. They're much more nervous because they know that they're being enforced on for communication in a public place. So they're wanting to meet sex workers in darkly lit, industrial, isolated areas. They're asking sex workers to either get into the car before they negotiate the terms of a transaction, or to follow them into a dark alley and do the transaction there. So that leaves the sex worker with little to no time to assess the client for signs of intoxication, to check his car, to see if there's a door handle on the passenger side, to see if there's weapons in the car, and just to get a sense of the client, but also to negotiate the terms of the transaction, including what she is or is not willing to do, where she's comfortable being taken, and how much she's willing to be paid. These sort of rushed transactions can lead to misunderstandings. Those misunderstandings can lead to violence. And so the focus on enforcement against clients really puts sex workers at risk. The Vancouver Police Department supports the criminalization of the purchase of sexual services. They believe that they need it as an extra tool to help them find predators. They like to talk about a single case that occurred, I think, in 1988 or 1999, where they did a check of a vehicle in the downtown east side and discovered that there were weapons in the cars and restraint devices. And they hold that up as, we stopped a predator. But what I like to remind the Vancouver Police Department is, according to their own report to the Missing Women Commission of Inquiry, they stopped Canada's worst serial killer on dozens and dozens of occasions in the downtown east side, and it didn't stop him from killing a single sex worker. So casting a giant net over every client in the hopes that you'll catch a single predator isn't going to work. And when we continue with that experiment, sex workers' lives are going to be at risk. Thank you.
Well, thank you, Chair. And just one or two comments before I ask a question. The overall intent of this legislation, of course, is to abolish prostitution, not to make it a safe occupation. And so, Ms. Pacey, I think maybe both of you have talked a number of times about how this is making it more dangerous for prostitutes. Well, of course, we don't want to make life safe for prostitutes. We want to do away with prostitution. That's the intent of the bill. We had just before you a witness, and I'm not sure if I'm going to pronounce this correctly, but you know who I'm talking about, Tamia Nagy, founder of the Frontline Victim Care Worker. And I asked her a question about choices, and she agreed that she had choices. She had a choice to go and turn tricks, or she had a choice to get beaten up, or she had a choice not to eat. And these were the choices given to her. She started as a young prostitute, left, and went back into the business because of not being able to eat. I guess my question would be, and you have not said this directly, but you have at least intimated, in my opinion, that this is in some degrees a reasonable occupation. And maybe, Ms. Porth, you can be more direct in this. You said you're a past sexual worker. How young were you when you went into the trade? I don't think many prostitutes wake up on their 18th birthday and say, I think I'm going to become a prostitute. I think they have somehow gotten into that occupation at a young age, been coerced, been manipulated, been forced into it. Do you have evidence that would show that that is not true, that the majority of sex workers are adults when they go into it and they really enjoy their type of work, and that this is not a very violent sort of an occupation?
So to be really clear, I started doing sex work when I was 34 years old. I started doing sex work in the context of extreme addiction and profound poverty. It was nevertheless a choice. I have a university education. I could have found other work. I could have gone to detox and treatment, and that's not what I chose to do. I didn't particularly like doing sex work, but not for the reasons most people think. I just didn't like playing dumb, and that's actually a part of the job. I never experienced any violence on the job. I was able, for the most part, to work in my own home. I had somebody else there if I needed any help. In the 4 years I did sex work and in thousands of sex work transactions, I only needed help once, and that was simply because the client had overstayed his welcome. It didn't require any violence to encourage the client to leave. I'm not suggesting that my story is in any way typical or atypical. The myth of the average age of entry is based on a number of studies, and there was a recent newspaper article, I think, coming out of the United States. There's been a number of articles and research that debunk that myth. It's based on a couple of different studies, but in both cases the studies were of underage sex workers, so chances are pretty good that the average age was going to be under 18. John Lohman, when he testified before the Justice Committee, had done a review of several Canadian studies which indicated the average age of entry in Canada is between 18 and 24 years of age. As I said in my opening statement, sex workers' experiences go along a spectrum. For 6 years, I was the executive director of Pay Society, which is a downtown east side nonprofit that works with street-based sex workers. I worked with well over 250 of them. Some of them really, really hated the work and really, really wanted out, and so we would support them to do that. Some of them were content with where they were at that time, and some of them were quite comfortable with their work and do feel that they chose it. I think what's really, really important is we need to start where people are at. We need to listen to what sex workers, currently working sex workers, have to say about their experience and start from there. And you need to believe what they tell you about their experience, because some of us find sex work, the idea of sex work, to be disgusting or distasteful doesn't mean that sex workers find it that way.
If I could just add to my colleagues' comments, I think it's very important to remember that pursuant to the Bedford decision and Canada's Charter of Rights and Freedoms, we have an obligation, this government has an obligation to ensure that its laws do not increase danger for people in the sex industry. The overarching objective that you mentioned about abolishing prostitution in Canada may be a legitimate objective from the government's perspective, but I'm here to tell you that it is not legitimate if those laws put actively working sex workers in harm's way. That is not consistent with the Charter rights that they have, and it's not consistent with the constitutional principles that protect all of us. The other thing I just want to make absolutely clear is that it will not work. Criminalization, very, very extreme forms of criminalization have been tried, as I mentioned, all over the world, and it has not worked in a single country. There is nowhere that we can look to say that they have stamped out prostitution or even considerably decreased prostitution. And there are many jurisdictions, and I'm speaking about New Zealand in particular, where we can look at decriminalization and that model as one that worked very effectively because it increased health and safety for those involved in sex work, but also did not increase the number of people involved in sex work. And that is because people do sex work for a range of reasons. And those are the reasons we need to be talking about today and taking an
And we are.
evidence-based approach.
And we are.
And we are. And so what I would like to remind us is that if we're talking about people who are doing sex work as a result of lack of choice or options, we really need to be looking at why that lack of choice or lack of options exist. For the women that we work with in the Downtown East Side, that is about a true and significant and meaningful investment in the services, dealing with the socioeconomic conditions that led them to sex work. Thank you.
I would like to come back to the impact of what Ms. Beasley has mentioned in relation to criminalizing prostitution close to schools. And I was surprised, as a matter of fact, to read your comment in relation to that, especially when you mentioned that those who will be involved in those areas will be probably the most vulnerable person. And we have heard, of course, the Aboriginal people testifying before. And I don't know if you were in the room at that time. Could you expand more on which basis of knowledge do you come to that conclusion? Because you're requesting us, in fact, to amend Section 213(1), if I read well what you have proposed to us.
Sure. So if I'm reading the legislation correctly, 213(1), which is it's still there as it was before, so the one section was struck, but the impeding vehicular or pedestrian traffic, approaching a vehicle, those remain. They are not qualified by the new Section 1.1, which was amended to specify areas near daycares, playgrounds, schoolyards. But the only individuals that are going to be affected by any of those are street-level prostitutes, right? So there's a whole wide swath of prostitution that exists outside of street-level prostitution, and primarily the ones we find on the streets, as I said, are individuals who are addicted, who are most marginalized. That's where you find most of our Aboriginal women who are being prostituted are on the streets. So what I'm saying is, in effect, by my understanding, the only ones who really are risking criminal charges under this reframing are those who are most vulnerable.
Do you have any comments to add to that, Ms. Spacey or Port?
I have many comments I could add, but I'll try to be very brief. There are, I'd say, two problems with the new reformulation of 213. One is that under no circumstances should street-based sex workers be arrested. And I think that seems to be an agreement from many of the panelists you've heard from today, especially this afternoon. The second point I'd like to make, though, is to ask you to contemplate whether the criminal law is necessary is the necessary tool or a useful tool to have a conversation with the sex work community about where sex work is happening in our various jurisdictions, whether that be cities or rural communities. Sex work is happening on the streets for various reasons. And in the city of Vancouver, where the Vancouver Police Department recognized that law enforcement, the effect of police pushing sex workers around, meant that sex workers were not coming to the police when they needed help. It was placing them in an adversarial relationship. And the Vancouver Police then put out a policy that said, we are going to use criminal law as the absolute last resort. We recognize the harms and the implications of that. And so what I'd like us to do is wonder and question why, in fact, that belongs in the criminal code, and why instead we might not be having conversations at the local level with our sex work communities and sex work outreach organizations to say to them, sex workers are working around a playground, although I have to admit it doesn't happen very often in our city because sex workers don't want to be near playgrounds for the most part. Just having conversations at the local level and saying, let's talk about where it's happening and where it's both safe for sex workers as well as good for our communities.
May I have another one? I raised this issue with the previous witness, the issue of health of prostitutes. Did any one of you have any comment to add to that? Will this bill, in fact, improve the security of the prostitute? Because, in my opinion, in the security of the prostitute, there is also the health risk, that, of course, happens to exist, which is very important by today's context of what could be a very deadly disease. So did you read the bill in that context also, the impact it will have on the health condition of prostitutes?
Sure. So the World Health Organization has condemned the criminalization of sex work as pushing sex workers further away from health supports and increasing their risk of vulnerability to HIV and other STIs. Criminalization in some countries has led to human rights abuses, such as mandatory testing, which the UN also recognizes as a human rights abuse. And the Lancet published a series of articles about the relationship between criminalization and an increased risk of HIV transmission to coincide with this year's AIDS conference in Melbourne. So what it means is that sex workers already have poor health access. They face a lot of stigma. So when I was a sex worker, if I went to see my doctor for an upper respiratory infection, my doctor was constantly wanting to send me to get tested for STIs. And this is despite the fact that in Canada, sex workers actually practice safer sex at much higher rates than the general population. So you don't want to go to the doctor. There was also a red border on my file folder which indicated that I was a high-risk group. So sex workers face a lot of stigma. Continuing to criminalize their occupation, and it basically views them as criminals or as helpless victims. It reinforces stigma, and it means that they're not going to get the same health care as every other Canadian citizen.
If you would have...
The second round, Senator McInnes.
Thank you. I had a question for Mr. McConaughey and Ms. Beasley, but I wanted to ask this question if I could have. Ms. Perth and Ms. Pacey, because I didn't hear it, but you'll tell me if I'm wrong. Do you believe that prostitutes are victims and are being exploited?
I think to be a victim, there needs to be somebody exploiting you. I never viewed my clients as exploiters. I set my rates. I chose what sex acts I chose to be engaged in, and if clients were not going to obey that, then it ended. I was fortunate in that none of them became violent, but the reason they didn't become violent is they were in my own home and they knew that there was somebody else there. For sex workers on the street, they're far more vulnerable to that kind of exploitation and that kind of violence. What I was vulnerable to in terms of clients was them threatening to report me to the Ministry of Children and Family Development because I had a child, or threatening to out me to my landlord who could evict me if they came to find out that I was doing sex work in my own home. And so again, it's criminalization that makes the sex worker more vulnerable.
And if I could just add to that, my starting point has been listening to sex workers, and that's what I've done for the last 11 years. And I have met with sex workers who describe their experience as one of victimization. It's something they never chose to do, and it's something they never wanted to do again, and they were seeking assistance in terms of changing their lives and changing the line of work that they were in. And I've met sex workers who have said, this is a choice I'm making, and it's not for you or any other Canadian to judge me for it. I'm an adult making consenting decisions about who I have sexual relationship with. And with both of those sort of communities, or irrespective of kind of the experience that led people into sex work, the conversation that followed has always, how did criminalization assist you, or did it? And that was how Pivot entered into this discussion, was with no position on what to do. It was, let's talk to sex workers about the impact that criminalization has had on their lives, whether that be positive or negative. And that is the conversation we've continued to have. And whether I'm sitting with a sex worker who really, truly feels victimized in the context of sex work, and I absolutely believe her that was her experience, or someone who also, or who describes their experience as one of choice, and I absolutely believe her too, criminalization has failed both of those groups. And it is time, in my view, for us to recognize that and move on.
But you agree that most prostitutes do not want to be in that business?
I actually do not agree with that. That's not my experience. I work in the downtown east side with street-based sex workers who face incredible challenges in their lives and incredible barriers. And most of the women I work with in the downtown east side tell me that they are looking for to change their lives, are telling me that they are looking to transition out of sex work. What I also know is that they are a small population and small percentage of the industry, and when I step out of that community and I start talking to indoor workers, and I start talking to independent workers, and I start talking to students at the university who are doing sex work to pay their way through, or I'm talking to moms in my community that are making a living on the side through this kind of work, they tell me that it's a choice, it's the best choice for them where they're at, and they wish for the government to both respect them for that choice as well as encourage their safety.
Well, it's not my style to argue with witnesses, but I respectfully disagree, and particularly in the evidence that we've heard so far and the multiplicity of papers that we've read leading into this. So, but you're entitled to your opinion. The final question I want to ask you, I read where in Sweden, over a 5-year period, the prostitution was reduced by 40%. Now, you said that that is not so. What's your evidence?
My evidence is based on reading the 3 major evaluations that came out of Sweden, and of course the most recent evaluation in 2010. The evidence out of Sweden, there are methodological issues in my view with how that research was conducted. It does make and claim that prostitution overall, that there was a decrease. If you push deeper and you look more deeply at that research, what you see is that prostitution was declining. The visible aspect of sex work was declining already because of the emergence of the internet. And so they were already seeing a decline in terms of the numbers of street-based sex workers. And they didn't know what to attribute that to, but they think it was probably the emergence of the internet. Then the law comes into force, and they continued to see a decline. And they also acknowledged that there was very rigorous enforcement at that time. There's a new law, police are excited about it, they're out on the streets and they're cruising around and they're deterring clients. And that was certainly recorded. What we saw then was, in my understanding, was a decrease in interest because chasing clients around on the streets strikes me as what the police have represented their policy as, became less interesting, and you saw street-based sex work increase again. Meanwhile, you saw an emergence of sex work indoors. You saw more Swedish sex workers working and advertising online. And so you have to ask yourselves, are those numbers accurate? Is there a trend, which is in fact that the visible trade moved indoors? And when you start to look more deeply, the challenge that we have is that the numbers actually are not reliable.
Like many others here, I share the skepticism that's been expressed by some of you regarding the effectiveness of using criminal law to deal with such a huge and complex social phenomenon as prostitution. I don't believe that any amendments to the criminal code would have as much a direct impact as we'd hope on prostitution or do anything to increase the security of sex workers in general. Now I'm going to ask you, in Canada, whether it be at the level of the federal government, the provincial or municipal government, when we put together police forces, the variety of community organizations that work in this domain, the health services organizations. When you put all those together, have we somewhere arrived in any significant manner, say in a town or a city or a neighborhood, to reduce in a substantial fashion the phenomenon of prostitution, or at the very least make sure that the exercise of prostitution is undertaken in appropriate, safe conditions? Is there any evidence of anywhere in Canada of such an experience outside of criminal code amendments where the social phenomenon of prostitution was approached as just that, a social phenomenon rather than a criminal one? Has there been any evidence of efficiency or effectiveness?
To talk about two things. One is a group I've been involved with for some time, and it's been around for about 11 years in Vancouver, called Living in Community. So it brought together neighborhood associations, the police, Vancouver Coastal Health, sex work support organizations, sex workers, all kinds of people to discuss the issues of sex work and the impact of sex work on communities. It started with a series of community roundtables where people could come together to talk about the issue of sex work. And a few years ago, we conducted a demonstration project in a neighborhood called Renfrew Collingwood in Vancouver that had a very active stroll called the Kingsway Stroll. And so in the 2 years, what we did was a lot of public education for people in the neighborhood, weekly outreach to the sex workers, and a number of different other events. Worked very closely with the Community Policing Office. and prostitution like related calls to the community policing office dropped from 98 in the first year to 2 in the last year. And so what I find is that most people don't think about sex work, they simply react to it, and the reactions are often based on misunderstandings and misconceptions. And if you can talk to community members about things like if there's a sex worker that's too close to your home, you could go and actually just talk to her. And often residents are terrified of sex workers for no apparent reason. It can make a huge difference. The other one is in the downtown east side, there are 2 social housing providers, Vivian and Serena's, that both permit sex workers who live there to bring clients into their home, and so into a safer indoor space rather than doing sex work on the street. And both of those housing models were evaluated by the BC Centre for Excellence in HIV/AIDS and had very, very positive outcomes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. My question will be for Ms. Pacey. Obviously, Bill C-36, like any number of bills, is not perfect. It has certain deficiencies, but I think that overall it's a really good bill. And the ultimate goal of this bill is to decrease prostitution. Don't you think it's the best way to also decrease the number of victims, in this case, that are often women and children? I'd like to hear what you have to say about that.
With respect, I do not think it's the best way to ensure that people who do not want to be doing sex work are given other options. I think that there are a range of protections and supports that sex workers need that are not provided for in Bill C-36, and in fact, it detracts from their ability to be able to access those things. My colleague, Ms. Porth, made an important point that I'd like to make again, which is that if sex workers are asking and need supports in order to transition out of sex work, that is going to be through the provision of supports and options and professional opportunities to them. The imposition of a criminal law framework over them that makes it more dangerous for them while they're there, creates the possibility of a criminal record for them, although I understand it's lessened as a result of C-36, that possibility still remains, and then doesn't actually make a meaningful investment in terms of professional opportunities, educational opportunities, access to better housing, access to the treatment and detox that perhaps someone like Carrie Port's situation may have facilitated her situation and her safety. So it is that meaningful investment in the socioeconomic factors that leads some people to do sex work that we need to be focusing on, as opposed to focusing on a criminal law that, in my view, will make it less safe for them and is a dangerous distraction from more effective and useful tools. The second piece is really the importance of ensuring that sex workers in the sex work community has full access to police protection. Continuing to criminalize the industry will continue to place sex workers in a distrustful relationship with police, make it more difficult for them to access police. And I think that the Vancouver experience is one that speaks absolutely clearly to the importance of ensuring that sex workers face no barriers when it comes to accessing police services and protections.
Avec votre permission, Monsieur le Président.
With your permission, Mr. Chair, if you had the opportunity to listen to what the minister said, you would have heard that he said that they were going to invest $20 million in terms of funding. That will be a consequence of this bill. Of course, it could be more, but we still will have $20 million to help people get out of prostitution. I suppose you agree with that money?
Minister, that they scrap Bill C-36 and invest $20 million as a starting point to try to make a meaningful difference in sex workers' lives.
Thank you, Chair. Thank you all for your presentations. Bill C-36 contains 49 clauses. In July of this year, the House of Commons Justice Committee heard from witnesses in the same fashion we are doing today and proposed some amendments to the bill, one of which is an amendment to Clause 45. Now, the proposal in the amended Clause 45.1 is to review Bill C-36 amendments to the Code after 5 years. In other words, the legislation is to be reviewed within a 5-year period. Could I have your thoughts on this, please, regarding this amendment? Anyone?
I would think if the government was convinced that this bill was the way to go and believes that it will protect the rights and the safety of sex workers, that the review should occur earlier than that. Because if the bill is increasing harm to sex workers, we don't want to wait for 5 years to find that out. I would think that 1 or 2 years would be more appropriate.
So we had recommended to the Justice Committee a 2-year review be written in, so, 5 was better than nothing, but we had asked for a 2-year review as well.
Anyone else?
I think it's prudent to have such checks. I also think that this is a cultural change in terms of, there's a massive shift to be criminalizing the purchasers of sex. It's going to take a long while with the large, slow-moving legal animal that we know we have in Canada. I think it would be nice if we could get all the answers in 2 years, but I think it's impractical, actually. I think it's going to take a while to work through the system to actually know whether or not it's functional, to whether or not it's performing the way we want it to. So while we'd all want answers next year, I don't think it's practical, actually. It's going to take working through the courts, working through the police services, social services, to actually see what is the impact. Is it having the desired effect? And so I think 5 years is reasonable.
Either one?
We would agree that a review of the bill would be useful. One of the things that other countries that have instituted Nordic-style models of law have found that is that over the 5 years, there's an actual impact on the population of men and their attitude towards prostitution, and there's a tremendous impact on young men and their attitudes towards prostitution. So I would really like to see a review, and for that review to examine social attitudes towards prostitution at that point. And hopefully, one of the things that I'm noticing is that in our discussion, we're still focusing on women and on women as victims. One of the things that we like about Bill C-36 is that there's a refocus on the demand side of prostitution, and I'd like to see more focus on the impact that we expect Bill C-36 to have on men's attitudes and men's behavior. For example, when we talk about the health of women in prostitution, and particularly in Asian massage parlors or other kinds of very restricted circumstances, we need to be clear that it is men who are the vectors of disease transmission. They're the ones who should be tested. They're the ones who should face the health checks, if there's going to be any kind of health check at all. They're the ones who are bringing the disease into the brothels and the massage parlors and introducing and the ones who are demanding the unprotected sex.
Second round, we'll begin with Senator Baker.
Chairman, Ms. Pacey, you might be wondering why a lot of the questions are directed toward you. And you represented the Downtown East Side Sex Workers United Against Violence Society in the Supreme Court of Canada decision in 2012. And it took you 5 years to be granted public interest standing to argue against the present laws that we have in Canada. So if I were a betting person, which I'm not, you won your case before the Supreme Court of Canada. You now have standing to argue not exactly the same parameters of the case we're dealing with in Bedford, because your case was a little bit different. Your grounds were different. And so if I were a betting person, which I'm not, I would bet that the first person who's going to challenge this constitutionally is somebody who has been granted public interest standing by the Supreme Court of Canada, which you have been, in challenging this new law. My question to you is this. You challenged the law under the civil rules of procedure of British Columbia. This Bedford decision was challenged under the civil rules of procedure of Ontario. In both cases, you run the risk, if you don't win your applications, your originating applications, you might end up with a gigantic bill from the Department of Justice for costs, okay? So let me ask you, on behalf of members of the committee, why wouldn't you bring these constitutional matters before a criminal court, get somebody who has been charged with an offense? Then you are not bound by costs under the criminal rules of procedure. Why do you persist in going through the civil rules of procedure of the BC court?
It's an excellent question, and it leads to an important point I'm glad you're opening the door for me to make, which is that my clients, Sex Workers United Against Violence and Cheryl Kisselbach, were very intentional in how they brought the proceedings forward in British Columbia, and Bedford, Leibovitz, and Scott were very intentional in how they brought their proceedings forward because they wanted to be able to challenge the laws as a scheme. They operate as a scheme, and the individual prostitution laws are harmful in and of themselves, and they're especially harmful if you look at the framework of laws and the way that those construct and constrain sex workers' ability to be safe. In a criminal context, you're usually charged with one, maybe two of the provisions at a time, and you are limited in your capacity to bring a challenge forward, except with the provisions that you are charged with. And similarly, it is very easy for the Crown to decide at any point, including the day before trial, to stay the proceedings. And we have seen that happen in many contexts where individuals charged file constitutional notices, go actually a very long way to trial, and then the Crown says, oh, we decided we've actually changed our mind and we're going to drop them against you. So it was an intentional and strategic decision to go forward, most importantly because, similar with Bill C-36, you must look at this as a framework, and you must look at the way in which the provisions work together to limit sex worker safety and options.
Thank you. Senator Batters.
Thank you. I wanted to address my question to Ms. Jay and Ms. Lee, dealing with, I thought you made an excellent point in your opening statement, and you made it in your brief as well, when you said, in the absence of Bill C-36, Canadian human trafficking laws apply only to traffickers, but not the buyers of trafficked women. Bill C-36 makes it illegal for a man to buy a trafficked woman. And I'm wondering if you have any research that you can tell us about that you have seen to indicate the effect of legalization or decriminalization of prostitution on human trafficking.
Well, I've been a frontline worker for 17 years, and I was a chosen representative of one of four representative of Canada to the International Leadership Program, which is an exchange program focusing on human trafficking with the United States Department. And in my work, I can tell you that countries where there was legalized prostitution, that human trafficking increased, as the Minister Peter MacKay had indicated. I personally visited Cambodia, Thailand, and those places where countries had rampant legalized prostitution, that women are trafficked into those countries for the purposes, because you can't supply enough women when prostitution is legalized and men are using more and more prostitution. Just like in battering and sexual assault, I think Bill C-36 is a very important bill because it provides social sanctioning against the exploitation of women, and it sends a very clear message to men and the men that are parasitically invested in women's exploitation that it is not okay as a society to be supporting their behaviors. For that purpose, we are in support of Bill C-36.
Amsterdam is considered a failed experiment. Prostitution in the Netherlands is being rolled back by those governments because they've realized that by legalizing prostitution, they invited in and entrenched organized crime in that activity, and there was an explosion in the unregulated areas of prostitution, including underage prostitution, and there was an explosion in the trafficking of women into those countries to service the growing demand, the demand that they deliberately grew for those for prostitution. So what those countries have had to do, and what they're doing very publicly, is that they're closing down the red light districts in their cities. And they're debating now ways to roll back that decision in order to defend themselves against the growth of human trafficking and the entrenchment of the organized crime syndicates.
Thank you.
Senator Joel.
Ms. Pacey, I would want to come back to the issue of the constitutionality of some sections of the bills, the one that, of course, deals with the objectives of the Bedford decision, which is essentially to increase the security of prostitutes. We have heard this morning the government arguing that the bill creates a different context because the bill recognized, or I should say the preamble of the bill recognized, that women are victims of prostitution, that the prostitution is essentially a phenomenon of victimization. And if you read the preamble, it speaks of exploitation, commodification, a disproportionate impact on women and children. Won't you be challenged on the basis that it might be a breach to Section 7, which is the security of the person, but it's saved by Section 1 of the Charter, which is limits that are reasonable in a free and democratic society, the objective being to fight for non-exploitation of women, non-commodification of women, and so forth. How will you rebut that argument from the government in court if you find yourself in that position on challenging the section of this bill that deals with the Charter of Rights and Freedoms?
Mm-hmm. It's a big question. My simple answer is this. I believe the evidence is going to speak for itself. I believe that the impact on the ground, especially as it relates to the clients that we work with, the community of sex workers that Pivot is part of, working in the downtown east side of Vancouver, and of course that's our focus and that's who we will likely represent on a going forward basis. The reality for them, as it was with the Bedford case and in the Suave decision, was so egregious. The conditions created by the laws was so appalling and so unjustifiable that in the context of Bedford and Suave, where we were dealing with different legislative objectives, in my view, the outcome was clear. In this case, we're dealing with different objectives, and that balancing exercise, when we're talking about principles of fundamental justice, we will be having a different conversation at the court. But my simple answer for you today is that the harms are going to be so tragic because the conditions will remain as they are under the existing laws, and what is awful to imagine is that sex workers will be placed in the circumstance of again having to withstand those conditions and circumstances and again have to go back to court demanding their rights.
Thank you.
Senator Jaffe.
I had earlier asked you about the report that you had prepared and we ran out of time. Can you talk about why you prepared that report and what were the findings of the report that you prepared with the HIV/AIDS organization?
So the purpose of that report, I mean, we are in an ongoing dialogue with the Vancouver Police Department and with the province of British Columbia and the city of Vancouver at all times about safety in our community. That is a conversation that was prompted by the tragedy that we've seen in Vancouver and the experience of the past 15 years with Canada's largest serial killer. That conversation is ongoing, and I'm happy to say that partners are coming to the table, including police, including municipalities, and members of the province are coming forward really with an invested interest, really wanting to know the best way forward. So that report was created, and that research took place to genuinely ask the question, if the police shift their enforcement practices, if they lift the pressures of enforcement away from sex workers, if they redirect that towards their clients, what does that mean for sex workers on the street? And sex workers were very interested in having their voices heard. So the BC Centre for Excellence, because they're research experts, carried out the qualitative work of going out, talking to sex workers, and asking them about the circumstances of their work and how it is for them ever since this policy shift took place. They then conducted the data analysis, because that's what they do so well. We then conducted the legal analysis to follow. And the the results show very clearly the conditions remain the same, with enforcement having shifted as they were under the communicating law. And a story that I will just share with you briefly is that sex workers explained that they may be standing in more well-lit locations now because they feel like the police aren't going to arrest them, but their clients drive up, they barely slow down, and they start to point to the dark alley around the corner. That is where the client is willing to stop. She then follows the client into that alley. That is where he suggests she gets into the car as quickly as possible before they're detected by police. She's in the car then, and that's where the negotiation takes place, where she has complete major loss of control over the conditions. And those are the exact conditions that we are trying to confront while being invested in supporting the sex workers in that community to have all the options and all the choices. And we're fighting for housing, and we're fighting for welfare, and we're fighting for health services, and we're fighting for all of those things. We want the women that we work with to be alive to enjoy those benefits if they arrive one day.
Thank you. We've reached the conclusion of the time allotted. We thank you all for being here today and contributing to the committee's deliberations on this important piece of legislation. Thank you all. We will suspend briefly, members, and reconvene at 4:15. Thank you. come to order, please. Our next panel is individuals, Ed Smith and Linda Smith. Mothers Against Trafficking Humans, Glendine Grant, who's the founder of the organization. Canadian HIV/AIDS Legal Network, Stephanie Clévaz-Loranger, who's a senior policy analyst, and Cara Gillies, who is a member of the organization. And Ms. Smith, I understand you will begin with an opening statement, and I think you all understand the time limitations we're trying to operate under. Thank you very much. Please proceed.
Thank you, Mr. Chair, and thank you also for the opportunity of speaking here to this committee today. We feel really honored to be here. I will share with you a little bit of our story, and then Ed will do some follow-up. At the age of 17, our daughter, Sherry Lynn Smith, was procured into prostitution by a young man who was just 18 years old. Somehow he convinced her that she was in love with him, and against all our pleading and tears, Sherry left home to be with him. For the next 10 months, her boyfriend, who was really her pimp, trafficked her to many cities in Western Canada until she was brutally murdered in Victoria, BC. Sherry was 18 years old and 6 months pregnant when she was beaten to death, and her body lay undiscovered in some bushes for 3 months. This happened in 1990, and no one has ever been charged with her murder. We had a lot of interaction with Sherry during the time she was working as a prostitute. We, of course, were always trying to persuade her to come home. She was seen by social workers, counselors, physicians, and youth workers. None of them could convince her to leave her pimp, and no one had the resources to help her leave. The police considered her to be a nuisance. She was apprehended by them on 3 separate occasions in 3 different cities, and all they did was send her home. There were hundreds of men who sexually used and abused our daughter. She was raped and beaten, robbed, and thrown out of a moving vehicle. We never heard of any of those men being charged. Even though Sherry was controlled and mistreated by her pimp, she would not testify against him, therefore he was never charged. However, we are encouraged as we see society's attitudes changing. Bill C-36 will be a leap forward in bringing care and compassion to the vulnerable and the victimized in our country. Law enforcement and communities will begin to recognize the abuse these women and children endure. The prostitute will be treated as a victim, not as a criminal, and the buyers of sex will be seen as the abusers they are. The pimps who buy, sell, and trade these females will be prosecuted as traffickers. Thank you.
Since Sherry's death, we have tried to do all we can to put a stop to sexual exploitation of women and children. We have tried to educate young people about the dangers of traffickers who are looking for the vulnerable. We have tried to educate men to the harm they do to those who are being sexually exploited and the harm they do to themselves and their families when they pay money for sex. Linda has told Sherry's story over 1,000 times in schools to grade 6, 7, and 8 students to teach them about sexual predators. She has also informed parents, churches, and community groups of the signs and symptoms of vulnerability and sexually abused children. I have spoken over 130 times at John schools in Regina and Saskatoon to men who have been arrested for soliciting a prostitute. They hear stories from former prostitutes whose lives have been so severely damaged that they feel they will never be able to recover. They hear from former Johns about how their addiction to sex and the use of prostitutes has destroyed their family and the relationships of those close to them. Prostitution destroys the lives of both the buyer and the seller of sex. I would like to see Bill C-36 strengthened in the area of education. Education to help young people understand the destruction that awaits them in a life of prostitution. There needs to be more information for men to help them see the harm they are doing when they pay money for sex, harm to themselves and to the prostitute. As men, we need to be the protector of women and children, not the abuser. I think Bill C-36 is a positive step forward, as it will help to protect vulnerable women and children. Bill C-36 will send a clear message to the buyers of sex and traffickers that we will no longer tolerate the abuse of some of the most vulnerable people in our society. Thank you for giving us the opportunity today to speak in support of Bill C-36.
Thank you. Ms. Grant?
Well, I'd like to thank you for having me, Mr. Chair and Senators. It's a privilege to be here and speak. My story is similar to the Smith story. My daughter, Jessie Foster, was taken down to the United States in 2006, and she was forced into prostitution. We had no idea this was happening until she went missing 10 months later. When she went missing, we hired a private investigator, and the private investigator found out the disturbing facts. He found out that Jessie had been beaten, hospitalized with a broken jaw, forced into prostitution, and arrested, not just once, a month after she was taken there, but 4 more times in September. She was planning on coming back to BC for a stepsister's wedding reception, and she disappeared from one night to the next. We've never had any answers, information, or anything on Jessie's disappearance, and she's now been missing for 8.5 years, 9 years in March. And I believe in Bill C-36 because it will help young women like my daughter against the person who was an Albertan who took her down, a trafficker who took her to the States and left her there with a known pimp, a violent pimp known to the Las Vegas Vice and Pandering Squad. And as far as I'm concerned, a law such as this will help the women by keeping men like that away from them. It's hard for me to keep telling Jessie's story over and over because it's the same. There's no change. There's no other answers. There's nothing new. The thing that has come from Jessie's disappearance is a lot of awareness. Jessie is probably Canada's most well-known missing victim of human trafficking. She's also we've been fortunate to have her story told on many documentaries and in several books. And as far as I'm concerned, Jessie's story has made a difference to other women, to other parents. I have had many parents and young women alike call me and tell me after hearing Jessie's story, changes were made in their lives, in their daughters' lives, that they made different choices and are here today to tell you stories, not here personally, but today they could tell you stories of how they survived and how they did not end up a victim. They were not taken away because they found out early on, because this was many years ago that I started doing this. They found out before we all in Canada started striving to find answers for human trafficking. So far ago that people used to think I was just a mom looking for an answer because, of course, human trafficking did not happen in Canada. Since then, I've been grateful and fortunate enough to tell her story to people like yourselves and hopefully make a difference. Jessie is one of 4 daughters. She's got nieces and a nephew that she's never had a chance to meet, but they are all fully aware of Auntie Jessie. I have a little picture of an angel that I found in my pocket when I got on the airplane yesterday morning that my granddaughter had drawn and hid it in my pocket so I would find it when I was away. She's drawn a missing poster for her auntie of a beautiful blonde girl in a sparkly dress, and she says, "Have you seen me?" And so as far as I'm concerned, Bill C-36 may not help anybody this year. It may not ever help Jessie, but it will help my granddaughter in 10 years from now when she's 16, and it will help Canadians in the future. We don't expect answers to appear come January. We don't expect changes to be made instantly. We do expect the changes will be made. I don't feel $20 million is something to laugh at. I think that's a substantial amount added with the other money that is available from the John schools and other places that these funds come from. It's what it is $20 million more than we had. before this. So that's a lot of money, and as far as I'm concerned, it will be going to good use. Helping women exit when they want to is so important, so important. Many women don't realize at the time that they are forced into it that they are being forced. Some of them think it's partly their choice. In Jessie's case, she thought this man was her boyfriend. She thought this man was her fiancé. She loved him, and yet he beat her, broke her jaw, and forced her to work as a prostitute on the Las Vegas Strip. And it's hard to wrap your brain around how somebody can be a high school graduate, she'd been on the honor roll, involved with friends, the same friends since kindergarten, into sports and dance, never gave me a lick of trouble her whole life, never got calls from the teachers, other parents, the police as Jessie was growing up. She was a beautiful young woman who had high expectations for her life. She'd never done drugs. And yet she still became a victim of human trafficking. She was still taken out of our country right under all of our noses, and nobody realized what was even happening until it was too late. And I just want everyone to understand my take on Bill C-36 is it has to pass. It has to become a law. And when that law passes, I myself and many others, we're going to be calling it the Jessie Law. Thank you.
Thank you. Ms. Clévez-Loranger.
My name is Stéphanie Clévez-Loranger, and I'm a lawyer at the Canadian HIV/AIDS Legal Network, a human rights organization that works to promote the rights of people living with and affected by HIV in Canada and internationally. The Legal Network intervened before the Supreme Court of Canada in Bedford and has worked on issues relating to human rights and sex work for over a decade. I'm accompanied by Cara Gillis, a member of the Legal Network, with 25 years of experience in sex work and 2 decades of experience in support and advocacy on sex trade issues. We thank the committee for this opportunity to present. Our written brief provides a detailed explanation of the different provisions of Bill C-36, including the amendment regarding communication, and it explains how these provisions will have harmful impacts similar to those of the provisions that were struck down by the Supreme Court. Our brief also explains how globally available scientific data demonstrate that decriminalization is necessary to uphold sex workers' right to health and to empower sex workers to protect their health, including protecting themselves against HIV. We would be happy to answer any question the committee may have on these topics. There are 4 points we would like to specifically draw the committee's attention on concerning the impacts of Bill C-36 if enacted. First, communication. The proposed communication prohibition, as amended by the House, may appear narrower than the one existing before Bedford. However, because of its ambiguity and because of the impact this ambiguity will have on its enforcement, street-based sex workers will continue to fear arrest and be prevented from properly screening clients. Second, criminalizing purchase. Experience in Sweden and municipalities in Canada demonstrate that criminalizing clients replicates many of the harm that the Supreme Court found unconstitutional in Bedford. Whether it is the sex workers themselves who are fearing arrest or their clients, the impact that this has on the safety dynamics are the same. Also, there is no data that indicates that criminalizing clients reduces demands. What criminalizing their clients does, however, is further penalize the sex workers. Third, benefiting from sex work and procuring. The provision of Bill C-36, which intend to protect sex workers from exploitation, are so broad that they will continue to target third parties sex workers work with. These provisions will have the same impact as the one the Supreme Court found unconstitutional for preventing sex workers to work with people who could enhance their safety and with other third parties providing them legitimate services. And finally, working indoors. The Supreme Court found the prohibition of body houses to be unconstitutional because of its negative impact on sex workers' security. Bill C-36 will not reinstate this prohibition, but the impact of its different provisions will mean that operating indoor venue could not be done legally. In essence, it reintroduces the same prohibition with the same harmful consequences via different means. For all these reasons, the main provisions of Bill C-36 would not withhold constitutional scrutiny. But most importantly, we can't wait for for this bill to be passed and wait until it makes its way to the Supreme Court, because most importantly, Bill C-36 will put sex workers' life at risk in an immediate future.
Good afternoon, and thank you for the opportunity to address you today. Off the top, I wish to express my concern that under this bill, the dangers imposed on sex workers by the old legal regime will remain the same for some and will worsen for many. Back when I worked the street, the communicating law prevented me from effectively screening clients or negotiating the terms of the exchange. The opportunity to take these most basic of measures would have gone a long way to enhancing my safety. If the law had been slightly different and had allowed me to hold my half of the conversation, but had silenced my clients and made them fearful of arrest, the impact would have been the same, with my safety equally jeopardized. And that is what we've seen with recent client-focused law enforcement in various municipalities, and what we will see with this bill's proposed sanctions against purchasing sex. Now, when I moved off street and was no longer a key target of the communicating law, I was immediately struck by how much easier and safer it was to be able to openly talk with clients and to manage their expectations in keeping with my own preferences and boundaries. And I have to say, I find it deplorable that this bill's blanket prohibition on any client communication in any context totally jettisons this safety measure. Off-street workers are going to face the same legally imposed dangers that those on the street have been subjected to for years. I'm also worried about the safety impact of the material benefits provision. While I appreciate that the exemptions may allow a worker to hire a bodyguard or receptionist, I am mindful that only a tiny number of highly privileged workers will have the resources to do so. In essence, the law is going to require folks to set up their own small businesses, which is often out of reach for the majority of working people, regardless of industry. Instead, many sex workers seek out parlors and escort agencies because they offer beneficial services such as screening, secure venues, and advertising. Sadly, the proposed sanction against criminal and commercial enterprises criminalizes this option. And I ask you to truly consider the consequences of this. If I have $50 to my name and my rent is due and my fridge is bare, I can't afford to spend money on advertising or security or a hotel room. And if I don't have the option of taking a shift at a place like an agency, I am then susceptible to turning instead to a potentially unscrupulous or even abusive individual of the sort we've heard about today. Now, certainly, abuses can be perpetrated by commercial enterprises and individuals alike. Fortunately, we have criminal laws to address behavior such as assault and forcible confinement, as well as laws against trafficking and living on the avails of or purchasing the sexual service of somebody under the age of 18. I understand the argument that having an economic interest in somebody else's sex work can indeed facilitate exploitation in the pursuit of profit. The sad reality, as we all know, is that this dynamic holds true in any industry, and that's precisely why we have labor and employment laws, and it's why we need to bring commercial sex businesses out of the criminal shadows and into the same regulatory frameworks that uphold the rights and safety of working people at large. So for these reasons, and the ones detailed in our brief, we urge this committee to reject Bill C-36 in its entirety. Thank you.
Thank you. Thank you all witnesses, and we'll begin the questions with the Deputy Chair, Senator Baker.
Chairman, and thank you to the witnesses for your excellent presentations. They were very, very informative. My question is to the last two presenters. And basically what you are saying is that this bill will not benefit persons who are providing sexual services if it is their own sexual service that they're providing. However, I'm sure you will agree that it's always been illegal to pay for sex. It's always been illegal. People have been charged over the years. We know that. But now, for the first time, wouldn't you agree, under this bill, if I read 286.5, no person shall be prosecuted for an offense under 286.2, which is receiving a material benefit, if the benefit is derived from the provision of their own sexual services. So for the first time in Canadian history, we have now a provision in which a prostitute is immune from prosecution for receiving a material benefit. Then it goes on to say, an offense under 286.4 in relation to advertisement of their own sexual services. So for the first time, you have a law in Canada that says that a person can advertise their own sexual services. Then it goes on, and it says that no person shall be prosecuted for aiding, abetting, conspiring, and so on, or provision of their own sexual services. In other words, operating with somebody else and collectively conduct. For the first time, we have that. If we go back a page, for the first time, we now have protection in which a prostitute will be able to have a bodyguard or a driver or a receptionist if it is for the provision of a service that is a legitimate service. And that's never been in the criminal code before. If you go back another page, it talks about the provision of somebody living off the avails of prostitution, in which if it's a legitimate living arrangement, you can't be prosecuted. So what do you say to the people who put the argument, like I've just put it to you, that there are provisions in this bill that protect prostitutes that we've never had in Canadian law before? And how would the benefits of all of those provisions in this law be negated by the other factors that you think will come into play to negate them?
At first glance, it might look like some of the provision will enhance the security of the sex workers. There's one dynamic that is going to change under the bill. Until now, paying for legal services was not a crime. It will become a crime now. And we've seen from other experiences, whether in other jurisdiction in Sweden or from study that Pivot has done in Vancouver, that when the client is criminalized, it creates the same dynamics that the ones we used to see when both the client and the sex workers were criminalized for communication. So with respect to what has to do in the streets, we're very much concerned that the same points where negotiations have to be done very quickly, it has to be taking place in more remote areas, because yes, the street worker might not be worried that she's going to get arrested, but if her client's going to get arrested, she's not going to be able to work either. So she's going to have to abide by the safety concerns of the client, who's going to be more stressed. It's going to be still very difficult for her to assess the situation. Now an option could be, well, great, then, but they can work indoors, so there will be increased safety indoors. The truth is that the different provisions of the bill will not make it accessible to work indoors. So first of all, because it's only if you sell your own services that you're immune from the prosecution, one could work by herself indoors if she has the resources, which I think my colleague can speak to is not the case for many of the street-based sex workers who have the possibility to work indoors. But then as soon as you hire people, it's unclear whether, like, security staff or receptionists could fall under criminal and get prosecuted, because of this exception to the exemption about commercial context. And what the minister made pretty clear earlier is that they consider any commercial setting to be exploitative. Even if the sex worker works by herself and then she hires people, what the minister said is that, well, we would have to see in such a situation if it would be considered exploitative. So it doesn't take away from the risk of being prosecuted, people who would potentially work with the sex worker. Now, what are the chances that somebody offering, like, receptionist or security legitimate services will likely accept to work in a situation where they know that this can be taken to court, they could be prosecuted, and then afterwards we would study whether there was exploitation or not. So for all these reasons, and also because advertising how could a sex worker advertise if no editor or website can actually carry her advertisement? Working indoors would likely not be a real possibility.
Okay.
I don't.
That's excellent. Now, let's go to the purchasing of, or to communicating for the purpose of obtaining a prostitute. And let's talk about all of those people who have been charged with buying sex. And Mr. Smith, you referenced that you speak to John schools. Could you tell the committee, first of all, the types of people you would find in those John schools? Do they serve a legitimate purpose? Should the government be paying more attention to the John schools? And how was your reaction you found to those people who had been charged with the criminal offense of purchasing sex?
By the huge majority, and I've spoken at 130 schools, average about 10 men, so probably about 1,300 men I've spoken to. And I honestly cannot remember at the end of the school, the men have to talk to the presenters. And some of the presenters are former sex workers. Myself, I tell Sherry's story, and I have not had a single man say, this has made no difference to me. I can't see why I shouldn't be able to go out and buy a prostitute. Every man says, I'm sorry, often in tears, ask for apology from the girls, and they say, and I have trouble believing this, but they say, I had no idea I was causing this much harm. And they say, I won't be doing this again. And some of the men who are former Johns that speak and also try and encourage the men to change, he asks them, how many are married? And I'm surprised at the number of men that put up their hands. And he asks them, do you have daughters, granddaughters? And many of them do. And so he asks them the next question, what would you think if your daughter or your granddaughter was out there? Would you sell your daughter to this guy? And then it just changes the way they look at it and realize the harm that's being done. And the John schools have made a huge difference. Several of my very close friends now are former Johns. I have coffee with the one fellow almost every week, and he's working through the things that have happened to him, but it resulted in the breakup of his family. Now he's since been remarried, and they're doing well. But I just see so much damage being done to not just the sex worker, but to the men who are willing to pay the money for sex. And I tell them honestly, you know, guys, I'm not here to lay a guilt trip on you, but if you had not been willing to pay money for sex, my daughter would still be here today. And
thank you very much, all of you, for being here today. First of all, to Mr. and Mrs. Smith, welcome from Regina, such a beautiful city, my home city. I'm very happy that you're here to join us today and tell your daughter Sherry's story. I watched your testimony when you testified before the House of Commons Justice and Human Rights Committee and found it very powerful. And particularly when I reread the testimony in preparing for this meeting, your daughter Sherry died in 1990 at age 18, and she was a Regina girl, just like me, and she was only 2 years younger than me. So reading that, it just really strikes home how, you know, this sort of a situation can devastate a family. And I want to thank you for all the work that you've done in Sherry's memory to try to prevent similar tragedies from happening to other Saskatchewan families, both through your work, Mrs. Smith, on speaking to all these school kids about how these types of situations can quickly escalate and get out of control, and for your work, Mr. Smith, in dealing with these Johns at John schools, and sounds like you're really making a difference there, and thank you for doing that. I go back to to Mrs. Smith what you indicated in your opening statement today. There were hundreds of men who sexually used and abused her. She was raped and beaten, robbed and thrown out of moving vehicles. We never heard about any of those men being charged. And so now you're saying that the buyers of sex will be seen as the abusers they are now. And I would just like you to comment a little bit further on that aspect of Bill C-36 and why you support the criminalizing of the purchase of sex.
Somebody today earlier said that we're just talking about women, not about men, and that it's men that drive the sex for sale. And I agree with that. I don't know how I would feel if someone came up to me and said, I knew your daughter as one of her clients. That would be really hard. And yet, there were many men, and we know that from some of Sherry's personal effects after her death or after her body was found. But I also believe in restoration and healing. And as Ed has mentioned, at the John schools we see the men finding out about the impact that they're having. And I would believe that that would be a better way of getting men to stop buying sex, is if they could see and hear from the victims and get a chance to make different choices. And so I'm really hopeful that this legislation would bring that about. Somebody mentioned the 20 million, and we need to have more John schools. In Saskatchewan, we have 2 cities, or 3 cities, I guess, that have John schools. But it's dependent on how frequently the police go out to make arrests. And so we know that we're just hitting the tip of the iceberg. There are many other men out there, many of them fathers and grandfathers, who are buying sex from, well, I consider them victims. My daughter was a victim. And yeah, so I'm glad that we've got Bill C-36.
And Ms. Grant, thank you also for your work in the name of Jesse, and thank you very much also for bringing that personal but very moving item that you did, the picture of the angel. And I liked thinking about your daughter in a sparkly dress, and that was a very nice image to think about. And you also testified before the House of Commons Justice Committee, and you said, this is why I believe in Bill C-36. The biggest reason is that we can't have the alternative. We can't risk more and more people being forced into the sex trade if this was to be a legal job, as there would never be enough people to fill the potential job openings. We need to stop this demand because that's the only thing that's keeping it going. And could you please elaborate on that?
Well, I said that because it's true. I mean, if there was no demand, there would be no need for supply. And I feel that, like Mr. Smith said, you know, some of those Johns don't know the harm they're doing, because to them it's just all about self-pleasure. And so I believe that there's a lot of men out there who like to hire prostitutes, and if this becomes a legal job and brothels open up and there's job openings, for women, those jobs are not going to be filled. There will never be enough women to fill a brothel in, say, Kamloops, where I live, with 95,000 people. There will, I think about things that could come from that, like having to apply there. I lose my job. I need to go on employment insurance. I have to apply at all the available jobs around. I look at those types of things. So if we didn't have to have women to supply the demand, or men to supply the demand, then I believe that it would drastically reduce what we're going through. And I just believe that it was the demand for sex that had her daughter killed and my daughter missing for 8.5 years. My youngest daughter was born in 1990, and I think about the 24 years of my Jenny and her 3 children. And in those years, that's how long you've been grieving. So I believe it's such an important thing to stop the demand. There are never going to be just average Joes. There's always going to be violent ones. And when when you get into a car or have a violent John come into your home or into your room, you don't know he's violent. You could talk to him till you're blue in the face going before the transaction, before the actual act, but you're not going to know if he's violent. So, you know, there's so many different risks, and I just want this bill to pass.
And just a quick final point, you were indicating earlier, I think in your opening statement, that when your daughter went missing, it initially wasn't considered trafficking because people weren't trafficked in Canada. And I just point out that there will, I'm sure, be a lot of talk about New Zealand as we deal in the next couple of days. And just to point out that according to a report of New Zealand's government dealing with their Prostitution Review Commission back in 2003, it's expressly stated in there that in New Zealand, trafficking is not considered trafficking unless it's across international boundaries. So that's just a point to consider.
Well, you know, can I just say on that, for me, trafficking doesn't have to be international, because you can be trafficked out of your father and mother's home as a teenager and then go home every night at the end of that night. So it has nothing to do with it. And I do believe that Canada's eyes have greatly opened up to the crime of human trafficking, you know, since 2006. There's not a day that goes by that I don't hear another story of arrests and rescues of victims, and so it's really making a difference.
Thank you.
Thank you very much, Chair. Thank you to all the witnesses for your testimonies, and I want to first ask the Smiths and Mrs. Grant. You know, first I want to thank you for sharing your story. This is very difficult, but also the positive way in which you've turned something very painful in your lives to come and help us all, Canadians. So thank you for that. Thank you very much. What I wanted to ask the three of you is that you all three have talked about education. And if you were going to craft education or raising awareness, what would that look like? Now, the chair will only give me a few minutes, so you will have to do it or you can send it in later to the clerk if you want to think about it.
Well, I have one. Like, I go into high schools too, all over BC and Alberta, and I give education speeches to the students. And I think that, well, looking into the audience while I'm talking, I can tell which ones of those teenagers, and you might know what I'm talking about, are listening, and the ones that are whispering or writing or texting while you're talking. I know which ones I've captured, and at the end of my talks, young men and women, they'll come up to me and they'll thank me and hug me. So I don't have an actual anything that I could suggest to draft, because that's out of my realm of any kind of education that I have. But I do know that I've seen positive results. A small town in BC, Ashcroft, I'm sure you know of, not very many people. I went there with Crime Stoppers. We gave our talk. The principal was away that week. She called me the next week and said that so many of her students came up to her and told her how amazing that presentation was and how much they appreciated it. And she called me to thank me because it made such a difference in their school. And it also happened in Boston Bar, which might have, 300 people. They had a girl go missing, and I was asked to speak. Their school is K through 12. It's such a small place. And I got a lot of positive results. It's these small towns. They're sort of left in the dust when it comes to thinking this is going to happen to them, because this is a big city issue, but it's not. It's an issue for everyone.
I really think men need to be educated about the dangers of pornography. And presenter earlier in the day talked about even, children. I have a 9-year-old grandson, and thankfully, my son and his wife are very vehement about monitoring his internet use. But almost all the men that I talked to after the John schools, I asked them, how did you get started? And over again, it started with pornography. So we need to educate men about the dangers of pornography.
Thank you. Ms. Perez-Loranger and Ms. Gills, I'll ask you the 3 questions, and then you can answer them. I didn't quite understand your body house explanation. Because what I understood from the minister this morning is that women could now work from home, and so if you can explain that. And the other thing is the advertising. I was always confused. There's been all day people have talked about women can advertise, but to advertise, where will they advertise if they, if the person who prints it will get prosecuted? And my third thing is more for Ms. Gillis is I'm hearing when I've talked to a lot of people this summer on this bill, and the big issue that comes up is how is the woman going to assess the client when the client is so nervous. And the biggest issue that when I've spoken to people who work with sexual workers, they've said that's the issue. How are they going to assess clients?
Sure. In terms of further explanation around the body house provision, certainly it is my understanding that under this bill, the body house for the purposes of prostitution section of the criminal code will be repealed. However, because of the prohibition against commercial enterprises, it's only the most privileged workers, people who have their own space, can rent their own space, don't have a roommate or children living with them, who will be able to, in real life and practical terms, take advantage of this new part of the law. It's also the case that while there certainly is, as was found in Bedford, a security benefit to working out of a fixed indoor location where, for example, you can have security cameras, you know where the entrances and exits are, you know who is and isn't on the premises, those benefits are going to be totally offset by the fact that now, as a sex worker, I will not be able to screen my clients or negotiate with them, even in a private place. And that's one area where the law has changed. So in the past, it wasn't ever criminal to purchase sex or to sell sex. It was criminal to communicate for the purposes of prostitution in a place that was public or open to public view. So if I met a fellow, say, in his hotel, I, prior to that, would have called him up on the phone. We would have had maybe an email exchange, and I would have been able to assess by his tone, his demeanor, what he was asking, not asking, what the safety risk might be, and also what he was actually looking for. And knowing in advance what somebody's expectations are really sets the tone for the transaction and can go a long way to avoiding misunderstandings and hence dangerous situations.
So just to finish up on the body house prohibition, it's because, it was struck down by the Supreme Court, and it's not reinstated by the bill. But however, what the bill does is that whenever transactions are seen as taking place in the context of commercial enterprise, any immunity that would be given to people working with sex workers is automatically removed. And there's no criteria of exploitation. So it means that as soon as somebody is making money of or is getting paid by a sex worker, if you are not the person selling your own services, you can fall into the ambit of that, of criminal prosecution. So what Kara was referring to is like a place where there's like structures, safety measures can be put in place, is very unlikely to be able to operate legally. And it's not all sex workers who will have the capacities and like financial ability to work from their house. For the advertisement, basically, Bill C-36 prohibits advertisement. Everyone who knowingly advertises sexual services will be considered responsible of guilty of an offense. There's just an immunity for the person who's advertising her own sexual services. But as you said, you cannot advertise if you have no means of advertising. So the internet hoster could be prosecuted, the newspaper also. So I mean, other than somebody in the street distributing flyers maybe of their own sexual services, I don't see how any advertisement could be taking place. And then how do you operate from the safety of an indoor location if you can't reach out to clients?
I'd like to thank the witnesses. I'll give you some time to put on your headphones. You can hear the interpreter. First of all, thank you for your witness statements. Ms. Grant, Mr. and Mrs. Smith, I also lost a daughter, and I truly believe and understand your pain. And you are very courageous for having come here to testify about what you've gone through. I also understand the expectations you have before our government to attack this serious problem that affects mainly young girls. My question And I have to say first that your daughter was certainly a victim of prostitution. But sometimes the impression that I have that the groups that defend the liberalization of prostitution don't understand or misunderstand that it's not only the young girl who is a prostitute that can be attacked and killed and is a victim, but it's the entire family that's victimized as well. And I'd like you to tell us, with the support that you're showing for Bill C-36, how this bill can effectively protect not only the young girl or the young boy who's working as a prostitute, but it can also protect the parents, the grandparents, and the entire family.
I always wanted to be a mother of a bride. I only had one daughter and one son, and I looked forward to that day when she would be dressed in white and I'd be able to attend her wedding. Looked forward to the high school graduation that never took place. There were so many things that were robbed from us. When a child dies, you lose your future. You lose the future that you're going to have with that child or that daughter, son. And so it's a very hard thing. All the family members go through grieving. Some of us it's very hard to grieve. I think that for both Ed and me, it's been advantageous to tell Sherry's story and to believe that it's making a difference in the young people's lives and in the men's lives who are buying sexual services. And so, again, we just feel that the education part is important, and I'm sorry about the loss of your child. I certainly understand the pain that goes along with that.
I think, as far as the family is concerned, one of the things that Linda and I experienced when Sherry was on the street was we felt helpless to be able to intervene. We contacted police and they would say, well, unless she's willing to testify against him, there's nothing we can do. As Linda said, because she was a juvenile, she's like a nuisance. The police say, well, it's easier, we'll just put her on the bus and send her home, then we don't have to deal with her through the legal system. And we felt helpless. And I really would hope that maybe Bill C-36 somehow could give parents some more authority. Like it was very obvious what was happening to her, but legally there seemed to be no way we could intervene. And so I know there have been some laws since Sherry's death. Joyce Smith, I know, introduced a law that did increase the age where we would have been able to intervene. And so I'm very thankful for that, but it's such a helpless feeling for a parent when you see your child involved in this and you can't do anything.
Well, when I was, when I listened to their story, and I know we didn't know what was happening to Jessie, so we didn't have any advance warning. Ours, hit us in the gut like a ton of bricks when we found out. I think that having Bill C-36 is going to make a lot of difference in many ways, simply because the authority is going to come down to the people that are responsible. The people that are responsible for a prostitute having to have sex with a man is because the man is wanting it. If a pimp is forcing the woman or the girl or the man to go with this man and have sex and then get beat if she doesn't go, all the choices have been taken away. I think that I actually want to talk about, because when you were saying about the John School, I want to see John Schools all over. We don't have anything like that. So Bill C-36 is going to also, I think, increase other communities of opening up things like the John School and like the education process. I kind of lost track of what your exact question was, though, when I was listening. I apologize for that. So I don't know if I've actually answered what you were wondering. Okay, thank you.
Senator Joyal.
Mr. Chair, I I listened carefully to what you've said this afternoon, and I have two kinds of questions. First one for the HIV network. If I understand your reasoning to support your conclusion, in each case when the prostitute is not in position to maintain her health condition because she is caught into an environment where she cannot negotiate, she cannot express the conditions under which she will accept to have sex against remuneration, or if he practice sex in an environment where there is no control on the health of the person, or where the control on health cannot happen because of all kinds of prohibition. In that context, you come to the conclusion that the provisions of the bill that maintain that unbalance would be struck by the court as being against Bedford. In other words, against the security of the person. Am I right in interpreting your position in a simple form like that?
Yes. I think you might have summarized it better than I did. This is exactly what we're saying. The only thing I just want to clarify is that, so exactly, places, if it's not possible to negotiate to like how it's going to be taking place, where we're going to be when the transaction is going to take place. Definitely, this has impact on the health and security of sex worker. And the second point that my colleague made, that I think we both made, is the control over security measures being taken, and not necessarily control over health measure. I just want to make it clear that we're not in any way suggesting what sometimes takes place under legalization regimes, where specific measures are put in place, such as mandatory HIV testing, and in themselves, they're actually violation of human rights, which actually do not help in the fight against AIDS, which tend to push away people from services. So I just wanted to make this point clear.
And if I could just add, the proposed prohibition against commercial enterprises actually serves as a barrier to effective HIV education and outreach, because these establishments are operating or will operate under the pretense that sex isn't taking place. So that makes it hard for outreach workers or peer educators such as myself to make contact with other workers. And indeed, it's well established that sex workers doing safer sex education with each other is extremely effective and puts us as leaders in the battle against HIV/AIDS here and internationally.
Because the Supreme Court, in a previous decision, you're certainly aware, that decision that has established the responsibility of a person who carries HIV to inform the partner with who they might have sexual intercourse of their condition. So in my opinion, there is a corollary to that decision. That decision means that a person cannot be put in a position whereby it would not perform sex in the safest context possible. Because if you have the responsibility to inform the person, we have also the responsibility to make sure that the person is aware of the risk of the act taking place. So the decision of the previous decision of the Supreme Court, in my opinion, has an impact on the way that the court will be called to interpret those sections of the bill.
It's likely that the two decision, it's also part of the law now, so
Yeah.
it could come into play
I think
into
it's a
interpretation.
Manitoba case, if I remember
Yes,
well.
and a case from Quebec also.
Yeah.
The only thing I want to raise to your attention is that what protects people the most is actually the wearing of the condom, because what happens with respect to HIV, many of the people living with HIV actually don't know that they have HIV. So clearly, you can't let somebody know that you have HIV if you don't know yourself. So as a matter of public health principle, it's been recognized the most important thing is to wear condoms. And the one thing we are actually worried, it's not just our own concern, it's been showed by many different studies, is that in contexts where there is criminalization of sex work, it's often correlated with a lower use of condom for many different reasons, because for sex workers, having condoms on them may mean that this is used as evidence of sex work, and in a context where it's actually the client that's criminalized. In Sweden, we've seen that police have been going through the personal belongings of sex workers to find evidence, to find condoms to show that there was sex work, even if the sex worker is not the one being prosecuted, but in the prosecution of the client. It also, that's one of the things we're concerned about. I would say mostly. Wearing the condom is the most, safety measures, safe sex is the most important thing to protect sex workers' health. And anything that would make it harder for them to do that, whether at the time of the negotiation, to have the time to make sure that the client knows that it's going to be protected, or whether it's not carrying condoms, those are the things we're concerned about. And all of these points were made in a recent publication of The Lancet, one of the leading medical journal that just had, that came out actually after the hearing at the House, so we actually have the benefit of this information. They had a whole issue on HIV and sex work, and they really made the link of how criminalizing sex work is making it a lot harder for the fight against AIDS. And just one last point is a very interesting point, I think, is that one of the study made a specific modeling of what's happening in sex work in Vancouver, and they showed, according to their estimates, that nearly 39% of infections could be averted among sex workers and their clients in the next decade if only decriminalization would take place. That's a study for the area of Vancouver. So it really has an impact.
On the second round, Mr. Chair, I would have a question to Ms. Grant and Ms. Smith.
Madame Smith.
My question is for Mr. and Mrs. Smith. Despite the awareness created by the media and, of course, the introduction of Bill C-36, could you tell us, and there's young girls like yours who were dragged into prostitution by a smooth talker, is it a money issue, or are there other things that explain the circumstances?
The young man who convinced her, we call it the lover boy scenario. He had a $400 a day drug habit, and he needed to get money for his drugs. And Sherry was the way that he made his money. She never had a penny to her name. She worked the streets of Regina, and we would go and pick her up and take her out for coffee. We always had to pay for the coffee. She never had any money. And so it's money. This is what's behind the whole industry.
But on the other hand, for Sherry, it was love. She thought that she was in love with this young guy to the degree that we could not convince her to leave him, to speak against him, to, even a social worker tried to convince Sherry that she didn't have any money to show for how long she had been working. And this man so psychologically controlled Sherry that she was willing to do anything that he asked her to do because she thought she loved him. And she told us straight up front that this relationship meant everything to her, and she would do whatever she needed to do to keep it.
Merci. Ma seconde question va être pour Madame.
My second question is going to be for Ms. Loranger. Obviously, I listened to your point of view regarding Bill C-36. I was a cop for 39 years with the SQ, and I, of my own eyes, saw sexual exploitation, sexual violence, and the criminal activities that go with that. And I even witnessed human trafficking and organized crime, and even crime tied to drugs. We know that the goal of the bill, in general, is to protect persons and communities, and more so than anything else, decrease demand for prostitution and sex services, because when you reduce demand, you reduce the number of victims. So I have a little difficulty understanding your position. You say that Bill C-36 is going to remove security from the prostitutes. So I'd like to hear more of what you have to say about that.
Continue in English. Thank you. So I'm actually thanking you for this opportunity to express myself on this topic, because I want to make it clear that we consider human trafficking as a very serious crime. It is a crime. It should remain a crime. We're just making the difference between consensual sex work, adult consensual sex work, and human trafficking. And one thing that came up from two study of evaluations in Sweden is there was actually concerns that the new Swedish law actually create a barrier to prosecution of people involved in trafficking, because, for instance, clients who before would have spoken and would have come out and could give testimony to alert authorities actually now feared self-incrimination. And we've also had sex workers reporting that it's actually harder for them to get help in a context of criminalization. So we are definitely not minimizing the importance of sex trafficking, and we think that all measures need to be taken against it. Our concern is that the the provision of C-36 do nothing to address it, and they create the same harms as were raised by the Supreme Court of Canada in Bedford, which are unconstitutional. So we're worried of the impact that it's going to have on the sex workers, on the security of the sex workers, while at the same time thinking that there are laws to address sex trafficking and that they can use to fight sex trafficking.
Merci, Madame.
Well, thank you, Chair. Senator Boisvenu actually had asked the question of the Smiths and Ms. Grant that I was going to ask, so I will just make a comment on that and not ask a question. I certainly agree with you that I believe that in any cases of prostitution that there are victims, whether the victim is the prostitute, whether the victim is the parents, the children, wives. There are always victims in prostitution, and I think you have addressed that. I want to thank you for your testimony and for being as strong as you have been here today, and simply want to wish you well. I will ask a question of, and I'll call you Stephanie because I cannot pronounce all of that. And this has been dealt with to some extent, but I do want to, at least for the record, ask this question. As an organization focused on health concerns and disease control, I would think that you would at least support the government's goal of significantly reducing the incidence of prostitution in society. Certainly condoms are a way of having safe sex, but if we reduce the incidence of prostitution, would that not go a long way to reducing some of our concerns in disease and health control, such as HIV and others?
I'd say that we're mainly concerned about the human rights violation that happen in context of criminalization. And the first, one of the first principles out of public health is that people need to be empowered in order to take the measures that are necessary to respect their health. So this is where our concern is as a human rights organization, to make sure that people's human rights are actually respected, and so that they're empowered with respect to their health. And also, I need to state again that there has been no conclusive data that criminalizing the client actually helps to reduce prostitution. For instance, let me just, in Norway, so the government itself, so In Sweden, sorry. So the numbers have been criticized a lot. Different people who evaluated the reports that came out said that there was no solid data in which the government based its evaluation that prostitution had actually decreased. And while there's been some people have stated that street sex work has been reduced by 50%, but there's actually no information as to how many of these activities could actually been displaced indoor. And most importantly, in 2007, so the government itself of Sweden, the National Board for Health and Welfare, conceded that there hadn't been any change in the overall number of sex work, and that what they could at most discern is actually that street prostitution was slowly returning after swiftly disappearing under post-law. And I think Katrina Pacey referred to that, and how it can be like policing strategies. If police are a lot more present right after the law passed, you might see that people move out of street prostitution, those who can, and that will be working indoors rather. But really the conclusion, we can't draw a conclusion that it's actually going to be reducing.
Well, let me draw one conclusion if I could. And you may say there aren't statistics. The one conclusion that I would draw, if the Smith's daughter or if Leslie had had no customers, they would probably be alive today.
And I will say that sadly there are no statistics. There's no study based on previous example that we will actually be reducing demand.
They would be alive today.
Thank you, Chair. Thank you all for your presentation. Bill C-36 may not be perfect, and it may contain flaws. But for all its flaws, in my opinion, it fills a void created by the Bedford decision. Now, when you look at C-36, you notice that there's a shift, okay, in the legislation. In other words, a shift from prostitution being essentially a nuisance offense, as described in Bedford, to the de facto prohibition of prostitution. The emphasis on C-36 is to protect sex workers, protect communities, and reduce demand for sexual services. My question is this: do you fully or partially agree with this shift of the legislators' intent? That is, the shift from prostitution being essentially a nuisance offense to the de facto prohibition of prostitution. You want to get rid of prostitution, or you want the shift?
Are you speaking to me, sir?
All of you.
All of us? I'll let somebody else go first.
I'd like to get rid of it altogether, but we're pretty sure that won't happen. So what we need to do is gain some control over what's happening and allow only those who want to do it, do it. It's the bottom line. You know, like Senator Platt said, you know, women would be alive or not missing today if it was not for a John or a pimp. And then period. That's it.
But I'm thankful that society's attitude is changing. I see this as a shift in the way we look at prostitution, and I'm glad for that, yes. Yeah.
And, you know, I can understand why prostitution is called a nuisance, but that's like, you know, looking at the top of the ocean and saying, well, it's a little bit wet here, when it goes so much deeper. You know, the nuisance part is just, it's just such a small fraction of the damage and harm that's being done.
Yeah.
If I could respectfully add that I do disagree on several points. In my opinion, the problems and indeed tragedies that we've witnessed aren't inherent to prostitution or sex work per se. It's about the context in which sex work takes place, context that's criminalized, where there's stigma, and that stigma is reinforced and reproduced through things like the criminal law. It's also about systemic social inequities that play out in negative ways in the sex trade and in other arenas. It's my belief that in a proper context where it's safe and where people's rights are respected, prostitution actually could serve a social value. And I say that simply because at its heart, prostitution is about providing a service that meets a very basic and natural human need, the need for sexual intimacy. And I think that if we had a more, if not ideal, then supportive environment, socially and legally, we would then have people who do not wish to engage in sex work having alternatives, and people who are comfortable with exchanging sex for money or purchasing sexual services being able to do so in a way that's safe and upholds our rights.
But going back to the objectives of Bill C-36, which is to protect communities, protect sex workers, and reduce the demand for sexual services, do you think that by legalizing prostitution, it would fulfill those three objectives? Do you think legalization of prostitution would protect communities, for example?
I'm going to differentiate between legalizing and decriminalizing because, you know, in many legalized regimes, the restrictions imposed are such that not everybody has access, and you create sort of a multi-tier system, and abuses do occur. I do think that in a decriminalized system, communities would be protected through the use of administrative mechanisms such as bylaws around zoning and licensing. Certainly, sex workers would be protected, first because they wouldn't have to worry about the criminal law and law enforcement, whether it's against them or their clients, interfering with their access to safety measures or going to the police when something goes awry. And many of the abuses, and I'll use the word abuse, that we see in the sex trade are correctly characterized as labor abuses. And once we moved sex work out of the criminal shadows, we would be able to use employment and labor laws and other such mechanisms to better improve the circumstances of all involved. I mean, when you push something underground, you attract more criminal elements and you make it more dangerous.
But then again, with legalization comes human trafficking and the growing of the sex industry.
So I would disagree. I think that with decriminalization, there's more literally eyes on the street. People are better positioned to report instances of abuse. And I have to say, we are not talking about eliminating the trafficking laws. The trafficking laws are important and they should stay on the books. If anything, it's good that they're being strengthened. But consensual adult sex, for consideration or otherwise, is different from trafficking and murder of children, as we've heard about previously. And I do not think it's the case that the demand will push trafficking forward. I think that if there were decriminalization, there would be more perfectly willing workers because the conditions would be safer, there'd be less stigma. And if there were the opportunity for trafficking to occur, it would be much easier to identify it because it would be above ground, because people like myself and my clients and managers I've worked for would never, ever tolerate it. And it's not tolerated now, but often instances of abuse do not get reported because there's a fear that the heavy hand of the law is going to come down upon us.
Start the second round with Senator Joyal.
Mr. Chair, I would like to draw your attention that on page 7, the bill and its section 12, the bill redefined what is common body house in the criminal code. Presently, the criminal code at section 197 define a common body house means a place that is kept or occupied or resorted to by one or more persons for the purpose of prostitution or the practice of acts of indecency. And the bill, in fact, eliminates the purpose of prostitution because the bill concentrates now only to the acts of indecency. How do you, which legal weight do you give to that change in the criminal code?
So I think it does mean that in theory, the prohibition is removed. Like the word prostitution is removed from what creates the definition of body house.
Yeah.
So the criminal code per se does no longer prohibit body houses. However, the Supreme Court did say that it's important, and we all know, to read all the different sections of the bill for them to be read together. And what happens is that other sections of this bill will come into play and will prevent sex workers from working in indoor locations. And some of these examples are the fact that, as I was mentioning earlier, no one can be receiving a material benefit if in the context of a commercial enterprise, and the prohibition against advertisement. So what we're saying is that in the consequence of the act will be the consequence will be very similar to what was happening before Bedford when sex workers were prevented from working in indoors venues.
So if I understand your reasoning, it means that for instance, a person who wants to practice prostitution could team with another person who wants to practice prostitution and open a body house. In other words, a place where you can entertain sex against benefit, remuneration. But if those two persons would be hiring a manager in that place, and that person would draw a salary, for instance, to maintain that house, that person would find himself or herself under the other sections of the code. So that's where you say the nuance means that, in fact, it would maintain the present prohibition into a body house, because there will be somebody who would be the manager of the place and would be directing customers and making sure that, you know, everything goes as it should go. Am I right by stating that, in fact, the amendments that is proposed to the definition of body house applies only in the context of two consenting adults who group together to offer sex in the same place?
So exactly, what you described for managers is exactly our interpretation of what's likely to happen. But even it's not clear that two sex workers would be able to work together, because the immunity against selling your own sexual services is taken away if you're having any activity that might have to do with the selling the sexual services of somebody else. So it's very unclear. As soon as, like, if two sex workers are working together, like, very easily you can refer one client to the other person, or you might be like opening the door, or maybe one of you is good in accounting and the other one is better at marketing, so that the roles may be separated. But then you're advertising for the sexual services of somebody else. So there's ambiguity, and we're worried that basically this little, like, door that's open to having sex workers work indoors, in fact, is not going to allow sex worker to work indoor, unless maybe in a situation where she's very isolated by herself, but even then wouldn't be able to advertise.
And not only that, wouldn't be able to communicate or screen effectively with clients, because under the provisions of this bill, any such negotiation on the part of the client will be criminalized. So under the current laws, as I mentioned, if I go out to, say, a client's hotel, I can speak with him freely in that environment. I can also speak with him in advance of being in that environment. Under this bill, that will not be permitted anymore.
May I have another question to Ms. Grant? I've listened carefully to the work that you do, both of you, Ms. Smith, Mr. Smith, and Ms. Grant, and I wonder today, with the internet age, you know, when all the kids have, you know what, you know, they are all like that. They have access to porn, they have access to everything, you know, all the sites of meeting adults or whatever. If, in fact, the most effective effort would not be at the education department level. You know, to me, it's better to teach children about the risk of sex than to think that they're going to find it, you know, on the internet. You know, to me, sexual education needs to be accessible in the right presentation form with the responsibility that it involves. Because today, if you don't do it, they're going to do by themselves anyway. And they run much more a risk of being badly informed with this than if there is an open discussions for everyone to have about the risk of what it entails. Because I wonder if we want to be effective, if it's not at that level that we should be first targeting, than trying to, repair the pots once they are broken. You know what I mean?
Yeah, proactive is always better and always cheaper than reactive, always.
So, in your suggestion to use the 20 millions, should the 20 millions also or some money should be made available for that? It seems to me that informing somebody of the risk of what what prostitution entails for a kid, because it's easy to fall in love, at 15, 12, we all dream of falling in love at that time with the perfect person, and we idealize the first relationship we have. We think that we're going to get married with that person and, be happy so much in a deserted island somewhere. We all dream that at an age. But and there is a risk in that if somebody, depict to you the mirage of taking you to the deserted island. So how do we address that situation, which is risky in itself, and how we sensitize the youth to that situation? That's, to me, a way to address part of the problems.
You know what I see? I see, as a grandmother now, I see that my grandchildren know a lot more and a lot different things than I did, which was, really sheltered, and the way my kids were. So kids are learning a lot of things earlier, younger. And parents aren't always really good at even having the sex talk with their kids. So sex education in school is how some kids learn, and through their friends and talking is how others learn. So I think that if the education did come young enough, and for me, I get invited in by not, usually it's not just the schools, it's a certain teacher for that one class, or maybe there's an assembly. It's not something that the schools are participating in fully, but it's made a difference. Every time I've talked to students, I've had a result in some way, whether it's a young man coming up to me and saying, I will never hire a prostitute in my entire life, and then having that mindset in his mind, or having young women understanding what could happen. We're not saying that they're all going to be Jessies, or they're all going to be Sherrys, and that they're all going to be murdered or go missing. But I think if the chance of one of our daughters being murdered or missing is enough, one. I mean, anyone who has children, they know. Whoever's lost a child, they know. I don't know if anyone else in this room has a family member who's missing. That's an ongoing nightmare. We don't get to have a funeral. We don't get to, I can't even say that I think my daughter's dead, because if she comes back, I have to look at her in the face and tell her I gave up. So yeah, we have to start young, and we have to instill it. I mean, when I was young, there was no talk about no smoking. There was no talk, and look at how things have changed. This is just another one of those things we're at this time in society, in the world now, where this is what we talk about. This is what we're teaching our children. I mean, my 5-year-old grandson says to me, why did somebody take Auntie Jessie? And he actually knows the name of the perpetrator simply because of him hearing us talk about it over his entire life. And he says things like, I'm going to grow up and be a policeman, and I'm going to go and I'm going to arrest him. And so he already understands. And I don't just want kids who have a missing aunt or a deceased relative to get this. I want kids to have this understanding. Kids are so smart nowadays. They learn everything long before I ever knew at the ages, and this is just going to be one more thing that they're going to learn at a young age. They're going to be educated on. It's not going to seem weird that your child comes home and talks about preventing human trafficking or preventing, any kind of sex work. It's just going to be part of a conversation now, and I believe it's past time for that.
Senator Batters, an opportunity for last question.
Thank you very much. And to the three of you who have lost daughters, I wanted, just because there's been a lot of talk here about your daughters, Sherry and Jessie, as prostitutes and as one who's been murdered and one who is missing. There's been a lot of talk about them in that context, but I just wanted to give you an opportunity, because maybe you don't get to, well, you don't have the opportunity to come before a Senate committee very often, I'm sure. And I know that your work here will do a lot of good. But I wanted to give you a chance to, each of you, to just briefly tell us a little bit about your daughters, about their lives.
It's really an honor to be able to speak here. And really, the tragedy that our family has gone through has put this situation of prostitution and youth in the forefront of many people's minds, that I believe would not have happened if we weren't upfront and willing to tell Sherry's story. In fact, as soon as the news was released in Regina of her body being found, the news station wanted us to talk about it. And so from that point on, we decided that that's what we would do. And it's just amazing. It's just amazing where telling her story has taken us. I mean, we've been to Europe and we've been to India and we've been up north, and you know, it's just and it's because people don't know about these things. They don't know how to talk to their children, and they don't know about the signs and symptoms of a child engaged in dangerous activity. And we've done research and put things together, and so that's what we do. And we just feel very honored and very privileged to be able to do this. I think we would rather have our daughter, for sure.
Yes.
But it's really a privilege to be able to speak about not only our sacrifice, but as I said earlier, the restoration that can take place when people have an opportunity to make better choices, whether you're a youth or a John or a girl who is a sex worker.
It's a little bit hard to do.
I bet.
But, yeah, you know, she, as you were sharing, Sherry was an honor student, top of her class, involved in sports, music, and just had so much potential. And yet, you know, and we still don't understand why she would fall for the, you know, for the line that this guy gave her. And because we were a very open, loving family. Sherry was not abused, but after her death, we did find out that in grade 9 she had been sexually assaulted by one of her peers. And that we found out 2 years after her death, and that answered a lot of questions for us. Because when the assault happened, her behavior changed. And so many of the girls that we have dealt with over the years, the numbers are just astronomical as to how many have suffered some type of sexual abuse. And a lot of them First Nations, Aboriginal girls. We have a friend who's a First Nations woman that was on the street for years. Her heart's desire at this point is to start a ranch that would be a recovery facility for girls off the street. And so when I hear 20 million in the bill to be involved, I can just see, you know, if she were able to somehow tap into that to fulfill this dream she has to help these girls. So many First Nations girls in our city really need someone to come alongside of them and help them. And, you know, we've received wedding invitations from gals that Linda has dealt with in their family to help the girl realize the danger she's getting into. And, you know, years later we get a wedding invitation from a girl we don't know who this is.
No.
And she kind of realizes, she phones and says, "You don't remember me, but you, Mrs. Smith, you came to my house and talked to my mom and let her know what kind of guy I was going out with." And I'm getting married today because I realized that you were telling the truth, and so I dropped him. And now I've got a good guy, and I'm getting married. And so, you know, there's those encouragements that come along, and we're so thankful for that. And I agree about the education. And, you know, sex education for children, it needs to be education that says sex is more than just a physical act.
Yes.
It's so much deeper than that. It goes to the core of your very being. And so, you know, I'm just really encouraged by this step, and I just hope we take more steps in the future.
We're going to have to end it on that heartfelt note. We appreciate the testimony of all of you here today. Very helpful to our deliberations. Thank you again. Thank you all. And members, we're going to adjourn, and we'll reconvene at 9:30 tomorrow with a little bit of a change from time today. So thank you all. Meeting adjourned.